left undone. As for the court, he welcomed its decision in West Coast Hotel Company v. Parrish and offered up a neat quantitative analysis, counting the votes of all the justices who weighed in on minimum wage cases, and came up with 17 justices having participated, 11 voting in favor, and 7 against. He counted Roberts twice. Maybe that was a kind of amendment, ratification. Who killed Article 5? The legal scholar Bruce Ackerman asked, studying the New Deal. Not the president, not the Congress, but the Supreme Court. For Ackerman, the court had interfered with the process of Article 5 amendment by submitting to pressure and negotiating the switch in time. But it took more than the court alone to kill Article 5. Convincing the court to change its mind was one way to amend the Constitution. With the court's decision in West Coast Hotel Company v. Parrish, New Dealers abandoned the minimum wage amendment. But another way to amend the Constitution was to convince Congress to pass a law doing the same work as an amendment. A new wave of states had ratified the child labor amendment during the Depression. 14 states had ratified in 1933, and 5 more in 1935, and 4 more in 1937, raising the total to 28 out of a required 36. Given the painfully low employment rate, removing children from the labor force made especially good economic sense. In 1934, FDR declared that even without the amendment, child labor had effectively ended. He spoke too soon. The employment of children continued, and the court's striking down of New Deal legislation led the National Child Labor Committee to intensify its efforts at ratification of the child labor amendment. But FDR still preferred other, easier means. When, in the switch in time, the court finally ruled in his favor, FDR turned to his Secretary of Labor, Frances Perkins, and asked her, "What happened to that nice unconstitutional bill you had tucked away?" That law was the Fair Labor Standards Act, whose provisions included the abolition of child labor. It would never have passed muster with the Supreme Court before its capitulation in 1937, but it passed Congress in 1938, and the chastened Supreme Court did not overturn it. The passage of the Fair Labor Standards Act led to the abandonment of the child labor amendment. It had passed Congress and failed a ratification, only to be rendered essentially obsolete by federal legislation. The same is sometimes said of the Equal Rights Amendment. These two failed proposals, both made in the 1920s, share another fate. Both, nearly a century later, remain the subject of ongoing efforts at ratification, since the problems they aimed to address have still not been solved by ordinary legislation. Not because it is old, but because it is ever new. On Constitution Day, September 17, 1937, the 150th anniversary of the Constitution, Roosevelt delivered a speech before a crowd of 65,000 gathered at the base of a floodlit Washington monument. He spoke of 4 handwritten sheets of parchment containing eternal verities unchangeable by time and circumstance, but he emphasized what the Constitution did not contain. It did not specifically provide for judicial review, nor does it mention the number of judges for the court. He maligned the delays of the amendment process. It cost 20 years of taxation on those least able to pay to recognize the constitutional power of the Congress to levy taxes on those most able to pay. And it has cost 20 years already, and no one knows how many more are to come, to obtain a constitutional interpretation that will let the nation regulate the shipment and national commerce of goods sweated from the labor of little children. He insisted that Americans would no longer tolerate such delays, could no longer afford the luxury of 20-year lags, and would no longer sacrifice each generation in turn while the law catches up with life. He asked Americans to revere the Constitution, not because it is old, but because it is ever new. As for the relationship between the old and the new, Jacobus ten Broek, a blind scholar of law at the University of California who went on to found the National Federation for the Blind, spent much of his time in 1937 undertaking an assessment of how the Supreme Court had made and justified its decisions over the course of the first century and a half of its history. Ten Broek, born in Canada in 1911, had lost much of his sight in an accident at age 7, and all of it by age 14. After graduating from the California School for the Blind in 1931, he'd studied history, political science, and law at the University of California, Berkeley, after which he was a fellow at Harvard Law School, until Thomas Reed Powell helped him secure a position at the University of Chicago. In a series of influential articles published between 1937 and 1939, ten Broeck conducted a thorough investigation of what he called the intent theory of constitutional construction, or the intent doctrine, that is, the justice's use of the records and proceedings of the Constitutional Convention for the purpose of discovering the intention of the framers. Ten Broeck thought justices' reliance on these records was very often naive, in that they appeared to credit the framers with the capacity to state their exact position in words, and with having been entirely lacking in concealable purpose, or else very cynical, in that they used whatever they found to justify whatever decision they pleased. But in a survey of a century and a half of Supreme Court decisions, with notable stopping points at Dred Scott and opinions written by George Sutherland, ten Broeck found that while the United States Supreme Court will use convention debates and proceedings to show that the intention of the framers thus reveals, affirms, or does not contradict the positions of the court, such intent so discovered will be disregarded when in conflict with the interpretation of the Constitution announced by the court. Beyond the intent doctrine's capriciousness, ten Broeck found, its methods are irredeemably flawed. The records of the Constitutional Convention are vague, incomplete, and contradictory. The framers, like all people, very often hid their own motives and intentions, and the records represent the views of the loudest delegates, but not necessarily of the body itself. On democratic grounds, the debates in the state ratifying conventions would come much closer to revealing actual constitutional intent than would the proceedings of the Framers' Convention, except that those debates are subject to all those same limitations. In the end, ten Broeck concluded, such sources are fundamentally unsound instruments wherewith to rationalize a decision rendered. If the intent doctrine were what its advocates claimed it to be, ten Broeck pointed out, each justice would be a mindless robot whose task is the utterly mechanical function of measuring constitutionality by the yardstick of conformity to the original intent. But none of this was true. Original intent was not discoverable. It was an act of interpretation, and weighing its influence required reasoning and judgment, neither of which was incontrovertible, and both of which were subject to contestation, argument, and revision. Ultimately, ten Broeck argued, the meaning of the Constitution varies even in the absence of formal amendment. That, for ten Broeck, was the nature of constitutionalism. Sutherland, he alleged, was simply wrong. A constitution's meaning ebbed and flowed. The economic conditions since Adkins had required the court's reversal in West Coast Hotel Company v. Parrish, as the majority had written, insisting that the court had an obligation to note economic and social facts. Ten Broeck pulled no punches. He called the intent doctrine a fallacy. Any theory which describes the meaning of the Constitution as changeless, which understands that constitutionality is decided by the outcome of a judicial search for the original intent, which makes of a constitutional issue only an historical question, which denies the proper influence of the altering factual world upon the meaning of the document, any theory which does all these things is an utterly false portrayal of what the Supreme Court actually does. He made a list of the factors the court ought to consider in interpreting the Constitution under what he described as the doctrine of constitutional adaptability, which he argued, not without a sense of irony, had been the framers' original intent. Original intent, the nature of the problem, the history of the country, the court's earlier decisions, the actions and present attitude of other branches of the government, the court's views as to justice, expediency, policy, social need, economic and political theory, ultimate consequences, and the justices' predilections. But above all else, questions should be considered in the light of present-day conditions as they actually exist, not in the near darkness of the world as it surrounded the framers, nor yet in the dimming illumination of things as they were in the youth of the justices. Ten Broeck devastated the line of constitutional interpretation that stretched from Roger Taney to George Sutherland. Let the courts adapt, he insisted. But formal amendment by 1937 seemed less and less likely. You could amend the Constitution by Article 5, amend the Constitution by persuading the court to interpret it your way, or amend the Constitution by convincing Congress to pass a law that did some or much of what you hoped an amendment might do. But for large numbers of Americans in 1937, no path to amendment was available at all. In April of that year, right after West Coast Hotel Company v. Parrish, John P. Davis, a founder and executive secretary of the National Negro Congress, testified before the Senate Judiciary Committee on the matter of the reorganization of the judiciary just before the committee tabled the idea, given the court's capitulation on the minimum wage. The Supreme Court, Davis told the Judiciary Committee, had ultimately failed to honor the 13th, 14th, and 15th Amendments. Practically every major citizenship right guaranteed Negro people by these amendments has been either seriously limited or rendered a nullity by biased decisions, he said. He recounted the whole sorry history, beginning with the Supreme Court cases that essentially nullified the 14th Amendment as it applied to black people, down through the persistence of lynching and Jim Crow poll taxes. Even if Congress were to pass an anti-lynching law, which FDR refused to support because he needed white Southern Democrats to support his New Deal legislation, Davis predicted that the court would find it unconstitutional. But as for other remedies, Davis had little hope. FDR might have risked Article 5 instead of funneling constitutional change through the courts. The civil rights movement did not have that choice. Least of all did Davis place hope in Article 5. We cannot wait for amendments while 3 million Negroes are denied the right to vote, he said. For who can say that the new amendments will not share the same fate as the old? His only hope, and it was a slender hope, rested in the Supreme Court. No argument would more powerfully indict the amendment provision of the Constitution, nor would any argument made in the 1930s more significantly redirect the nation's constitutional history in the aftermath of the Second World War. Chapter 10. The Lost Amendment. No state law shall be held to conflict with the Constitution or laws of the United States by reason of the fact that it may require the maintenance of racial segregation in public schools if such state furnishes substantially equal public school facilities to all races. Failed amendment to the U.S. Constitution introduced into Congress, 1954. Reporter Ethel L. Payne, 43, 5'3", and indomitable, was preparing for a 5-week world tour on March 26, 1955, when she filed an arresting story from Washington, D.C. Southern segregationists opposed to Brown v. Board of Education, the Supreme Court's landmark 1954 decision declaring segregation in public schools to be a violation of the 14th Amendment, were seeking to overturn it by calling for a constitutional convention. They wanted to pass what would come to be called the Lost Amendment, an amendment for the lost cause. Brown v. Board of Education, whose interpretation of the 14th Amendment relied on sociological rather than historical evidence, altered both the relationship between constitutional amendment and judicial review and the very nature of constitutional agitation. From Reconstruction through the start of the New Deal, efforts to amend the Constitution had come more often from the left than from the right. In 1937, after FDR won his battle with the court, New Dealers abandoned the idea of amendment and looked to the court to enact change. So did the Civil Rights Movement. In 1940, the young Baltimore lawyer Thurgood Marshall founded the NAACP's Legal Defense Fund and plotted out a litigation strategy to defeat segregation by challenging Plessy v. Ferguson's separate but equal doctrine. Beginning in the 1940s, but especially after 1954, calls for amendment came more often from the right, and in particular from a conservative political minority, chiefly Southern Democrats, determined to overturn the New Deal, halt the march of communism, reassert states' rights, and impede the extension of civil rights. After Brown, that minority would continue to pursue Article 5 amendment, and even, as Ethel Payne reported, a constitutional convention. Finding little but failure, they also tried to defeat the Warren Court by arguing for interpreting the Constitution according to the original intent of its framers, repurposing the old pro-slavery argument that the Constitution sanctioned slavery to claim that it also sanctioned segregation. By the 1960s, original intent doctrine had become a hallmark of a conservative insurgency within the Republican Party, led by Arizona Senator Barry Goldwater and California Governor Ronald Reagan. A decade later, it entered the elite legal academy, and in the 1980s, the Justice Department, public discourse, and finally, the Supreme Court. Ethel Payne is not the most obvious figure to serve as a guide along this winding path. She was not a civil rights lawyer, even though she'd wanted to be one. Born on the south side of Chicago in 1911, Payne was the grandchild of former slaves, from Tennessee on her father's side and from Kentucky on her mother's. Her father, who died when she was 12, had been a Pullman porter. Payne never lacked for audacity. In 1931, when she was barely 20, she wrote to W.E.B. Du Bois asking to write his biography. As an NAACP activist in the 1930s, she'd applied unsuccessfully to the University of Chicago Law School. In 1937, she warned FDR against packing the court, an institution that she described, in a letter published in the Chicago Tribune, as the final greatest hope for political, moral, and economic justice for blacks. In 1941, she'd helped A. Philip Randolph, founder of the Brotherhood of Sleeping Car Porters, organize a march on Washington. In the 1940s, she'd studied English and history at a junior college and later journalism at Northwestern at night while working at the Chicago Public Library by day. After the war, she was living in Tokyo when she was hired by the Chicago Defender, the nation's leading black newspaper. In 1953, she became the Defender's Washington correspondent. But what makes Payne an especially useful chronicler of this era is that, unlike so many observers of the battle over segregation during the Cold War, she spent a great deal of time outside the United States, reporting on the struggles for political equality and self-determination of what were called the darker races. That reporting casts light not only on the nature of the color line, but also on the limits of mid-century Cold War liberalism. In 1941, FDR had signed the Atlantic Charter, which endorsed the right of all peoples to choose the form of government under which they will live. At the end of the Second World War, the United States officially committed itself to decolonization and self-determination, even as it sought to extend its own sphere of influence and halt the spread of communism by pressuring newly independent nations in Africa and Asia to align with the United States over the USSR. Under these circumstances, American race relations became a concern of the State Department, contributing to Truman's decision to form a Committee on Civil Rights. Communist propagandists abroad have tried to prove our democracy an empty fraud and our nation a consistent oppressor of underprivileged people, the committee warned. This critique came from within the United States as well. Du Bois, in a 1947 statement to the new United Nations, described the United States as the greatest modern attempt at democratic government to deny its political ideals, and argued that American racism is far more dangerous to mankind than the atom bomb. The costs of racism as domestic policy were borne by the people on whom it was imposed, including, during the Second World War, more than 100,000 people of Japanese ancestry imprisoned in internment camps. The Supreme Court notoriously upheld that policy in 1944 in Korematsu v. United States, but a dissenting justice rightly described it as the abhorrent and despicable treatment of minority groups by the dictatorial tyrannies which this nation is now pledged to destroy. From a U.S. foreign policy standpoint, American racism had different costs. The imprisonment of Japanese and Japanese Americans, the impoverishment of Native peoples. The Russians have been particularly watching our attitude toward Native Indians of our country, Eleanor Roosevelt warned on the radio in 1949. The continued colonial status of the island territories of Hawaii, Guam, and Puerto Rico, and above all, the persistence of Jim Crow laws, gave the Soviet Union abundant ammunition in persuading former colonies in Africa and Asia that the United States was not to be trusted, and that they should align instead with the USSR. It was from that vantage point that Payne would call the day the U.S. Supreme Court issued its decision in Brown the greatest date in United States history in regard to its relations with Asians and Africans. Payne arrived in D.C. just in time to watch the second round of oral arguments in the series of consolidated school segregation cases that were gathered together under the heading of the Kansas case, Brown v. Board of Education. Brown had first been argued in 1952, but the new Chief Justice, Earl Warren, had called for a re-argument and asked the parties to ascertain what was the interpretation of the 14th Amendment with reference to schools at the time of its adoption. To answer Warren's questions, Thurgood Marshall relied on a book by Jacobus Tenbrook, The Anti-Slavery Origins of the 14th Amendment, published in 1951. "We have taken full advantage of your book," Marshall wrote Tenbrook in 1953. Tenbrook, who had earlier denounced the original intent theory of constitutional construction as a fallacy, had sought to demonstrate that the 14th Amendment had origins well outside the debates held in the Capitol. On the opposing side, the historical research used by the NAACP's adversaries was chiefly prepared by a little-known lawyer from Richmond, David J. Mays, who had just won the Pulitzer Prize for his 2-volume biography of the 18th-century Virginia lawyer, judge, and slave owner Edmund Pendleton. Ethel Payne had first met Thurgood Marshall in Tokyo and once described him, entering a courtroom, as devastatingly cool. She watched the oral argument in Brown, rapt. "The fate of segregated public schools is now in the hands of the U.S. Supreme Court," she reported after the justices exited the courtroom. "The court must now decide whether to declare Jim Crow unconstitutional or leave it entirely up to the states to settle." But the stakes were greater still. The conservatism that had opposed progressivism and the New Deal as varieties of socialism took on a new and more radical cast in the 1950s, as an anti-communist crusade that after Brown drew strength from Southern segregationists who tied together opposition to federal power with opposition to civil rights. The conservative insurgency that began in the 1950s would over the next 2 decades reshape the Democratic and Republican parties. It's easy, eyeing that remarkable realignment, to lose sight of the world stage on which it took place. In the spring of 1954, as the U.S. Supreme Court deliberated over Brown, Indian Prime Minister Jawaharlal Nehru and Indonesian Prime Minister Sukarno began plans to hold a convention of delegations from Asian and African nations to chart their own course, unaligned with either the United States or the Soviet Union. It would be held in Bandung, Indonesia. Payne would be sent to cover it. On May 17, 1954, the day the court was expected to issue its opinion, Payne was in the courtroom, sitting with the press. "If any of you are in touch with the big man upstairs, you can put in a good word for us on this case, please," Marshall said to reporters as he walked past. The defender had halted its presses, awaiting the decision. Warren began reading the court's unanimous opinion at 12:52 p.m. He said he'd found the historical evidence of the original intent of the framers of the 14th Amendment to be inconclusive. He also rejected the idea that he ought to defer to it, even if it had been conclusive. In approaching this problem, we cannot turn back the clock to 1868 when the amendment was adopted, or even to 1896 when Plessy v. Ferguson was written, Warren said. We must consider public education in the light of its full development and its present place in American life throughout the nation. Only in this way can it be determined if segregation in public schools deprives these plaintiffs of the equal protection of the laws. The moment it became clear how the court had decided, the room stirred, pulsed with emotion. "There I was, right in the middle of it, and almost out of my mind," Payne wrote. Reporters raced to get out the story, which was broadcast within minutes on the radio. Across the city, black taxi drivers blared their horns in jubilation. Much of the country celebrated. But segregationists in the South began pursuing all means possible to defy the court. In 1955, in a decision known as Brown 2, the court ordered segregated schools to be integrated with all deliberate speed, although it provided no mechanism for enforcing this decision. "If people don't want to go to school together," Mississippi Senator James Eastland said, in an interview on CBS, "Who's going to make them?" Eastland insisted that there was no racial friction in his home state. That summer, 2 white Mississippians mutilated and murdered the 14-year-old black child, Emmett Till. A year later, even 6 years later, hardly any public schools in the Deep South had been integrated. On that 26th of March, 1955, Ethel Payne reported a story that had barely been noticed in the white press. Joint resolutions had just been introduced into the House for a federal amendment that would change the method of amending the Articles of the Constitution by lowering the number of states required to call for a constitutional convention. The purpose of the maneuver, Payne reported, was to use an amended Article 5 to overturn Brown. She warned that if this effort were successful, the integration of schools could be delayed maybe 10, 20, or even 50 years. Ethel Payne might have covered that story. Instead, she boarded a plane for Bandung. The Rights Revolution. In the United States, Brown is credited with inaugurating a rights revolution, during which rights, including civil rights, the rights of criminal defendants, reproductive rights, and more, were principally achieved by decisions made by the Supreme Court, especially during the Chief Justiceship of Earl Warren, which began in 1953 and ended when Warren retired in 1969. These rights were not achieved by constitutional amendment. Only a single amendment to the Constitution was ratified between 1933 and 1961, the 22nd. In 1951, limiting the presidency to 2 terms. Of the 4 amendments ratified between 1961 and 1971, only the 26th concerned constitutional rights, and it didn't establish a new right. Instead, by lowering the voting age to 18, it merely expanded an existing one. The rights revolution, however, was worldwide, lasted considerably longer, and outside the United States was driven not by judicial interpretation, but by the drafting and amending of constitutions. Language relating to rights in national constitutions nearly doubled between 1910, when words about rights comprised about 6% of national constitutional texts, and 1948, when that percentage had risen to 10. By 1970, it had risen to 12. By 2000, 15% of words in national constitutions concerned rights, a growth that came to be known as rights creep. One way to consider Brown as a constitutional change effected through judicial interpretation is to compare its history with the progress, or rather the failure, of the Equal Rights Amendment. Although first introduced into Congress in 1923, the ERA was in many ways the last of the Reconstruction Amendments, since suffragists had since the 1860s fought for the 14th Amendment to prohibit discrimination on the basis of sex. In the 1930s, it had seemed possible that it might wend its way through Congress. The hardships of the Depression had strengthened support for equal rights. "We have the best chance of winning equal rights now that we have ever had since the amendment was first introduced," one National Woman's Party lobbyist proclaimed in 1936. Congress, swamped with petitions calling for the ERA's passage, held hearings in 1938. "The logic of this step is self-evident," said one advocate, endorsing the idea that the history of rights is characterized by an ever-widening community of rights holders. But just as Florence Kelley had opposed the ERA in the 1920s, leading liberal women, including Eleanor Roosevelt, continued to oppose it in the 1930s, fearing that it would undo necessary protections for women, especially within labor legislation. Kelley died in 1932, but in her place, the opposition was led by Frances Perkins, FDR's Secretary of Labor, who complained that the ERA denied the unique biological function of women and their responsibilities as homemakers and mothers of future citizens. The Supreme Court's 1937 decision not to overturn labor legislation, the passage of the Fair Labor Standards Act in 1938, and women's contribution to the labor force in the Second World War combined to allay many of those objections. Since labor laws no longer offered special protections to women but instead guaranteed these protections to men as well, much of the protectionist position had become obsolete. A swell of support followed. In the 1940s, the Equal Rights Amendment appeared to be keeping pace with another popular proposal, the Presidential Term Limits Amendment. The first hearings on that amendment, no person shall be elected to the office of the president more than twice, were held in 1940. A 1943 survey found that 54% of Americans opposed the presidential term limits amendment, while 46% favored it. A year later, those in favor had risen to 58%. FDR's decision to seek a fourth term in 1944 cemented support for the measure. Congress passed the 22nd Amendment in 1947, and it was ratified in 1951. Prospects for the Equal Rights Amendment seemed, if anything, better. In 1940, the Republican Party endorsed the ERA. The Democratic Party followed 8 years later. By the mid-1940s, 25 governors had endorsed it. Eleanor Roosevelt abandoned her earlier objections in order to support the charter of the newly formed United Nations, whose preamble affirmed as fundamental human rights the equal rights of men and women. The ERA also gained the support of the National Association of Colored Women, headed by Mary Church Terrell, who testified in Congress in support of the amendment in 1945 and again in 1948. Like Ethel Payne, Terrell brought an international perspective to constitutional rights. As a young woman, she'd studied in France, Germany, and Italy, experience that had informed the founding of the NACW in 1896. In 1904, she'd addressed the International Congress of Women in Berlin, speaking on the progress of colored women. She'd followed the establishment of equal rights provisions in constitutions in Europe, both before and after the Second World War, and in her testimony to Congress in 1948, she noted that Japan's new constitution, too, granted equal rights to women. Terrell argued that the absence of such a provision in the underdeveloped U.S. Constitution was internationally embarrassing, in the same way as were American race relations. In 1950, the Equal Rights Amendment passed the Senate by the required two-thirds majority. This version included a rider designed to appease protectionists, modeled on those in many European constitutions. The provisions of this article shall not be construed to impair any rights, benefits, or exemptions now or hereafter conferred by law upon persons of the female sex. The Senate again passed the amendment in 1953, but in the House, the bill never wriggled free of the stranglehold imposed by the Judiciary Committee. For 2 decades, during which the number of women in Congress never rose above 20 or less than 5%, opponents of the ERA kept it locked up. However momentous the worldwide rights revolution, it left American women behind. Provisions for women's rights had been made in 35% of national constitutions by 1946, in 51% by 1956, and in 62% by 1966. This failure of American democracy did not encourage civil rights activists to change their minds about seeking change through the courts, rather than through Congress and Article 5. From the vantage point of conservatives, though, Article 5 looked somewhat promising. Between 1937 and 1960, even as the New Deal became more firmly established, embraced not only by Harry S. Truman, but also by Dwight D. Eisenhower, an emerging conservative counter-revolution attempted to limit federal power, especially as exercised by the executive and judicial branches. Conservatives considered both the 18th Amendment and the 22nd to be successes in their efforts to rein in the federal government. What they particularly liked about Article 5 was that it avoided both the executive and judicial branches, the branches they blamed for creeping socialism in the United States. They were happy to see the abandonment of the Child Labor Amendment and the locking up of the Equal Rights Amendment, even as their own list of proposed amendments grew longer and longer. By the 1950s, anything that anyone demanded of the Constitution, by whatever mechanism of change they sought to pursue, confronted a document whose meaning and place in American life had been transformed by the frantic, paranoid bunker mentality of the Cold War. La Constitución del Estado Libre Asociado de Puerto Rico. Puerto Rico's struggle for independence and its drafting of a new constitution formed a crucial backdrop to the court's deliberations in the school segregation cases. Enacting its stated commitment to self-determination, the United States had granted the Philippines independence in 1946. But its other territorial possessions, including Puerto Rico, it had not liberated, a state of affairs that revealed the limits of the United States' commitment to decolonization, self-determination, republicanism, and constitutionalism. a commitment constrained by American ideas about race. A Puerto Rican nationalist party, the Partido Nacionalista, founded in 1922, had long been fighting for independence. And for just as long, the FBI had been attempting to thwart it, infiltrating the party and assembling surveillance files, or carpetas, on all its leaders and many of its members. Pedro Albizu Campos, who had studied at the University of Vermont and earned degrees from both Harvard College and Harvard Law School, became the head of the Partido Nacionalista in 1930. In 1932, he ran for a seat in the Puerto Rican Senate against the Partido Popular Democrático's Luis Muñoz Marin, who had long supported Albizu Campos and who also proclaimed himself to be an avowed nationalist. Muñoz Marin, too, had studied in the United States, though he had dropped out of Georgetown Law School to become a poet in Greenwich Village. The FBI had carpetas on both men, including evidence that Muñoz Marin, an alcoholic, had become addicted to opium. Muñoz Marin defeated Albizu Campos, who went on to organize sugar workers. During a military purge of nationalists, Albizu Campos was arrested and tried for conspiring to overthrow the U.S. government, resulting in a hung jury. In a second trial, in 1936, he was found guilty. Muñoz Marin, meanwhile, went on to become president of the Senate in 1940. Although Muñoz Marin had consistently advocated for independence, in 1943 he suddenly began arguing against it, claiming that Puerto Rico was not ready for self-government. He appears to have done so under pressure from the United States, which had over him the hold of his FBI file. Albizu Campos was paroled in 1943, having served a prison sentence first in Puerto Rico and then in the United States. After an extended stay in a hospital in New York, he returned to Puerto Rico in 1947 and was met with crowds of supporters and the Cuerpo de Cadetes de la República, a liberation army he had formed in the 1930s. Hoover now pursued him as a communist, and in 1948, at Muñoz Marin's instigation, the Senate passed a gag law under whose terms any advocacy of independence, including the display of the Puerto Rican flag, was illegal and punishable by as many as 10 years in prison. In 1949, Muñoz Marin was elected governor, and the U.S. State Department began referring to Puerto Rico not as an island possession, but as an associated state, without granting it any change of status, largely for the sake of countering critics. It is only one of the things we might do to gain with respect to Puerto Rico, as we have with respect to the Philippines, credit into the eyes of Latin America and the world at large, according to a State Department memo. Communism, in all its terrifying brutality, was bleeding, it seemed, to every corner of the globe. In China, Mao Zedong had come to power in 1949. In Eastern Europe, the sphere of Soviet influence had widened behind what Churchill described as the Iron Curtain. Soviet tanks would soon roll into Hungary to crush an anti-communist revolt. Domestically, the United States became consumed by the fear of communist infiltration of American institutions and even of the federal government itself, especially after Wisconsin Senator Joseph McCarthy, in a speech in February 1950, claimed that Truman's State Department was riddled with communists. That July, the U.S. Congress passed a law that purported to endorse home rule for Puerto Rico and calling for Puerto Ricans to organize a government pursuant to a constitution of their own adoption, which could only be ratified if Congress approved it. The Partido Popular Democrático approved of the plan. The Partido Nacionalista did not. Declared Albizu Campos, what they are seeking to do with that constitution is validate the current relationship, a forced relationship that began on July 25, 1898, with the invasion of Puerto Rico's national territory, so as to stand before the world, seemingly, with hands unsoiled. In October 1950, Albizu Campos led a revolutionary uprising that included an attempt to assassinate Muñoz Marin. The United States met this insurrection with overwhelming force, including bombing 2 towns and occupying much of Puerto Rico with the National Guard. On November 1st, Puerto Rican nationalists in Washington attempted to assassinate Truman while he was staying at Blair House, down the street from the White House, which was undergoing renovations. Hours later, the Insular Police, the FBI, and the National Guard coordinated an attack on Albizu Campos' apartment in San Juan, and he was again arrested. Munoz Marin declared martial law, and his government, aided by American forces, arrested more than 3,000 people within days. Albizu Campos was tried in August 1951 and sentenced to 80 years in prison. Meanwhile, Puerto Rico began the process of constitution writing. In a referendum, notably boycotted by the Partido Nacionalista, 3 in 4 Puerto Ricans who voted favored holding a convention. It met in San Juan from September 1951 to February 1952 and drafted a constitution that, in line with the most progressive American state constitutions, guaranteed a series of socioeconomic rights, including a right to work. It also borrowed heavily from the United Nations' 1948 Declaration of Human Rights. Section 1 of Article 2 reads, "Human dignity is inviolable." Submitted to the people for ratification, the Constitución del Estado Libre Asociado de Puerto Rico passed with an 82% majority. Yet because Puerto Rico was not in fact a sovereign nation, the Constitution required the approval of Congress, as if Puerto Rico were a state, which it also was not. In hearings, members of Congress expressed concern that the Constitution had an amendment provision that granted Puerto Ricans the power to amend it. Suppose they amended it by striking it all out, one congressman asked Munoz Marin. If we were to assume the people of Puerto Rico will go mad, the governor answered, we might as well stop discussing the whole matter. In the end, Congress required that any amendment be subject to Congress's approval. On July 25, 1952, 6 months before the Supreme Court heard arguments in Brown v. Board, the Constitución del Estado Libre Asociado de Puerto Rico went into effect. The Constitución itself would later be moved from the safe of the Supreme Court of Puerto Rico, deposited in an urn made of marble, and covered with a concave glass hermetically sealed by a 1-inch bronze ring. In Washington, Americans moved the U.S. Constitution to a new shrine, too. Constitution Avenue. On a chilly Saturday, December 13, 1952, the 9 justices gathered in the first-floor conference room of the Supreme Court building to begin their deliberations in Brown v. Board. It must have been very difficult to concentrate. Only a block away, a military procession led by 12 police motorcycles and 4 soldiers carrying submachine guns, followed by a bayonet-wielding honor guard, 2 military bands, 2 armored tanks, one of which broke down en route, and 1,300 servicemen and women made its way from the Library of Congress to the National Archives, 10 blocks away on Constitution Avenue. Stalin was in Moscow, Mao in Beijing, the missiles were in their silos, the Buicks in their driveways. In suburban tracts, on abandoned farmland, Americans were building fallout shelters, bunkers against atomic attack. And more than 1,000 U.S. troops were guarding an armored tank, a Marine personnel carrier with a gunner sitting on top, to operate a machine gun. Inside were 6 sheets of sheepskin parchment, suspended in helium-filled glass cases, enclosed in wooden crates, resting on mattresses. The Declaration of Independence and the U.S. Constitution. No ancient procession, no devotion to any deity was more worshipful. But this was the Cold War's Constitution, protected from atomic attack. When the procession arrived at the steps of the National Archives building, servicemen armed with submachine guns flanked those who carried the glass cases up the steps. Inside, they were put on display alongside the Bill of Rights in a new shrine more secure than the one built in the Library of Congress in 1924. This tomb, the world's largest safe, was designed to withstand almost anything. Every day, the Constitution would be under armed guard. At night, it would be lowered by an elevator 20 feet below ground into what the New York Times described as a specially constructed bomb and fireproof vault made of reinforced concrete 12 1/2 inches thick and enclosed in steel sheeting 2 1/2 inches thick. It is estimated to be resistant to anything except a direct atomic bomb hit. Truman gave a speech inside the archive building, standing before the new shrine. He celebrated the Constitution and its ideals of liberty and warned against those who, in their pursuit of communists, a pursuit he called hysterical, failed to honor the Constitution. "They're turning it into a mummy," he said, "as dead as some old pharaoh of Egypt." It was an odd thing to say, standing in front of a sarcophagus, but it was also an indictment of the kind of argument that justices had heard days before during oral argument in Brown. During that first round, the NAACP's lawyers, including Thurgood Marshall, offered a narrow, incremental argument. They didn't ask the court to overturn its opinion in Plessy v. Ferguson, a case that had involved separate accommodation for blacks and whites and railroad cars. Instead, they'd insisted only that Plessy's separate but equal doctrine didn't apply to public schools. It was the justices, not the lawyers, who introduced broader questions about whether the doctrine, and segregation itself, violated the 14th Amendment, as it was understood in the 1950s, a world where Puerto Ricans were writing their own constitution. Asked one justice, "The social and economic conditions and the personal relations of the nation may have changed so that what may have been a valid interpretation of them 75 years ago would not be a valid interpretation of them constitutionally today?" On the third and final day of oral argument, Thursday, December 11th, Milton Corman, defending school segregation in the District of Columbia, offered his answer to that question, arguing that even if conditions and relations had changed, the Constitution had not. In one of the most extraordinary moments in an extraordinary day, Corman then asked the court's permission to quote from an earlier decision which he hoped would buttress his opinion. He proceeded to read these words. "No one, we presume, supposes that any change in public opinion or feeling in relation to this unfortunate race in the civilized nations of Europe or in this country should induce the court to give the words of the Constitution a more liberal construction in their favor than they were intended to bear when the instrument was framed and adopted." "That, Your Honors, was from Dred Scott v. Sandford. Almost 100 years ago," Corman said, "but it is equally applicable today." Americans had changed, a civil war had been fought, slavery had ended, race relations had changed, but the Constitution, Corman suggested, was still the Constitution of Dred Scott. It was as dead as some old pharaoh of Egypt. "I think we've got it won, 5-4, or maybe 6-3, John W. Davis, the South Carolina lawyer who led the segregation argument, said as he left the courtroom. 2 days later, while the Constitution itself made its way to the National Archives, the 9 justices met to begin discussing the case. Their deliberations, as always, were private. 4 justices appear to have favored overturning Plessy. 2, including the Chief Justice, Fred Vinson, a Democrat from Kentucky, favored upholding it, and 3, including Felix Frankfurter, leaned toward overturning Plessy, but wanted stronger evidence to do so. Frankfurter urged that the decision be delayed, and the cases re-argued in the next term. But even as these 9 men were deliberating, they would have heard the rumble and roar of a constitutional celebration, a drumbeat, a thrum, the screeching of bagpipes, an American yawp. The people within our own borders. During that first round of oral argument in Brown v. Board, Justice Robert Jackson asked Thurgood Marshall, "What, if any, effect does your argument have on the Indian policy, the segregation of the Indians?" Marshall had little to offer by way of an answer. "I think the biggest trouble with the Indians is that they've just not had the judgment or the wherewithal to bring lawsuits," he said. It was hardly illuminating. But even as the NAACP was fighting to end school segregation, the National Congress of American Indians, formed in 1944, was fighting to end a new federal government policy known as termination. Termination had first been proposed in 1947 during congressional hearings about reducing the number of federal employees. In the name of freeing the Indians, conservatives from Western states proposed to terminate the federal government's involvement in Indian affairs. Western legislators aligned termination with the civil rights movement. A South Dakota congressman indicted the Truman administration for demanding that the colored man be given complete and wholly equal rights in the South, while not granting those rights to Indians. Terminationists also depicted reservations under the New Deal's Indian Reorganization Act as communistic. A Nevada senator complained that while the United States was spending billions of dollars fighting communism, it was at the same time perpetuating the systems of Indian reservations and tribal governments, which are natural socialist environments. Termination was at heart a budgetary measure, a way to relieve the federal government of its financial obligations to Indian tribes and coerce assimilation in the guise of supporting native sovereignty. In 1949, an Indian task force, within a commission reporting on ways to reorganize the executive branch, advocated progressive measures to integrate the Indians into the rest of the population as the best solution of the Indian problem. A 1952 House report on the Bureau of Indian Affairs endorsed this plan. Federal Indian policy had been so fickle that it was then naturally proposed to effect this change by way of constitutional amendment to assure its lastingness. In January 1953, the arch-anti-communist and most powerful member of the Senate Judiciary Committee Chairman Patrick McCarran, who had long opposed Paiute land claims in his home state of Nevada, proposed amending the Constitution's Commerce Clause so that it would read, "The Congress shall have power to regulate commerce with foreign nations and among the several states, that is, deleting and with the Indian tribes." William H. Harrison of Wyoming had another idea, calling for the abolition of the Bureau of Indian Affairs and the termination of the federal government's relationship with Indian tribes, declaring that at the earliest possible time, they should be freed from federal supervision and control. The National Congress of American Indians opposed the amendment. To challenge termination, Executive Director Oglala Sioux Helen Peterson spent months driving through Indian country talking to Indians with Winnebago activist Elizabeth Rowe Cloud in Rowe Cloud's old Chevy. Elizabeth Rowe Cloud was the widow of Henry Rowe Cloud, who had toured Indian country in the 1930s with John Collier, meeting with tribal congresses to discuss the writing of their constitutions. Peterson then also organized a 3-day conference in Phoenix on the crisis in Indian affairs and an emergency conference in Washington in February 1954, attended by delegates who represented more than 1/3 of the Native Americans in the United States. It opposed termination and adopted a Declaration of Indian Rights written by Joseph Gary, the Coeur d'Alene president of the NCAI, who had fought in both the Second World War and the Korean War. In a statement on termination, the NCAI placed measures like McCarran's proposed amendment in their Cold War context, asking, "Shouldn't Indians have the same right of self-determination that our government has stated, often and officially, is the inalienable right of peoples in far parts of the world? Do we apply a different set of principles of ethics to the people within our own borders?" Under Peterson's leadership, Indians didn't win what many called the War of 1954. But in an illustration of the political power of a growing indigenous rights movement, the National Congress of American Indians defeated McCarran's amendment, a rare but crucial victory. When Congress held hearings on Indian termination, the Seneca activist and editor Alice Lee Jemison, who had opposed the Indian New Deal as a denial of tribal sovereignty, voiced support for McCarran's termination amendment as the only method by which Congress can ever fully free the Indians from the status in which they are now held. Jemison spoke for herself alone, but Helen Peterson, speaking on behalf of the NCAI, questioned the claim that it would restore the same rights to Indian tribes which are enjoyed by all other citizens of the United States, pointing out that it would give Indians nothing, since they had been granted citizenship in 1924, and would take from Indians protections they are properly entitled to and want to keep. That spring, in March 1954, 4 Puerto Rican nationalists, led by 34-year-old Lolita Lebron, carried semi-automatic pistols into the visitors' balcony at the Capitol, began to unfurl a Puerto Rican flag, shouted "Viva Puerto Rico Libre," and fired nearly 30 rounds, wounding 5 members of Congress. Ethel Payne, reporting from the Hill that day, had only just left the chamber, moments before the shooting. Before the insurrection on January 6, 2021, by armed supporters of President Donald Trump, it was the only successful invasion of the U.S. Capitol. 2 months after the invasion, the Supreme Court handed down its decision in Brown v. Board of Education. We have nothing to fear from the record of history. The Supreme Court had been unable to make a decision after the first round of oral arguments, so Justice Frankfurter had convinced his colleagues to hold the case over to the following term. Frankfurter also asked his clerk, Alexander Bickel, to research this history. Bickel minutely reviewed the records of the 39th Congress and argued that, as originally understood, the 14th Amendment did not apply to segregation in schools or otherwise, but that its framers had crafted it with language sufficiently elastic to permit reasonable future advances. Frankfurter's clerk concluded that the legislative history of the amendment is, in a word, inconclusive, but asserted that the record of history, properly understood, invited a decision that would consider the condition of the United States in the 1950s, not the 1860s. Frankfurter then circulated the memo to the other justices. Vinson called for re-argument in Brown and asked the parties to ascertain what was the interpretation of the 14th Amendment with reference to schools at the time of its adoption. And then, unexpectedly, in September 1953, Vinson, 63, died of a heart attack. "This is the first solid piece of evidence I've ever had that there really is a God," Frankfurter said privately. After Eisenhower named California Governor Earl Warren to replace Vinson, Warren asked the parties in the case to answer Vinson's 5 questions about the history of the 14th Amendment. The Richmond lawyer David J. Mays prepared the answers for the Virginia case. Mays's law firm represented the segregated school district in Davis v. County School Board of Prince Edward County, a suit filed by the NAACP on behalf of more than 100 students, including the leading plaintiff, Dorothy Davis, a 14-year-old girl. Mays would go on to become the architect of the South's campaign of massive resistance to integration, and later of original intent, originalism. David John Mays, born in Richmond in 1896, just 7 years after the death of Jefferson Davis, was a child of the lost cause. "I had almost memorized the Klansman when still a little fellow," he recalled, referring to Thomas Dixon's 1905 novel, The Klansman, a historical romance of the Ku Klux Klan, in which a thinly disguised Thaddeus Stevens, calling the Constitution a worn-out rag, "We have outgrown the swaddling clothes of a babe. We will make new constitutions," orchestrates what Dixon calls the Black Plague of Reconstruction, leading heroic Southerners to form the Klan to defend the Constitution in the spirit of chivalry, humanity, mercy, and patriotism. In 1915, Mays took the train from Virginia to the Capitol to watch D.W. Griffith's film adaptation of the book, The Birth of a Nation. 2 years later, he'd seen his first lynching in Memphis. He and his friends howled with excitement at the prospect, he wrote in his diary, and he watched with a mob of 3,000 as a black man named L. Persons was doused with gasoline. "When the match was applied," Mays wrote, "Persons made no sound except for a faint pig squeal." Mays served in the military both before and during the First World War, when he also began to devote himself to colonial American history. He studied law at the University of Richmond. In 1924, after entering private practice, he began writing a biography of Edmund Pendleton. It would take him a quarter century to finish. With the exception of a series of letters to James Madison, Pendleton's papers had been mostly destroyed. Mays spent years tracking down what survived of his other correspondence in scattered archives. Politically, Mays started out as a conservative Democrat, but despised the New Deal and left the party over civil rights. Above all, he was a Southerner. When he was a young lawyer, he complained in his diary that his black maid, Sarah Good, chose Washington, D.C. as her destination for a week's vacation. "I should much prefer her going somewhere else," he wrote. "The Negroes there have entirely too many liberties to suit me." He lost faith with the Democratic Party under FDR. "I have about all the New Deal that I can stand," he wrote in his diary in 1935. He generally favored social legislation, including the abolition of child labor, but he opposed executive overreach and was outraged by Roosevelt's court-packing plan. "I have stomached much of Roosevelt," he fumed, "but no more." He undertook a letter-writing campaign nationally to defeat it. In May 1953, Mays won the Pulitzer Prize for his biography of Pendleton, the year Ernest Hemingway won the Fiction Prize for The Old Man and the Sea. The next month, the court issued the call for the parties in the school segregation cases to answer those 5 questions about the history of the 14th Amendment. Mays sent a staff of men to conduct research in the Library of Congress, the New York Public Library, and other libraries 4 weeks, then summarized that information for the court. In November 1953, Mays's firm submitted its brief to the Supreme Court. At over 200 pages, it bears the hallmarks of Mays' approach to historical research, and equally his voice, as when the brief insists, "We have nothing to fear from the record of history." Or when it mocks the NAACP's brief as having been written by one of the Negroid conspiracy school of historians. It interprets all history in the light of a supposed race struggle. The Mays brief argues that the framers of the 14th Amendment did not intend to abolish segregation in public schools and did not imagine that anyone in the future might interpret the amendment in that way, and that under these circumstances, the court lacks the power to do so. The brief does not argue that the justices are in all cases obligated to base a decision on research into the original intent of the framers, because this intent cannot generally be known, but insists that this is a different case, where here the exact intention of the framers is known, and it therefore constrains the court because the judicial power does not extend to reversal of the exact intention expressed by the framers. On May 17, 1954, Ethel Payne was in the courtroom with a slew of reporters awaiting the court's decision. Chief Justice Warren elected to read the 9-0 opinion aloud. He spoke at length about what research into the history of the 14th Amendment had revealed and what it had not. The most avid proponents of the post-war amendments undoubtedly intended them to remove all legal distinction among all persons born or naturalized in the United States, he observed. But their opponents, just as certainly, were antagonistic to both the letter and the spirit of the amendments and wished them to have the most limited effect. What others in Congress and the state legislatures had in mind cannot be determined with any degree of certainty. In short, he said, borrowing a term from Bickle's brief, the historical record was inconclusive. When Warren declared the historical record inconclusive, he was dismissing research that Mays, the newly anointed Pulitzer Prize-winning historian, had overseen. As Mays put it, his interpretation of the 14th Amendment was argued but never heard. For the rest of his life, he dedicated himself to getting Americans to listen to it and to heed it. On May 17th, the Constitution of the United States was destroyed. The day Warren announced the court's opinion, Mississippi Senator James Eastland declared, "The South will not abide by nor obey this legislative decision by a political court." Eastland, born in Sunflower County, Mississippi in 1904, owned a nearly 6,000-acre cotton plantation there. An arch anti-communist, he'd hunted for subversives in his role on the Senate Judiciary Committee's Internal Security Subcommittee, on which he served beginning in 1951. More famously, sometimes called the Voice of the South, he was one of the Senate's leading defenders of segregation. Within days of the court's ruling in Brown, another Mississippi Democrat stood up on the floor of Congress and proposed a constitutional amendment to overturn it. And Eastland introduced his own proposed amendment into the Senate, then regularly reintroduced it, granting the state's exclusive jurisdiction to regulate health, morals, education, marriage, and good order. There is nothing in the United States Constitution that gives the Congress, the President, or the Supreme Court the right to declare that white and colored children must attend the same public schools, Eastland liked to say. By July 1954, first in Mississippi, then swiftly spreading, Southerners began forming white citizens' councils, sometimes known as the Uptown Klan, to oppose integration. Attacks on black men, women, and children grew in number and ferocity. Unable to keep schools segregated, some state legislatures proposed constitutional amendments to instead abolish public education. In September, the Associated Press filed a report from Jackson, Mississippi, quoting a legislator from the Mississippi Delta who embraced lynching. "A few killings would be the best thing for the state just before the people vote on a proposed constitutional amendment empowering the legislature to abolish public schools," the Mississippi lawmaker told the AP reporter, because those murders would make certain that the people would approve the amendment and would save a lot of bloodshed later on. Opponents of the court's decision in Brown claimed that the NAACP was a communist front. James Eastland and Joseph McCarthy, even after McCarthy's downfall, issued a statement in which they accused Chief Justice Warren of following the communist line. The emergence of Puerto Rico's independence movement, the resistance of the National Congress of American Indians to being amended out of the U.S. Constitution, and Cold War concerns about the spread of communism in newly decolonized nations formed a backdrop both to the Supreme Court's decision in Brown v. Board of Education and to Southern segregationists' reaction to it, which was to defy it by any means necessary. On May 17th, the Constitution of the United States was destroyed, Eastland liked to say at Citizens Council rallies, telling white Southerners, "You are not required to obey any court which passes out such a ruling. In fact, you are obligated to defy it." Virginia Senator Harry Flood Byrd called for a campaign of massive resistance to Brown. The engineer of that campaign was David J. Mays. Beginning in January 1955, Mays served as lead counsel to a commission charged by the governor of Virginia with reporting on the effect of the Supreme Court's decision on the state and framing a legal approach to minimize its reach. The art of it is to recognize the binding force of the Supreme Court decision while destroying its effect, Mays wrote in his diary. It was Mays who determined what statement the commission ought to make and who conducted most of its research. "Plowing through constitutions," he wrote in his diary. He also served as lead counsel in continued battles with the NAACP in Virginia, time and again facing Thurgood Marshall in court. In September 1955, the Prince Edward schools reopened, still segregated. "It took a great deal to bring this about," Mays beamed. "I'm glad to have had a part in it." He did not, however, expect to prevail in the U.S. Supreme Court, where, as he wrote in his diary, "The 9 wise men will pay no attention to mere white folk." The Virginia Commission issued its report in November 1955, opening with a restatement of the chief argument of the Mays brief. "When the 14th Amendment was adopted 3 generations ago, no one dreamed that it had any application to segregation in the public schools." The report also recommended a series of solutions, chiefly to be enacted by way of a state constitutional convention, whose purpose was to avoid enforced integration. Mays coordinated the convention, was elected a delegate, receiving 0 votes in black precincts, and while demurring from serving as its president, ran the convention from behind the scenes. Mays also worked closely with James Kilpatrick, editor of the Richmond News Leader, who in a series of editorials essentially called for Calhoun-style nullification. Resurrecting the antebellum Southern idea that the Constitution is merely a compact among sovereign states, Kilpatrick argued that the states retain a right of interposition by interposing their sovereignty between the federal government and the citizens of a state. They could approve or reject any new meaning of the Constitution offered by the court. Without this right, Kilpatrick insisted, the states would be compelled to lie down like sheep and be sheared by any court. White supremacists' reaction to the court's decision in Brown inaugurated a new era in the history of American constitutionalism. Conservatives pursued constitutional amendment as a mechanism for reversing the expansion of federal power represented by both the New Deal and the decisions of the Warren Court, beginning with Brown. And when that failed, they turned to original intent. Not for decades would this method come to be called originalism, but it first broke out into public view in 1954. Defiance of Brown v. Board consolidated conservatives' commitment to constitutional amendment as the only legitimate method of constitutional change, at least so long as the Warren Court lasted, since it was the only method that bypassed both the judicial and executive branches. In 1955, in response to Brown v. Board, amendment fever broke out as local and national organizations advocated a slate of proposed constitutional amendments to overturn the New Deal, halt creeping communism in America, and use states' rights arguments to defeat the assertion of federal power represented by the court's decision in Brown. They printed newsletters and pamphlets, some of them to tiny circulations by mimeograph. They broadcast over the radio. In the South, white citizens' councils made their constitutional claims in publications like The Crusader, The Alabamian, and The White Sentinel. But the kingpin was the stylish and erudite National Review, founded by William F. Buckley in 1955, in answer to Warren's insistence that one cannot turn back the clock in order to, as he put it, stand athwart history and yell stop. Massive resistance wasn't only massive resistance to desegregation. It was massive resistance to federal power. The Campaign for the 48 States, founded in 1955, sought passage of 5 federal constitutional amendments: the Reed-Dirksen Amendment, establishing a top tax rate; the Byrd-Bridges Amendment, requiring the federal government to balance its budget; the Reed-Walter Amendment, to grant the states full power to amend the Constitution without the intervention of Congress; the Munt-Kodert Amendment, restructuring the Electoral College so as to take away excessive power now exercised by the minority groups in the larger cities; and the isolationist Bricker Amendment, sponsored by Ohio conservative Senator John Bricker, to constrain the executive's treaty-making powers. None of these 5 amendments captured the attention of the public, but not for lack of trying. The Campaign for the 48 States produced a series of short television programs, Twilight Zone-like in their alarmism, one for each of its amendments. The episode on the Byrd-Bridges Amendment was titled, "The Thief Who's Never Been Caught." After a cue for a crash of cymbals, thunderous chord, rolling of timpani, and powerful dramatic music, and the warning that this thief, inflation, which contributes to the national debt, will remain at large unless he is forever chained down by constitutional amendments, its announcer gravely intones, "The program you are about to see is the most important one that has ever been on television." The Balanced Budget Amendment went nowhere in the 1950s, but it would come back in the 1970s with a vengeance. The Bricker Amendment was the best known of the proposals advanced by the Campaign for the 48 States, but a 1953 poll found that fewer than 1 in 5 Americans had heard of it. The same poll reported that only 1 in 3 Americans correctly answered the question, what are the first 10 amendments to the Constitution called? Still, the 20% of Americans who had heard of the Bricker Amendment were decidedly zealous about it. At a time when conservative suburban white women were the fastest-growing and most active foot soldiers in the Republican Party, a vast array of citizens' organizations had sprouted up, including Vigilant Women for the Bricker Amendment, based in the Midwest, which published a monthly newsletter. Brickerites viewed the United States' involvement in the United Nations as a betrayal of the Constitution, objected to the U.S. ratification in February 1955 of the 1949 Geneva Conventions, believed American consideration of the UN's 1948 Convention on the Prevention and Punishment of the Crime of Genocide to be unconstitutional, and generally feared a world government and a treaty power never foreseen or intended by the Founding Fathers. Liberal intellectuals from Louis Hartz to Richard Hofstadter dismissed the far right as a lunatic, paranoid fringe. But opposition to Brown gathered all manner of states' rights advocates, isolationists, white supremacists, Klansmen, anti-communists, John Birchers, and tax revolters. Together, they were far stronger than the sum of their parts. Among the now forgotten national leaders of this piecemeal movement in the 1950s was Howard Drummond Smoot, known as Dan Smoot, a self-identified constitutional conservative. Born in Missouri in 1913, Smoot grew up in poverty, working as a child on a hog farm. He won a scholarship to Southern Methodist University, and in 1941 began a Ph.D. in American civilization at Harvard, but dropped out to work for the FBI, where he pursued communist subversives. He could not enlist due to color blindness and flat feet. He was forceful and aggressive and had a tendency to be a little overconfident, which was attributed to his recognition of his own intelligence and ability, one supervisor reported. For being extremely antagonistic, sullen, and very uncooperative, and for having questioned the special agent in charge, he was censured and put on probation in May 1951. By June, he had resigned to work for the millionaire Texas oilman and far-right provocateur H.L. Hunt. After he left the FBI, he turned to political commentary and broadcasting, issuing Dan Smoot Speaks and later the Dan Smoot Report as a newsletter from Dallas, beginning in 1955, and 2 years later as a weekly 15-minute radio and television spot heard throughout the South, Midwest, and West Coast to an audience that reached 6 million. Soon, the FBI was keeping a file on Smoot, not as a former agent, but as a current political commentator whose radio program would be heard at White Citizens Council meetings. Smoot asked the FBI to send him a letter stating that he had resigned and not been fired, but meanwhile the FBI was conducting its own inquiry into him, noting in his file that he had, for instance, told a crowd of 1,000 people in Portland, Oregon, that a vote for either party this November is a vote for the Communist Manifesto. For his televised Dan Smoot report, Smoot looked half G-man, clean-shaven with close-cropped hair and a dark suit and tie, and half professor, sitting behind a wooden desk in front of a wall lined with bookshelves and a globe. The 14th Amendment, he said in one episode, was never legally adopted, calling it an illegal appendage to our organic law. Beyond the repeal of the 14th Amendment, the strenuous proposals of new amendments, interposition, and old-fashioned political violence, segregationists also explored the possibility of calling a federal constitutional convention to overturn Brown v. Board. This method had the advantage of not only bypassing the federal judicial and executive branches, but Congress as well. The entire work of amendment, from proposal to ratification, would be done in the states. In February 1955, the Georgia legislature petitioned Congress to call a convention to consider an amendment affirming the state's exclusive power to operate and regulate their schools. In March, the Mississippi House of Representatives voted to petition Congress to call a convention to amend Article 5 so that in the future a convention could be called whenever the legislatures of any 12 states called for one by a 2/3 vote. It would take little guessing to list who those states would be, Ethel Payne reported, with not a little bitterness in the Chicago Defender. There had been 11 states in the Confederacy. Mississippi's petition never made it to Congress. It died in the state's Senate Judiciary Committee, which feared that the southern states would be outnumbered in a constitutional convention. Our voice would sound like a summer rain on Niagara Falls. Payne was worried. Southerners opposed to integration had no hope of getting enough states to call a convention or achieving a constitutional amendment to undo Brown, any more than they had ever had any hope, a generation or two before, of repealing the 14th Amendment. Still, the performance of these efforts was not without meaning and consequence. And as Payne pointed out, they were supported by Northerners who wanted to get the Bricker Amendment through. She was not wrong to worry. In the spring of 1955, the Senate Judiciary Committee's Subcommittee on Constitutional Amendments began hearings on the Bricker Amendment, despite its lack of widespread public support. It was not difficult to imagine that were a constitutional convention to have been successfully called in the 1950s, Brickerites, Birchers, and segregationists would have been willing to scratch one another's backs. Ethel Payne's report from Washington on March 26, 1955, about Southern states' interest in holding a constitutional convention was one of the last she filed before boarding a plane to attend a very different convention. The Color Curtain. Early one morning in March 1955, Payne, still in bed, got a call from her editor in Chicago. "How would you like to go to Indonesia?" Well, I was half asleep, so I said, "Indo who?" And he said, "Yes, Indonesia. You know, there's a great conference going to take place there." He said, "It's the first conference of darker people of the world, and we thought you would be the person to go and cover it." So I said, "Yes? When?" And he said, "Well, like yesterday." Bandung was Payne's first foreign assignment, and she was leery, but she also needed a break from Washington. she'd become notorious for asking Eisenhower hard questions about his civil rights agenda during press conferences at the White House. By the summer of 1954, he'd become so annoyed that he stopped calling on her. She went to Chicago and packed her bags. She got her shots. She flew to California and boarded a TWA plane for the 22-hour flight from San Francisco to Manila, stopping in Hawaii to refuel. Then she got on a private jet with the head of the Philippine delegation to the Bandung conference and flew to Jakarta. When the plane landed, a group of Indonesian students swarmed her. "I'm just a reporter," she told them. But they really wanted to talk to her. "We heard you were coming and we want to talk to you," they insisted. "We want to learn all about you. We want to learn all about what's happening in your country to Negroes in your country." With more than 1,000 delegates from 29 newly independent countries, representing 2/3 of the world's population, the Bandung Conference was scheduled to begin on April 18, 1955. It was not drafting a constitution, but it would have its influence on American constitutionalism. Ethel Payne called it the first time in history that a summoning of the darker people of the world has taken place. The American press mainly represented Bandung as a bid by China to lure its neighbors into the communist fold, or even as a prelude to war. Some credence was being given to the possibility of a communist attack after the Asian-African Conference, said a Georgia Democrat who chaired the Senate Foreign Relations Committee. The Eisenhower administration had rejected the request of Congressman Adam Clayton Powell, Jr., New York Democrat, to attend as a representative of the United States. And W.E.B. Du Bois, Paul Robeson, and Roy Wilkins were all prevented from attending because the State Department had revoked their passports as suspected communists. Eisenhower refused to send so much as a message to the conference, though the NAACP sent one on behalf of all Americans of goodwill. Richard Wright, the celebrated Black American writer living in France, read about the conference in the newspaper, a meeting of the despised, the insulted, the hurt, the dispossessed, in short, the underdogs of the human race, as he wrote. "I felt that I had to go." White people he met in Paris were skeptical. "But is not this Asian-African conference merely racism in reverse?" a young white American asked me. He was obviously worried. "I think that the Asians and Africans are trying to gang up on the Western world," a young woman, a journalist, told me. "Isn't this racism inspired by the communists?" an American professor asked me. There had been rumors, too, that the United States sought to undermine the conference. Powell, denied by the State Department an official role at the conference, went anyway. As soon as he arrived, he held a press conference. "Anyone who said the United States was out to sabotage this conference was a liar," he said. He talked about the great progress on integration in the United States and insisted that racial discrimination couldn't be used as a propaganda weapon. He stood, if not as an ambassador, then as a racial emissary, evidence of his claim that racism is on the way out in the United States and nothing can stop it. Payne didn't have much use for Powell, who was vain and full of bluster. United States fears that the precedent-setting conference would be red-dominated appeared unfounded in the opening days, she reported. But she was impressed by Indonesian President Sukarno, particularly by his opening address. "For many generations, our peoples have been the voiceless ones in the world," Sukarno said. "We are often told that colonialism is dead. Let us not be deceived or even soothed by that." He then cleverly gestured toward the United States, calling on delegates' common detestation of colonialism by remarking on the significance of the date. It had been on another April 18th, in 1775, that Paul Revere had ridden to Lexington and Concord with the warning that the British were coming. Sukarno called the American Revolution the first successful anti-colonial war in history. "But that war won't be won," he went on, "until we can survey this our own world and can say that colonialism is dead." Tennessee-born Carl T. Rowan, who'd served as a naval officer during the Second World War and then gone to Oberlin on the GI Bill, reported on Bandung for the Minneapolis Tribune. one of only a handful of black reporters writing for a general newspaper, he toured the South for the Tribune in 1951. In the 1960s, he'd become President John F. Kennedy's Deputy Assistant Secretary of State, and then, under Lyndon Johnson, Director of the United States Information Agency and a member of the National Security Council, making him the highest-ranking African-American in the federal government till that time. Rowan had a much wryer voice than Payne's, but he agreed with her assessment of Sukarno's opening address. Anyone who expected him to cite Marx or the Soviet Revolution were disappointed. Richard Wright published his quite different impressions of Bandung in The Color Curtain. The coinage of the title, a recasting of Churchill's Iron Curtain, didn't stick. If Rowan's takeaway was that the United States ought to do a better job countering the anti-American propaganda of authoritarian regimes around the world, Bandung's broader message, for Wright, was that the color struggle was the world's struggle. And Adam Clayton Powell, after he returned to the United States, concluded almost exactly the reverse. Bandung had completely changed my thinking, he later reflected, in that it led him to see civil rights as not a black struggle, but as America's struggle. After Bandung, Rowan traveled across Asia, discussing constitutions with villagers and leaders from India, Pakistan, and Burma to Hong Kong, Thailand, and the Philippines. In a thatched hut village south of Madras, villagers told him that the Indian constitution has outlawed caste. Rowan found the evidence for this claim vanishingly slim. Everywhere he went, he met people who pressed him about the South's campaign of massive resistance to desegregation. I was banging my head against a stone wall and trying to convince them that while injustices remained, Rowan wrote, Negroes were making startling strides toward first-class citizenship, and that if life lasted, we would reach our goal in America in a democratic way. Bandung set the American civil rights movement in a global context, but also exerted an influence on it. Homer A. Jack, an American peace activist, went to Bandung, where there was much talk of Gandhian nonviolence. Jack had been an avid student of Gandhi. He had worked at the War Resisters League with Bayard Rustin. In 1947, through the Congress of Racial Equality, or CORE, they had organized the first Freedom Ride through the South. After Bandung, Rustin had begun advising the young Baptist preacher Martin Luther King Jr. during a bus boycott in Alabama. They have conducted a disciplined campaign which would in many aspects have made Mahatma Gandhi very proud, Homer Jack would report from Montgomery. Much in the history of the civil rights movement involves the march from Montgomery to Selma. But in the history of American constitutionalism, much involves the journey from Bandung to Montgomery. The Declaration of Constitutional Principles. When Ethel Payne returned from Bandung, she went to Montgomery. She'd never been to the South. By the time she filed her first report, the bus boycott, begun by Rosa Parks on behalf of the NAACP in December 1955, was in its 10th week. Blacks in Montgomery got around town and to and from work, mainly by walking. The young, the old, the middle-aged, the lame and the halt, housewives, maids, and cooks, bellhops, janitors, and laborers, school teachers, doctors, and lawyers, Payne wrote, they were all taking to the road. Payne wrote an early account of King. This gladiator going into battle wears a reverse collar, a flowing robe, and carries a Bible in his hand. She cited the influence of Gandhi on the boycott. She asked the defender if she could stay in the South and report from there. In an investigative series called The South at the Crossroads, which ran in the Defender, and which the newspaper, in a nod to Richard Wright, advertised as Payne reporting from behind the color curtain, she reported on white resistance to Brown v. Board and predicted that someday a local authority is going to defy a direct order from the courts to admit Negro children, and the courts will then be required to prosecute and carry out that order. She compared Jim Crow in the American South to apartheid in South Africa and explained that the backbone of the Montgomery bus boycott was women working as cooks and maids and nannies in white households. And she reported on the travels of James Eastland. When Payne arrived in Montgomery, Eastland was in the city to address an Alabama White Citizens Council rally. At the time, Southerners in the Senate were preparing a formal statement replying to Brown. Georgia Senator Richard Russell had heard an idea he adored. The Corwin Amendment had passed Congress in 1861, had been ratified by 3 states, Maryland, Ohio, and Illinois, and had no ratification deadline. What if it could be resurrected? It read, "No amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state." Weren't public schools domestic institutions? Russell had written to the Georgia Attorney General, arguing for the state to ratify it. This might be called the story of the Lost Amendment, the New York Times reported. True, the Corwin Amendment would seem to violate the 13th Amendment, but Russell still liked the idea. A lost amendment for the lost cause. At the same time, Russell and Byrd were working with another arch-segregationist, South Carolina Senator Strom Thurmond, to draft what they called a Declaration of Constitutional Principles. Thurmond was its principal author. It followed the logic of Kilpatrick's editorials. Russell was frustrated that an early draft, calling Brown illegal and unconstitutional, had been deleted in order to secure the signatures of more moderate Southerners. On March 12, 1956, 2 days after the Times reported on the moonshot Lost Amendment strategy, the declaration was released to the press, and Georgia Senator Walter George read it out loud in the Senate. Rebutting Warren's opinion in Brown, it offered the opinion its signers wished the court had written instead. The original Constitution does not mention education, neither does the 14th Amendment nor any other amendment. The debates preceding the submission of the 14th Amendment clearly show that there was no intent that it should affect the systems of education maintained by the states. And it contained an indictment of the court. Though there has been no constitutional amendment or act of Congress changing this established legal principle, almost a century old, the Supreme Court of the United States, with no legal basis for such action, undertook to exercise their naked judicial power and substituted their personal, political, and social ideas for the established law of the land. The Southern Manifesto, as the Declaration of Constitutional Principles became known, was signed by 77 members of Congress and 19 senators, all from the former Confederacy. Only 3 Southern senators, Albert Gore, Estes Kefauver, and Lyndon B. Johnson, refused to sign. All 3 aspired to the presidency. How did the nation react to this? Carl Rowan asked. It shuddered, just the way the Southerners hoped. Reading the manifesto, many Northerners came to believe that Brown could not be enforced, and that maybe it shouldn't be. The manifesto urged resistance to Brown by lawful means, but it was hard to see what could be lawful about resisting a decision of the Supreme Court. Eastland, in particular, would soon be exceptionally well positioned to block the appointment of Supreme Court justices who approved of the decision. By the end of the year, he'd become chair of the Senate Judiciary Committee. Some signers told reporters that the lawful means included proposing constitutional amendments. Rowan complained that Southerners, even as they parade in the cloaks of flaming patriots, fill the nation with strife, tear away at the judicial system, and discredit democracy in the darkest, farthest corners of the globe. Payne wrote that the Southern Manifesto came very close to declared treason. In response to it, the Executive Committee of the National Baptist Convention, meeting in Chicago in April, issued the Negroes' Declaration of Intention. It avowed the civil rights movement's love for our nation, goodwill towards all, utter devotion to the federal Constitution, and undying faith in God, along with its commitment to the complete victory of freedom on every front and the preservation of the soul of the nation, whatever the cost. Payne read the Southern Manifesto with another manifesto in mind. In Montgomery, she'd gone to see Eastland speak at the State Coliseum to that White Citizens Council rally, 12,000 strong. At the event, the organizers distributed handbills that read, "A preview of the Declaration of Segregation. When in the course of human events it becomes necessary to abolish the Negro race, Proper methods should be used. Among these are guns, bows and arrows, slingshots, and knives. We hold these truths to be self-evident, that all whites are created equal, with certain rights. Among these are life, liberty, and the pursuit of dead niggers. In every state of the bus boycott, we have been oppressed and degraded because of the juicy, unbearably stinking niggers. Her story about it ran on March 7, 1956. 5 days later, the Confederates in the Capitol issued their own declaration. A question of intent. The authors of the Southern Manifesto argued that in Brown v. Board, the court had violated the original Constitution by making an alteration to the Constitution that could rightly be changed only by constitutional amendment. To support this argument, and in the hope of reversing Brown, they insisted that the only way to interpret that original Constitution was to discover the intent of the framers and the text's original meaning. Segregation had been denounced, if faintly, by both parties. The Southern white man has nowhere to go politically, Mays complained in his diary on November 5, 1956, Election Day. Massive resistance was failing. All these court cases, Mays wrote, were so many paper dolls. Mays voted for Dwight Eisenhower, but Eisenhower disappointed him even more than FDR had. In September 1957, on the orders of Governor Orville Faubus, a high school in Little Rock refused to admit black students. After a standoff, Eisenhower called in 101st Airborne Division to enforce integration. Before September 3rd, Little Rock was just the capital of Arkansas, Ethel Payne wrote. Now, thanks to the foolhardiness of Governor Faubus, it has become infamous as the seat of defiance of the federal government. For Payne, every story in the South had a global dimension. That had been true for her before Bandung, and it had only become clearer afterward. In 1957, the year she traveled to Ghana to report on its independence, she also reported from Birmingham. Living in the South today is about as uneasy and dangerous as it is along the Gaza Strip in the Middle East. But black reporters like Payne and Rowan weren't imagining the international dimensions of America's constitutional impasse over race. Dalip Singh Sand, a Sikh American from California and the first Asian member of Congress, was on a trip to Southeast Asia during the crisis at Little Rock. From abroad, he liked to report on how the budding new nations growing out of the wreckage of colonial empires are one and all writing their constitutions on the American pattern, and the Declaration of Independence and the Bill of Rights have been eagerly studied and widely copied. This was both true and not true. It was certainly true that many newly independent nations had written constitutions that borrowed from the American Constitution, though its own outdatedness, especially with regard to human rights, meant that its influence as a model was, by the 1950s, on the decline. Most new constitutions guaranteed rights like women's rights that the U.S. Constitution did not, and the U.S. Constitution guaranteed some rights, like the right to bear arms, that hardly any new constitutions included. A tiny 8% of national constitutions contained a right to bear arms in 1946. Only 2% contained such a provision by 2006. It was also true that the imprinting of an American constitutional pattern on new nations was a story that Eisenhower's America wanted to tell, as if the sheepskin parchment sheets of the Constitution, stored in a concrete and steel bunker 20 stories below ground in hopes that they would survive an atomic bomb, could be laid out upon the new revolutionary office device, the Xerox copying machine. And yet the American pattern in the 1950s seemed hardly one to emulate. Sand, speaking of the events at Little Rock, and, like Adam Clayton Powell before him, hoping to burnish America's reputation for equal rights, insisted that in 35 out of the 48 states of the Union, there was no discrimination against Negroes in schools or public places. This was not quite a comfort. And if the civil rights movement was gaining strength by the end of the 1950s, in 1957 Congress was debating the first Civil Rights Act since Reconstruction, so was the conservative response to it, and not merely among the Dan Smoots of the world. The central question, wrote Buckley in the National Review in 1957, is whether the white community in the South is entitled to take such measures as are necessary to prevail, politically and culturally, in areas in which it does not predominate numerically. That is, was the South justified in denying black citizens the right to vote? And here is how Buckley answered. The sobering answer is yes. The white community is so entitled because, for the time being, it is the advanced race. To say that white supremacy lay behind opposition to Brown v. Board of Education is not to say that the opposition had no constitutional argument to make as well, and that argument was made, but separating the two is like trying to pull apart the strands of plied yarn. With massive resistance failing and federal troops enforcing integration, David J. Mays came up with a new idea. In 1958, at his urging, the Virginia legislature created the Commission on Constitutional Government, or CCG. As agreed, the governor then asked Mays to head the commission. Mays planned to use the commission, which he referred to as my CCG, to shift the campaign of massive resistance from a focus on race and the undesirability of integration to a focus on the Constitution and a return to its original intent. If it had become unpalatable to defend segregation, it was certainly still possible to defend the sanctity of the Constitution. Mays led the Commission on Constitutional Government, but his deputy was the Richmond News Leader editor and instigator of the interposition option, James J. Kilpatrick, who had by now become a contributor to the National Review. Like the Liberty League of James Beck's day, the CCG aimed to promote the idea of states' rights and original intent through publications and a high school curriculum. In 1959, Mays agreed to testify before Congress in support of a constitutional amendment that would return the question of segregation to the states. It had been proposed by Georgia Senator Herman Talmadge and was co-sponsored by 6 other Southern senators, including Eastland and Byrd, all of whom had signed the Southern Manifesto. It was, in effect, a version of the Lost Amendment that Russell had dreamed of. Like the 1861 Corwin Amendment, which placed slavery forever out of the power of the federal government, the Talmadge Amendment placed public education forever out of the power of the federal government. Herman Talmadge had long served as governor of Georgia, following in the footsteps of his father, Eugene Mr. Segregation Talmadge. Between them, they'd held the governor's office for 60 years. In 1955, before running for the U.S. Senate, Herman Talmadge published a pamphlet called You and Segregation, a primer on states' rights and a call for resistance to Brown v. Board. Talmadge's pamphlet took particular aim at the NAACP, which, he intimated, was a communist front whose members yell for the Supreme Court like spoiled brats. Talmadge's pamphlet did not include a call for a return to the original intent of the framers. It was instead a mix of heated anti-communist ranting and a strenuous argument for states' rights. Yet of all the strategies used by segregationists to overturn Brown, an amendment along the lines that Talmadge proposed in January 1959 earned the most popular support. It has been suggested that the Constitution of the United States be amended to permit each state to decide for itself what it wants to do about integration of white and colored students in the schools, Gallup said in a poll conducted the first week of February 1959. Would you favor or oppose such an amendment? 51% of Americans were in favor. That spring, the Senate Judiciary Committee's Subcommittee on Constitutional Amendments, whose members included Eastland, held 5 days of hearings on Talmadge's amendment. Talmadge, under questioning, told his colleagues that he did not consider a ruling of the Supreme Court to be the law of the land, a position repeated by a parade of other pro-amendment, pro-segregation witnesses, including the head of the Sons of the Confederacy and the Sons of the Republic of Texas, and a fairly motley assortment of far-right figures, one of whom testified that the New York Times and the Washington Post were communist fronts. Very little of the testimony was particularly edifying until the third day, with the seating of David J. Mays. Mays took pains to make clear that he was appearing that day in his capacity not as the lead counsel in a series of legal battles with the NAACP, aimed at preventing the integration of Virginia schools, but in his capacity as head of the Virginia Commission on Constitutional Government. He knew Talmadge's amendment had no hope of passage, but he agreed to appear before the committee for propaganda reasons. He wanted his statement entered into the congressional record, writing in his diary, "My material may make a dent in somebody." It did. Despite insisting that he represented not his law firm, but the Commission on Constitutional Government, Mays explained his role in the school segregation cases and said that the statement he wished to enter into the record was simply a restatement of the brief his firm had submitted to the Supreme Court in 1953. "What I present here today is a summary of that summary," he said. And indeed it was a summary of that earlier research, leading to its conclusion that the Congress which initiated the 14th Amendment did not believe that it barred segregation in public schools. But Mays's 1959 statement to the Subcommittee on Constitutional Amendments also differed from that earlier brief in that it was far more concerned, as Mays told Congress, with the original intent of the 14th Amendment. When the CCG published Mays' testimony, it titled the tract, "A Question of Intent." The Talmadge Amendment truly was a lost cause. 51% approval in a Gallup poll wasn't anything close to the level of support required to amend the Constitution. Mays' strategy had always been better because it had a broader application. It didn't succeed in overturning Brown, but Mays' principal argument, which was to present a single mode of constitutional interpretation as the only legitimate mode, had the important benefit of equipping opponents of the Warren Court's many other landmark decisions with an argument that could be used against nearly all of them. Long before the nomination of Robert Bork and the spread of originalism across the federal judiciary, David J. Mays pioneered the judicial philosophy these men would adopt. Quietly, Mays, the Pulitzer Prize-winning segregationist, wrote the script. Part 4. The End of Amendment, 1961 to 2016. No unborn person shall be deprived of life by any person, provided, however, that nothing in this article shall prohibit a law permitting only those medical procedures required to prevent the death of the mother. Failed amendment to the U.S. Constitution, introduced into Congress, 1975. The bicentennial of the signing of the U.S. Constitution fell on September 17th, 1987, in Ronald Reagan's America, Hollywood in the White House. But the celebration had kicked off months before in Orlando, Florida, with a nationally televised parade down Main Street, USA, the Constitution's 200th anniversary piggybacking on Walt Disney World's much ballyhooed 15th birthday. B. Arthur and Betty White, the wisecracking first ladies of television comedy, arrived by hot air balloon. Mickey, Goofy, Donald Duck, and Chip the Chipmunk, dressed in 18th century cloaks, knee breeches, and tri-cornered hats, carried an American flag through a town square decorated with red, white, and blue bunting. Ray Charles and Dolly Parton performed, and while a choir sang a medley of patriotic tunes beginning with America the Beautiful, Charlton Heston, in blue blazer, white shirt, and red tie, played the role of America's lantern-jawed historian, explaining the origins and meaning of the Constitution. Our leaders of tomorrow must be as dedicated to its preservation as were the leaders of yesterday and the leaders of today, Heston commanded sternly. Former U.S. Supreme Court Chief Justice Warren Burger attended, too, as an official honoree. The Washington Post reported finding him hunkered down at Epcot Center in a reviewing stand with top Disney brass, waving with his two grandchildren as the marching bands, Mickey, Minnie, a giant rooster, dancing bears, and the like, paraded past in a remarkable flex of the hammerlock Walt Disney put on America. In the day-glow, light-bright, Morning in America 1980s, the Constitution had become kitsch. Launching the Constitution's bicentennial at Disney World had been arranged by a 17-member commission appointed by Reagan, a former television and film star who'd been groomed for political office since meeting William F. Buckley, Jr. in 1961. Reagan's Commission on the Bicentennial of the United States Constitution included the First Ladies of Conservatism, Phyllis Schlafly and Lynn Cheney. And in a true coup, he'd convinced the 77-year-old Berger to head the commission. Berger resigned from the court to accept the position. Berger, a Minnesotan, had been nominated to the court by Nixon in 1969. Over the next decades, the parties became sorted by ideology, liberals as Democrats, conservatives as Republicans. The distance between the parties widened, and the ideological intensity of partisans increased. These three developments, ideological sorting, heightened partisanship, and intensifying polarization, were to a considerable degree driven by decisions made by the Supreme Court, particularly those about the constitutional status of women, women's bodies, and their eggs, embryos, and fetuses. The Jeffersonian question of whether a constitution could bind generations as yet unborn took on new meaning as an emerging pro-life movement insisted on the constitutional rights and legal personhood of unborn children. As Chief Justice, Berger had been famously unwilling to speak to journalists, but during Disney World's 4-day press junket, he delivered an address to 6,000 reporters whose expenses, travel, lodging, and every Magic Kingdom meal, were all paid for by Disney. The only thing about Berger's speech that was newsworthy, according to the New York Times, was the way the press debased itself by reporting it. Asked by one journalist, who declined the dosh, whether all this might be trivializing the Constitution, Berger said, "I wouldn't let it worry me too much." And then in a televised ceremony, he presented Disney executive Michael Eisner with relics and replicas from the Constitutional Convention, on loan for the bicentennial. James Madison's desk, a vest worn by George Washington. Days later, in Washington, a madman with a hammer tried to smash the glass protecting the Constitution and the Bill of Rights in the National Archives, the first ever attack on the National Shrine. The bicentennial was inescapable. Grocery store cashiers gave away free copies of the Constitution. The government printed enough for every American household. A facsimile of the Constitution went on the road, along with an original of the Magna Carta in a temperature-controlled 40-foot trailer truck that traveled to more than 100 cities. ABC TV ran a series of bicentennial constitutional minutes during Saturday morning cartoons, featuring characters from Looney Tunes. Professor Bugs Bunny, dressed in cap and gown at the front of a lecture hall, sings an ode to the amendments that begins, "Our Constitution's really splendid, but sometimes we do amend it." Daffy Duck, dressed as a vaudevillian in waistcoat and spats, soft shoes across the stage, crying out, "Menda, menda, menda, menda." And then Bugs belts out, "It was intended to be amended." And it was intended to be amended, but it was no longer amendable. Instead of producing constitutional amendments, the civil rights, women's liberation, marriage equality, reproductive rights, and environmental movements produced landmark legislative gains and rights-protecting court decisions whose importance was matched only by their reversibility. Learning the lessons of the New Deal and the Civil Rights Movement, and after 1982, reeling from the derailing of the Equal Rights Amendment, liberals abandoned both constitutional amendment and democratic deliberation. Conservatives notionally championed amendment, but learning from liberals and reeling from their own many failed amendment attempts, they too sought constitutional change in the judiciary. On the 200th anniversary of the Constitutional Convention, asked whether they would consider holding another one for the purpose of amending the Constitution, 71% of Americans said it was a bad idea. For the bicentennial, Berger wanted Congress to declare Constitution Day, September 17, 1987, which happened to fall on his own 80th birthday, a one-time national holiday. This remarkable Constitution of ours, not perfect but remarkable and getting better as time goes on, is something that should be brought into the consciousness of every person in this country, he told a congressional committee in April 1987. The next month, in a speech in Hawaii, the aging Justice Thurgood Marshall declared his refusal to participate in the celebration. "I do not believe that the meaning of the Constitution was forever fixed at the Philadelphia Convention," the 78-year-old Marshall said. "Nor do I find the wisdom, foresight, and sense of justice exhibited by the framers particularly profound." Congress declined to declare Constitution Day a national holiday. And when the day came, September 17, 1987, Reagan delivered a bicentennial address at Independence Hall in Philadelphia, calling the Constitution a covenant with the Supreme Being, and CBS televised Philadelphia's Constitutional Parade. But on C-SPAN that day, you could watch a very different discussion of the Constitution. Reagan's new Supreme Court nominee, Robert Bork, was explaining his understanding of the nation's founding document to Joseph R. Biden, chair of the Senate Judiciary Committee. Reagan had nominated Bork, a Yale Law School professor, to the U.S. Court of Appeals for the D.C. Circuit in 1982. The Senate had confirmed his nomination unanimously. Berger's retirement in June 1986 had created a Supreme Court vacancy that Reagan filled with the brilliant and charming Antonin Scalia, whose appointment the Republican-led Senate approved by a vote of 98-0. In the summer of 1987, when Reagan tapped the 60-year-old Judge Bork to replace retiring Supreme Court Justice Lewis F. Powell, Jr., he expected opposition, but not strenuous opposition, and he certainly did not anticipate defeat. But when the Judiciary Committee opened hearings on Bork on September 15, 1987, the nominee faced a hostile Democrat-run committee. The abandonment of amendment had raised the stakes for Supreme Court appointments. Bork also proved unusually expansive in his answers. Where earlier nominees had followed a modified version of the Frankfurter Rule, placing strict limits on what they'd discuss, Bork announced on the first day of his confirmation hearings, "I welcome this opportunity to come before the committee and answer whatever questions the members may have." He added that though he said he was happy to discuss his judicial philosophy, he would demur on specific cases, a distinction that, as Ruth Bader Ginsburg would later remark, blurred as the questions and answers wore on, not least because Bork appeared delighted by the attention. The televised Bork hearings brought originalism as a judicial philosophy into public view in the character of a pompous and irascible man, just as Americans were being asked, even as they picked up a gallon of milk at the corner convenience store, to think about the Constitution and to think about it in a very particular ye olde way. Constitutional conservatism had come packaged with heritage tourism before, especially with the colonial revival of the 1920s. The brand advanced by Reagan's Justice Department in the 1980s had become for the first time the position of a political party, the GOP. It also advanced a new claim that the people who ratified the Constitution in 1787 had established its democratic legitimacy, and that therefore the liberal jurisprudence of the Supreme Court was fundamentally undemocratic, a betrayal not only of the nation's past, but of democracy itself. Bork had first publicly stated his emerging judicial philosophy in 1971, the last year the Constitution was meaningfully amended, when he gave a lecture at Indiana Law School that, printed in the Indiana Law Journal, would become one of the most cited law review articles ever published. His interest in the original intent of the framers had come in response to Griswold v. Connecticut, a 1965 Supreme Court case in which the court declared state laws banning contraception for married couples to be an unconstitutional violation of a right to privacy. In 1972, pressed by the women's liberation movement, Congress passed the Equal Rights Amendment and sent it to the states for ratification. It was widely expected to earn a speedy ratification. The next year, in Roe v. Wade, the Supreme Court applied the logic of Griswold to abortion and declared state laws banning the procedure during the first trimester to be an unconstitutional violation of a right to privacy. Opponents of Roe marshaled their forces against the ERA and triumphed. Its ratification window expired in 1982. Originalism as a method of constitutional interpretation had been greatly advanced in 1982 with the formation of the Federalist Society. It would earn a perch on the court with Scalia's appointment in 1986, and despite the defeat of Bork's nomination in October 1987, it would become enmeshed in American popular culture through the celebration of the bicentennial. The more power originalists gained in the federal judiciary during the Reagan Revolution, the less interest they expressed in Article 5 amendment. There was, however, an exception. Even as originalism came to prevail in the federal judiciary, a movement with origins in the fantasies of far-right extremists in the 1950s to achieve a list of constitutional outcomes that ranged from repealing the 16th Amendment to overturning Brown v. Board of Education was resurrected in the 1980s by supporters of a balanced budget amendment. Unable to get that amendment through Congress, fiscal conservatives began calling once again for a constitutional convention whose larger purpose swelled into a hope of dismantling the administrative state. Between 2014 and 2022, the legislatures of 19 states, including 9 of the 11 states of the Confederacy, passed resolutions calling for a convention to propose amendments to impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials and members of Congress. Since no such convention had ever taken place before, how delegates would be selected and what rules a convention would follow remained entirely unsettled. Despite the growing conservatism of the Supreme Court, liberals did not seek change by way of Article 5 amendment. This made sense strategically, since even if they had been able to get an amendment through Congress, they were unlikely to achieve ratification in the states. Mocked as Atari Democrats who courted wealthy knowledge workers and tech entrepreneurs and who abandoned blue-collar voters, liberals lost control of state legislatures. In 1978, Democrats controlled legislatures in 31 states, Republicans in 11. 7 legislatures were split. By 2015, the situation had flipped. Republicans controlled legislatures in 30 states, Democrats in 11. 8 legislatures were split. Democrats recovered in a handful of states. By 2024, Democrats controlled the legislatures in 21 states and Republicans 28. Liberals interested in federal constitutional change proved unwilling to endorse either amendments or a convention. But having sought constitutional change under the Warren Court from 1953 to 1969, they found that as the composition of the court changed, their gains were being reversed. In a 2013 decision, the court undid much of the 1965 Voting Rights Act. In 2022, in Dobbs v. Jackson Women's Health Organization, the most formidable legacy of the counter-revolutionary originalist insurgency, a Supreme Court majority overturned the 1973 decision Roe v. Wade. After Dobbs, Republicans, whose party platform had since 1976 advocated a constitutional amendment establishing either a right to life or the personhood of fetuses, withdrew that plank. The risk of insurrection rose. Much of this risk came from contested presidential elections and the public's declining approval of the Supreme Court. In 1969, after a proposal to abolish the Electoral College by constitutional amendment passed in the House, it was only very narrowly defeated in the Senate, mostly due to the surprising opposition of strange bedfellows, the NAACP and Southern segregationists. As the distribution of the population changed, the likelihood of a presidential candidate winning the White House but losing the popular vote grew. George W. Bush lost the popular vote to Al Gore in 2000, but won the Electoral College vote after the Supreme Court halted a recount in a contested vote in Florida. In 2016, Donald Trump lost the popular vote to Hillary Clinton by nearly 3 million votes, but won in the Electoral College. He appointed 3 justices to the Supreme Court, all originalists. Originalists had long insisted that the only way to change the Constitution was by Article 5 amendment. But even before conservatives gained control of the Supreme Court, they stopped calling for amendments, no more interested in bringing key constitutional changes to the public than were liberals. After Trump lost both the popular vote and the Electoral College vote to Biden in 2020, the president's followers staged an armed insurrection, invaded the U.S. Capitol in an attempt to halt the certification of the Electoral College vote, and called for the hanging of the vice president. After Trump was impeached in the House, the Senate voted 57-43 to convict him, falling short of the required two-thirds majority. In 2024, in a stunning political comeback, he won re-election, winning both the electoral and popular vote. In the early 2020s, a divided nation witnessed rising political violence that included not only a failed insurrection and a mob calling for the hanging of a vice president, but also the attempted assassination of President Trump and a plot to kill Supreme Court Justice Brett Kavanaugh. Republicans' 2024 platform endorsed no constitutional amendments, but did promise a national celebration to mark the 250th anniversary of the founding of the United States. A nearly 900-page conservative policy agenda known as Project 2025 advocated not a single constitutional amendment. Democrats proposed constitutional amendments, but only to diminish the power of the Supreme Court. 2.5 centuries after the American Revolution began, Americans appeared to have altogether abandoned the philosophy of amendment. Chapter 11. The Subcommittee on Constitutional Amendments. No person, government, or governmental agency shall deprive any person of the right to a decent, clean environment. Failed amendment to the U.S. Constitution, introduced into Congress, 1970. Birch Bayh was counting votes. He'd been counting votes on this amendment for 4 years, in the Senate, in the House, in committees and conferences, in his sleep. The stern-jawed senator from Indiana, a man people sometimes called the Kennedy of the Midwest, wanted to abolish the Electoral College. The method of electing the president had been the subject of more proposed amendments than any other feature of the Constitution. 6 times it had passed one branch of Congress. Bayh's version provided for a direct national popular vote, and in the event that no candidate met that threshold, a runoff would be held between the 2 top vote-getters. Bayh's proposal eliminated the existing provisions of throwing an electoral college tie to the House of Representatives. By September 1970, the Bayh Amendment had passed in the House 339-70. It enjoyed overwhelming popular support, polling at more than 80% in favor, and it had the faint-hearted endorsement of the President, Richard Nixon, the AFL-CIO, the American Bar Association, the League of Women Voters, and the U.S. Chamber of Commerce. As debate began in the Senate, Bayh knew he had at least 55 solid votes. He needed 67. The fate of one of the most sweeping constitutional changes ever put to a Senate test may depend on no more than a dozen votes, the Washington Post reported. "One man can make a difference," had been one of Bayh's campaign slogans. This time, he needed 12. Aside from James Madison and Thaddeus Stevens, no American did more to amend the Constitution than Birch Bayh. Americans ratified 4 amendments between 1961 and 1971, beginning with the 23rd, which granted electors to the District of Columbia for presidential elections, and the 24th, prohibiting poll taxes in federal elections. Bayh, as chair of the Senate Judiciary Committee's Subcommittee on Constitutional Amendments, wrote both the 25th, providing for presidential succession, and the 26th, lowering the voting age to 18. And he sponsored and steered through passage in the House and Senate what was widely expected to become the 27th, the Equal Rights Amendment. He also championed a D.C. Representation Amendment, an Environmental Rights Amendment, and an amendment lowering the minimum age for the House to 22 and for the Senate to 27. And he celebrated and publicized the very idea of amendment by holding hearings on controversial, polarizing amendments on school prayer, busing, abortion, and much more. Senate Judiciary Committee Chair James Eastland, who opposed most of what Bai tried to get done, once confessed to him a grudging admiration. "Boy, you've got that abortion thing, you've got that prayer thing, you've got that busing thing. How do you survive all of that? Any one of those things could kill me at home." But Bai's most ambitious amendment, the abolition of the Electoral College, was also his greatest failure. Birch Bai, born in Terre Haute in 1928, spent summers on his grandparents' farm. As a kid, he won a tomato-growing competition. He played football. He was a boxing champion. He met his wife, the Oklahoman Marvella Hearn, in 1951 when they competed against one another in a speech competition. She won. They were married the next year. Bai liked to say, "She won the contest, and I won the girl." Elected to the Indiana legislature in 1954, he won his first term in the Senate in 1962, backed by an award-winning jingle that was played incessantly on every Hoosier's radio and television set. "Hey, look him over. He's my kind of guy. His first name is Birch. His last name is Bai." He was nearly the youngest member of the Senate. Friends called him B2. He'd sidle up to guys, grab them by the arm, and say, "Hiya, Tiger." B2 was keen to make his mark. The Senate Judiciary Committee had notionally established a subcommittee on constitutional amendments in 1947, but it hardly ever met and seems to have held only closed hearings. By the time Estes Kefauver became chair in 1955, the Subcommittee on Constitutional Amendments had become the graveyard where ideas for constitutional change went to die. That obscure outfit had conducted almost no really important business since the nation decided to repeal prohibition more than 3 decades ago, as the New York Times put it. The 1959 hearings where David J. Mays testified, for instance, had marked the end of the road for Herman Talmadge's Lost Amendment. Mays had agreed to testify not out of any notion that the hearings marked the start of a successful campaign for the amendment, but only in order to get a statement into the congressional record. Kefauver had undertaken only one serious initiative, the reform of the Electoral College, a project to which he more fully dedicated himself in the aftermath of the election of 1960, one of the closest in American history. John F. Kennedy won 49.72% of the popular vote to Richard M. Nixon's 49.55. The Electoral College result, 303 to 219, masked the narrowness of Kennedy's victory. The difference of fewer than 12,000 votes in a handful of states would have led to a different outcome. Kennedy won Illinois' winner-take-all 27 electoral votes, even though he defeated Nixon by fewer than 9,000 votes. And allegations of voter fraud in Chicago do not appear to have been unfounded. On top of all that, maverick electors in southern states cast their electoral votes for Harry F. Byrd. Defenders of the Electoral College are hard to find, Kefauver said, calling the Electoral College an outmoded relic, the result of a distrust of the people and conditions of geography and communications which no longer exist. Kefauver had held 7 days of hearings and issued a report on December 15, 1960. Hardly anyone disputed that change was not only necessary, but urgent. According to a poll of 254 heads of political science departments, almost 91% of them favor some constitutional amendment on the subject, his subcommittee reported. But Kefauver had become bogged down in a slew of proposed reforms, unable to sift them. Nearly all of the proposals on the table abolished the bizarre and antiquated role of the elector. If the Electoral College was to be retained, At the very least, its votes should be cast automatically by a clerk in the State House, say. 3 different solutions were proposed to avoid a minority president, a president who lost the popular vote but won the Electoral College vote. Replacing the winner-take-all vote in the states with a proportionate vote, replacing the statewide electoral vote with a district vote, and holding a direct national popular election. Kefauver had not been able to steer his subcommittee through this thicket. When Kefauver died suddenly in August 1963, Bai asked Eastland, as the head of the Judiciary Committee, for the post, pointing out that he was the only Democrat on the committee without a subcommittee chairmanship. Eastland had planned to kill the subcommittee, deeming it a mostly useless waste of money, and one subcommittee too many. But Bai convinced him not to. Eastland called him up. "Birch," he said, "I think you'll make a splendid chairman of the subcommittee on constitutional amendments." The New York Times read the appointment more cynically. It seemed a suitable place to put a young Hoosier who had flunked his bar exam the first time and had practiced law only a couple months before coming to Washington. Bai put it this way: "I found myself the keeper of the graveyard." Bai hadn't favored a direct national popular vote when he first took his seat in the Senate. He'd only gradually come around to the idea. And Eastland hadn't much opposed a direct national popular vote when he appointed Bai chair of the Subcommittee on Constitutional Amendments. But he came to believe that Bai had to be stopped. On September 23, 1970, during the third week of a Senate filibuster on the Electoral College Amendment, Bai pointed out that his amendment had been subject to more days of debate than any other constitutional amendment in the last century. And still, no date had been set for a vote. Bai announced, defying the Democratic Party leadership, that he would block all Senate business, effectively shutting down the Senate until a vote was held. Southern segregationists were Bai's chief opponents in this battle, but the NAACP was against abolishing the Electoral College too. This battle was by no means the only constitutional amendment battle of the 1960s and 70s, but it was one of the most consequential. Bai made a difference. Under his leadership, Congress passed the 25th and 26th Amendments, nearly abolished the Electoral College in 1970, and sent the Equal Rights Amendment to the states in 1972. But the era is more remarkable for the amendments that didn't pass than for those that did. Of the more than 11,000 amendments introduced into Congress between 1791 and 2024, roughly 5,300, nearly half, were introduced between 1953 and 1979. The growing size of Congress, along with a changed rule about co-sponsorship, accounts for some of this difference, but by no means does it account for all of it, and in any case, the number of representatives had been more or less stable since 1911. A record-breaking 775 amendments were proposed in the 91st Congress from 1969 to 1970. One of the most important, an environmental protection amendment, never even went to committee. And for all its dynamism, the Bai era marked the last flurry of constitutional amendment in American history. Bai would hold hearings on the Electoral College once more in 1977, but that year, the Subcommittee on Constitutional Amendments was dissolved, and amending the Constitution became, once again, no longer possible. The giant slept. The far right. During the era of the Warren Court, from 1953 to 1969, most calls for constitutional amendment were sounded by what had come to be called the far right, the array of anti-communists, conspiracy theorists, vigilance societies, and white supremacists who believed the Supreme Court, the presidency, the federal government, the United Nations, the university, and much else had been taken over by a worldwide communist conspiracy, and that at stake was the Constitution itself. The John Birch Society, founded in 1958, For America, We the People, and the Committee for Economic Freedom, for instance, all supported the repeal of the 16th Amendment under the banner of what they called the Liberty Amendment. The mimeographed newsletters of anti-communist vigilance societies comprised just one element in a vast ecosystem of ultra-conservative agitation, from Dan Smoot's televised broadcasts to the many radio programs aired across the country by and for conspiracy theorists and self-described constitutional patriots. Radically conservative ideas were spread by old-fashioned means, too, the U.S. Postal Service. One of the Birchers' chief activities was writing letters to members of Congress. A network of patriotic letter writers based in Pasadena and founded in 1958 as an outgrowth of the local John Birch Society chapter, flooded state and national legislators with letters accusing everyone from Eisenhower to the PTA of communist subversion. One of its leading campaigns was for the Liberty Amendment. Another was for the impeachment of Earl Warren. At the start of this era, the parties were not sorted either by ideology or by race. Roughly, the GOP was the party of business, and the Democratic Party was the party of labor. There were liberal Republicans and conservative Democrats. Black voters had inclined toward the GOP since the days of Abraham Lincoln. But by the end of the Warren era, the parties had begun to sort themselves out, chiefly over court decisions, especially those concerning civil rights, beginning with Brown v. Board of Education. First came the far right, then came the New Left. Conservative white Southerners left the Democratic Party for the GOP, and black voters became Democrats. In the 1970s, and especially after Roe v. Wade in 1973, the parties themselves would polarize, Democrats moving further to the left, and Republicans moving considerably further to the right. Once that polarization began, it would continue for decades. It's not surprising that it became more difficult to amend the Constitution once party sorting and polarization set in. It's virtually impossible to achieve the two-thirds supermajority requirements of Article 5 in a polarized House and Senate, and ratification in 3/4 of the states is essentially inconceivable under such conditions. But the difficulty of amending the Constitution also drove polarization. It was because of the insurmountable hurdle of Article 5 that with the failure of the Child Labor Amendment in the 1930s, liberals had sought constitutional change through the courts instead of by way of amendment. So did the Civil Rights Movement. Liberals were also enthralled not only to the prospect of exercising the power of the judiciary through carefully chosen appointments, but also to the ever-expanding power of the executive. The greater their successes, the stronger the backlash. The stronger the backlash, the greater the polarization. The greater the polarization, the greater the difficulty of amendment. The greater the difficulty of amendment, the greater the recourse to the courts. And then the wheel turned again. The emergence of a far right and its clamor for constitutional amendments posed challenges to both Democrats and Republicans. Beginning in the spring of 1961, the Kennedy administration, even while hoping that the far right would splinter the GOP, in the end it instead splintered the Democrats, sought means to diminish its influence. Out of a series of meetings and exchanges among Walter Reuther, head of the United Auto Workers, Reuther's two brothers, and Kennedy's Attorney General, Robert F. Kennedy, came a 24-page proposal known as the Reuther Memorandum. It made 4 recommendations: adding right-wing organizations to a list of subversive organizations, directing the FBI to investigate them, denying them federal tax exemptions, and using the FCC to get far-right broadcasters off the air by way of the Fairness Doctrine. The Kennedy administration, in fact, implemented the last 2 of these recommendations. Democratic strategists sought to depict these agitators as a lunatic fringe, and so, to a considerable extent, did Republicans. Robert Welch, head of the John Birch Society, believed both Eisenhower and his Secretary of State, John Foster Dulles, were communists. Bob Welch is, of course, nuts on the Eisenhower-Dulles business, William F. Buckley wrote to Arizona Senator Barry Goldwater in March 1961. But the Society has some very good people in it. Buckley was loath to disavow the Birchers, given their support, including financial support, for the agenda he advocated in the pages of the National Review. His own mother was a Bircher. Buckley also knew what kinds of attacks he'd be subjected to if he tried to distance the magazine from the Birchers and their infamous letter-writing campaigns. As you know, these idiots set off on a harebrained campaign to impeach Earl Warren, James Kilpatrick wrote to Buckley. The word got back to Welch that I thought the idea preposterous, whereupon he commanded all his faithful members to write Mr. Kilpatrick a letter, and by God, they all did. The first 20 or so I answered with individual letters. The next 100 we answered with a mimeographed reply. The next 400 we filed. Calls to impeach Warren and the heightened public interest in the personnel on the bench had consequences. Beginning in 1955, nominees to the Supreme Court regularly appeared before the Senate Judiciary Committee, where their confirmation, once routine, would by the end of the 1960s become the subject of heated dispute. In April 1961, as the Kennedy administration was considering the Reuther Memorandum, Buckley published an editorial in the National Review, gently denouncing Welch. The point has come, if Mr. Welch is right, to leave the typewriter, the lectern, and the radio microphone and look instead to one's rifles, Buckley wrote, insisting that Mr. Welch was not right and that one could still argue policy positions and do things like write gentle editorials. In this piece and others, Buckley stopped well short of denouncing the Birch Society itself, whose members he continued to court. Instead, he blamed the press for opportunizing on the mistaken conclusions of Robert Welch to anathematize the entire right wing. Meanwhile, a more respectable organization had emerged to advance what was increasingly called constitutional conservatism. Americans for Constitutional Action, a conservative counterpart to Americans for Democratic Action. The ADA had been formed in 1947 by Eleanor Roosevelt, John Kenneth Galbraith, Walter Reuther, Arthur Schlesinger Jr., and Reinhold Niebuhr, among others, for the purpose of preserving and extending the New Deal. The ACA, founded in 1958, sought to elect more constitutional conservatives to Congress. Its conservatism was indeed the conservatism of the far right. Its founder, for instance, did not believe the 14th Amendment had been properly ratified. The ACA was also a successor to the Campaign for the 48 States, which, at its dissolution in 1959, turned over the balance of its funds to the ACA. Dedicated to the preservation of the spirit and principles of the Declaration of Independence and the Constitution of the United States, as these were enunciated and promulgated by the founders of our republic, the ACA established a rating system, the ACA Index, again in answer to a method used by the ADA, ranking each member for their adherence or lack thereof to conservative constitutionalism. Dan Smoot reprinted the ACA Index in his weekly newsletter. In one ACA rating of U.S. senators in 1960, for instance, for private ownership and against government ownership, John F. Kennedy and Lyndon B. Johnson rated 0, while Barry Goldwater and Harry Byrd both rated 100, and Strom Thurmond 75. In the spring of 1963, as a National Draft Goldwater Committee formed in Texas, urging the Arizona senator to enter the 1964 presidential race, Democrats decided to wage a campaign against the ACA. Both the far right and the possibility of a Goldwater bid for the presidency, which augured a possible conservative takeover of the Republican Party, were much in the news. Daniel Bell's The Radical Right appeared that year as an updated version of a collection he'd first edited in 1955. Richard Hofstadter revisited his earlier argument that the far right ought to be considered as essentially only pseudo-conservative on the argument that its concerns were not chiefly political, but a matter of cultural politics, by dwelling on how fundamentalism had recast itself as anti-communism. Yet he stood by his general description of the far right, that it tolerates no compromises, accepts no half measures, understands no defeats, and in that way exists outside the frame of normal democratic politics, which is largely an affair of compromise. Also in 1963, there appeared The Far Right, an investigative report by Bernard Eisman of CBS and Donald Jansen of the New York Times. Eisman and Jansen brought a storm down on the Kennedy administration by publishing parts of the Reuther Memorandum, which had been leaked to them. Kennedy sought to redirect attention to the far-right organizations themselves. In May 1963, Kennedy held a press conference, mainly to talk about the situation in Birmingham, Alabama, where Martin Luther King Jr. had been arrested and thousands of school children were marching in the streets, protesting the segregation of the schools, and met with a brutal assault by police deploying dogs and fire hoses. Much of it had been broadcast on television. "We have waited for more than 340 years for our God-given and constitutional rights," King wrote from the Birmingham jail. "The nations of Asia and Africa are moving with jet-like speed toward the goal of political independence, and we still creep at a horse and buggy pace toward the gaining of a cup of coffee at a lunch counter." There would be no more waiting. The Children's Crusade would change the course of the civil rights movement. It would lead Kennedy, weeks later, to address the American people on live television, calling for support for civil rights legislation. "The time has come for the nation to fulfill its promise," Kennedy said. "The events in Birmingham and elsewhere have so increased the cries for equality that no city or state or legislative body can prudently choose to ignore them." At that press conference in May, though, reporters asked Kennedy about something else. "Mr. President, you've spoken out before against the dangers of the so-called radical right in politics," began one reporter. "Could you update those observations today in view of the fact that a dozen states or so, influenced in part by extremist groups, have given varying degrees of approval to legislation which would change the form of amending the federal Constitution and would undercut the powers of the Supreme Court as well?" Since 1954, 8 states, Georgia, Idaho, Illinois, Indiana, Michigan, Missouri, South Dakota, and Texas, had petitioned Congress for a revision of Article 5, and 4 states, Alabama, Arkansas, Florida, and Georgia, had called for a constitutional amendment countering the power of the Supreme Court. "It has always seemed to me remarkable that those people and organizations who are founded in order to defend the Constitution should seek to change it," Kennedy answered. Notably, he did not name any of those extremist groups. But weeks later, the House took up the question and named names when California Congressman Ronald B. Cameron, a lawyer and former Marine representing Los Angeles County, rose to speak. In 1962, Cameron, a Democrat, had earned his seat by defeating the incumbent Republican John Rousselot, who then went on to serve as a regional director for the John Birch Society. Cameron had won, but nationally 100 of the 150 candidates supported by the ACA prevailed in the 1962 midterm elections, and in California, Birchers nixed Richard Nixon's gubernatorial campaign. Cameron charged that the ACA was attempting to clothe itself and the John Birch Society with an aura of respectability by holding a gala in Washington at which more than 150 members of Congress were to receive distinguished service awards honoring their constitutional conservatism. Pointing out overlapping leadership and membership and funders, Cameron charged that the ACA was simply the John Birch Society by another name. A phalanx of congressmen rose to add to Cameron's evidence, blaming the lunatic fringe of the far right for giving conservatism a bad name. "Your ACA rating is not entirely, but to a large degree, your Birch rating," said Morris Udall, in remarks that also suggested the extent of conservative organizing. Most of his mail, Udall said, concerned the impeachment of Chief Justice Warren, getting out of the United Nations, communists and homosexuals in the State Department, and so forth. Cameron also pointed out that among the amendments endorsed by the campaign for the 48 states was a reform of the Electoral College, a reform that Cameron charged was designed to weaken the voting power of urban areas, in other words, to suppress the influence of black voters. This was the Munt-Codert Amendment, which proposed to replace winner-take-all Electoral College voting with a district system. Outside the far right, it had very little support. But the idea that the Electoral College reform was part of a conspiracy designed to suppress the black vote would one day come to haunt Birch Bayh's graveyard. One heartbeat, one vote. Bayh's chairmanship of the Subcommittee on Constitutional Amendments began on September 30th, 1963. Less than 2 months later, John F. Kennedy was assassinated. Johnson was sworn in as president, but the nation no longer had a vice president. Bayh set to work on what became the 25th Amendment to resolve the problem of what process is to be followed if a president needs to be replaced and who is to determine when a sitting president is no longer capable of holding office. He also wrote a book about it, One Heartbeat Away, the only insider's account of the history of a constitutional amendment during its arduous travels through the House, the Senate, and the states. There had been plenty of problems with presidential disability and succession in the past. President William Henry Harrison died in office in 1841. Vice President Garrett Hobart in 1899. FDR in 1945. James Garfield lingered for nearly 80 days, barely conscious, after being shot in 1881. William McKinley lived for more than a week after being shot in 1901. Woodrow Wilson remained in office for 16 months after suffering a debilitating stroke in 1919. By the 1950s, there was also the fear that the president, his vice president, and possibly members of Congress might be killed in a nuclear attack. An amendment providing for presidential disability and succession had first been proposed by Dwight Eisenhower, who suffered a massive heart attack in 1955 and underwent 2 surgeries during his presidency. A poll conducted in 1957 reported that 64% of Americans favored such an amendment. But it was only after Kennedy's assassination, and the proposal first introduced into the Senate by Bayh on December 12, 1963, that Congress finally took up the matter in earnest. Shrewdly, Bayh enlisted the aid of the American Bar Association. By January 1964, he was able to open hearings on the issue in his subcommittee. Meanwhile, Johnson, on taking office, pledged himself to civil rights legislation. The Supreme Court's decision in Gray v. Sanders in March 1963 codified the idea of one person, one vote. The conception of political equality, from the Declaration of Independence to Lincoln's Gettysburg Address to the 15th, 17th, and 19th Amendments, can mean only one thing. One person, one vote, Justice William O. Douglas wrote in the 8-1 opinion in Gray v. Sanders, a decision that would also energize interest in abolishing the Electoral College in favor of a direct national popular vote. So did the court's next one-person, one-vote decision, handed down on June 15, 1964, in Reynolds v. Sims, requiring that both houses of a state legislature had to be equally apportioned by population. This led to a flurry of state constitutional conventions to address reapportionment and redistricting. Rhode Island, Connecticut, Tennessee, New Jersey, New Hampshire, New York, Maryland, Pennsylvania, Hawaii, New Mexico, Arkansas, and Illinois all held constitutional conventions between 1964 and 1970. More than 250,000 people marched on Washington in August 1963 to call on Congress to act on civil rights legislation. January 1964 saw the ratification of the 24th Amendment, prohibiting the poll taxes that had been a feature of the Jim Crow South since Reconstruction. But when the 1964 Civil Rights Bill got to the Senate, 18 Southerners staged a filibuster that lasted for 57 days. It was broken only by a cloture vote on June 10th. On June 19th, the day the Senate was scheduled to vote, Birch Bayh and Ted Kennedy were supposed to be speaking at the Massachusetts Democratic State Convention. They missed a planned flight to Springfield at 2 o'clock on the Kennedy's plane. They cast their votes, and the bill passed. Bayh and Kennedy, along with Marvella, the pilot, and a Kennedy aide, then boarded a twin-engine Aero Commander 680 at 7 p.m. 3 miles from the airport in western Massachusetts, the plane crashed into an apple orchard in a heavy fog. The pilot and Kennedy's aide died. but Bai pulled his wife out through a window and went back into the plane to rescue Kennedy, dragging him through a hole in the fuselage. Kennedy, who had a broken back and a collapsed lung, would remain in the hospital for months. By July, Bai had recovered enough to attend the signing ceremony, broadcast live on national television, as one of some 75 guests of the president. Johnson signed and then gave away pens as a memento. Robert F. Kennedy got 6 pens, Martin Luther King Jr. got 1. "This will remain among my most cherished possessions," King said. "I really should have got a bunch." Birch Bayh got 1. So did Ethel Payne. Weeks later, Senate Minority Leader Everett Dirksen introduced a constitutional amendment to overturn the one-person, one-vote principle by leaving the power to determine legislative apportionment to the states. Introduced twice more in 1965, with sizable numbers of co-sponsors, it failed to secure passage. Dirksen then led the most significant campaign to call for a constitutional convention since the call in the 1910s that had produced the 17th Amendment, a campaign that only grew in strength with the passage of the Voting Rights Act in 1965. By 1966, 28 states had petitioned Congress for a convention. By the start of 1967, 32 out of the required 34 states had joined this campaign. Dirksen also supported a constitutional amendment overturning 2 decisions of the Warren Court, one in 1962 and one in 1963, prohibiting prayer and Bible reading in public schools. Beginning just weeks after the first of these 2 decisions, members of Congress had introduced more than 300 proposed amendments constitutionalizing school prayer. "They put the Negroes in the schools, and now they've driven God out," said one Southern congressman. But the conflation of the 2 issues was inept. A school prayer amendment enjoyed widespread national support. Segregation did not. Goldwater, endorsing a school prayer amendment, made the matter an issue in his presidential campaign, and the GOP included it on its 1964 platform. More than 3 in 4 Americans supported a school prayer amendment, and members of Congress had also been flooded with mail from constituents, nearly all of it supporting a school prayer amendment. The quantity of congressional mail broke all records. But most churches and the National Council of Churches opposed an amendment. Bayh's pursuit of the Presidential Disability and Succession Amendment necessitated some horse trading over the prayer amendment. Charged with reconciling the differences between the House and Senate versions of the presidential amendment, he visited Dirksen's office to seek his support. He was seated in a chair next to a table on which had been placed, quite deliberately, stacks of postcards endorsing the prayer amendment. In exchange for Dirksen's support on the presidential amendment, Bayh agreed to hold hearings on the prayer amendment, which he himself did not support. "I thought I had committed political suicide," Bayh later said, but he came to believe, too, that holding the hearings had been a useful exercise in addressing a public concern and relieving the pressure on an issue. He may have been keeper of the graveyard, but it was an awfully busy graveyard, a place where Bayh presided over hearings for all manner of conservative amendments with which he disagreed. "I had to sit there and keep a lid on," he later said, knowing that his colleagues were glad there was somebody willing to sit there and take the heat for that. They were glad he had wielded the spade and was willing to do the burying. They didn't want it out on the floor, where they'd all have to vote on it. Both the House and the Senate held hearings, but the prayer amendment never came to a vote in either house. The Presidential Disability and Succession Amendment, however, passed Congress in 1965 and was ratified in 1967. Bayh's deft handling of the process earned him a national reputation. But the defeat of the prayer amendment, along with Goldwater's loss to Johnson in 1964, only heightened the frustration of conservatives. The beginning, middle, and end of all constitutional inquiry. In March 1965, police outside Selma, Alabama, shot and killed a young black man during a voting rights protest. On March 7th, Bloody Sunday, 600 protesters trying to cross the Edmund Pettus Bridge into Selma were met by dozens of sheriff's deputies and state troopers and posse men who attacked them with tear gas, billy clubs, and bullwhips, a confrontation broadcast on television that night. 1 week later, during a joint session of Congress, Johnson introduced a voting rights bill, also known as the Act to Enforce the 15th Amendment, that prohibited discrimination in voting by race or color, outlawed literacy tests, banned poll taxes in state elections — the 24th Amendment had prohibited poll taxes in national elections — and required states that had, as of 1964, applied tests or taxes for voters to get clearance from the federal government for any changes in their voting laws. In April, the National Review published a cover story by James Kilpatrick called "Must We Repeal the Constitution to Give the Negro the Vote?" The piece followed on a campaign waged by Mays and Kilpatrick's Virginia Commission on Constitutional Government that had argued that the 1964 Civil Rights Act was unconstitutional. A year later, Kilpatrick undertook to argue that the Voting Rights Bill was unconstitutional, too. While admitting that the South had been for a century engaged in willful defiance of the plain language of the 15th Amendment, he argued that the great bulk of Southern Negroes were and remained genuinely unqualified for the franchise. And in any event, determining qualifications and procedures for voting were powers reserved to the states. "It is possible to get at the evil with a scalpel instead of a cleaver," Kilpatrick wrote, urging a far narrower piece of legislation. Conservatives were on surer ground, or at least more democratic ground, when they contested Supreme Court decisions and damned a judicial oligarchy than when they questioned laws passed by Congress. By the mid-1960s, they increasingly raised those questions with reference to the intent of the framers, as had David Mays in his 1959 testimony before the Subcommittee on Constitutional Amendments under Kefauver. Kilpatrick often echoed Mays's arguments in opinion pieces and editorials, and in the foreword to a 1960 pamphlet titled, "Did the Court Interpret or Amend?" They had amended. Hammered home by Birchers and segregationists, states' writers, and constitutional conservatives, this position had become, by 1964, the position of the Republican candidate for president, Barry Goldwater, who in 1960 had written that the 14th Amendment was not intended to and therefore did not outlaw racially separate schools. Dan Smoot emerged as David Mays's most dedicated popularizer. "No court can validly consider such questions as whether the law would be good or bad for the country, or whether the people seem to want or not want the law," Smoot wrote in 1965. Instead, the courts can consider only what the constitutional provision in question meant at the time it was written and adopted to the people who wrote and adopted it. They were restricted, that is, to the original intent of any provision, which must be determined by the original historical record of that provision. Smoot, in a move adopted by later originalists, made a list of what those original historical records were: the debates at the Constitutional Convention, the Federalist Papers, and the records of the state ratifying conventions, and for a constitutional amendment, the records of Congress and the state legislatures or conventions that debated that amendment. No other historical records mattered. Reference to these and only these sources was the only way to interpret the Constitution, Smoot argued, just as Article 5 was the only way to change the Constitution. But a far more perceptive commentator had recently emerged. In the fall of 1965, the 45-year-old New York-born political scientist Martin Diamond published an article in Public Interest called "Conservatives, Liberals, and the Constitution." Diamond had never finished college, having interrupted his studies to serve in the Second World War, but on his merits had been admitted to graduate school at the University of Chicago in 1950. Like many mid-century conservatives, Diamond had made a long political journey from left to right. He'd been a member of the American Socialist Party from 1937 to 1952, but his 1956 dissertation was at once a disavowal of socialism and an explanation of its decline in the United States, which he attributed to American constitutionalism, especially federalism, American democracy, and American prosperity. The average American has always been only 40 acres or a generation away from the middle class. Diamond liked to joke that Americans were driven by, in the words of a country song, faster horses, older whiskey, younger women, and more money. At Chicago, Diamond fell under the influence of the German émigré Leo Strauss, a political philosopher who rejected modernity and called for a return to classical political ideas. It was Strauss who drew Diamond away from socialism. Diamond brought to Straussianism the same fervor he had brought to socialism. In particular, he applied Straussianism to American constitutionalism, calling for a return to the ideas and the original intentions of the framers. American Straussians were the original originalists. Yet, despite the Straussians' contribution to history, they are not in fact historians, as the historian Gordon Wood once remarked. They are not really concerned with the way historians understand the past. They are usually interested, for example, in only a few documents of the late 18th century, the Declaration of Independence, the Constitution, the Convention debates. They have no conception of the process of history. Diamond dedicated himself to a Straussian reading of the Constitution. One of his first major essays appeared in 1959. In Democracy and the Federalist, a reconsideration of the framers' intent, Diamond set about dismantling Charles Beard's 1913 and economic interpretation of the Constitution. Against Beard's reading of the framers as having been motivated by economic self-interest, Diamond argued that in Madison's conception of the Constitution, the struggle of classes is to be replaced by a struggle of interests. That is to say, the framers intended for the Constitution to thwart class struggle by providing for democratic expression of the political will in the form of deliberative majorities moderated through specific mechanisms, the separation of powers, bicameralism, federalism, the Supreme Court, and the Electoral College. Refuting Beard and other progressive-era historians, Diamond countered the charge that the amending process was undemocratic. Everyone is familiar with the arithmetic which shows that a remarkably small minority could prevent passage of a constitutional amendment supported by an overwhelming majority of the people. But turning that arithmetic around, he argued that the object of Article 5's structure was not at all to give power to minorities, but to ensure that passage of an amendment would require a nationally distributed majority, though one that legally could consist of a bare numerical majority. Diamond's Conservatives, Liberals, and the Constitution can be read as a reply to Kilpatrick's "Must we repeal the Constitution to give the Negroes the vote?" Diamond observed that conservatives and liberals appeared to be moving toward opposite poles, conservatives cloaking themselves in constitutionalism and liberals in democracy, without realizing that this tension was both fundamental to a constitutional democracy and productive. The liberal is the intelligent foe of the Constitution, and the conservative its foolish partisan, Diamond wrote. Given the dominance of either, the Constitution would perish. But neither fully understood the Constitution, and both seemed to have forgotten that their own positions were unstable. He pointed out, for instance, that while conservatives had very strongly favored judicial review in the 1930s, they did not like it in the 1950s and 60s, while for liberals the opposite was true, and that this fickleness also applied to their appetite for constitutional amendment. Liberalism long sought to evade a conservative court and the frustrating Constitution by trying to substitute the methods of direct democracy, initiative, referendum, recall, abolition of the Electoral College, legislation by amendment, Diamond wrote. Now it is the conservatives' turn. It is they who are now restive regarding the Electoral College and who have introduced a spate of largely ill-considered constitutional amendments. He also rightly predicted that the tables would turn once again were the court to become conservative. But if Martin Diamond offered a careful and concerned account of the widening distance between liberals and conservatives, less nuanced commentators reached a different public with coarser accounts. These included Alfred Avens, a rogue political scientist and oppositional legal scholar. Avens, born in 1934, had studied at CUNY, Columbia, and the University of Chicago. He held many jobs for a very short time, from Rutgers to Memphis State. Numerous law schools will not consider me for a teaching post because of my race relations views, he wrote to Buckley. I admire your courage, Buckley wrote back. But the defining intellectual commitment of Avens's life was his opposition to the court's decision in Brown v. Board of Education as an incorrect reading of history. Beginning in the late 1950s, Avens set for himself the task of recovering the original intent and understanding of the 14th Amendment in order to argue against the Warren Court and against civil rights more broadly. He opposed civil rights legislation as special rights for Negroes and objected to integration as a violation of the right of the individual to choose to associate or decline to associate based on ethnic grounds. In 1965, when he was barely 30, Avens had captured the attention of conservatives for his denunciation of civil rights legislation as unconstitutional. The beginning, middle, and end of all constitutional inquiry is the original intent of the framers, Avens wrote Buckley, a statement he used again early in 1966 when he appeared before the Supreme Court to argue that a New York law requiring an English language literacy test for Puerto Rican immigrants, notwithstanding the Voting Rights Act, was constitutional. The 14th Amendment covers only what were known in 1866 as civil rights and not political rights at all, Avens told the court, after Chief Justice Warren introduced him as Mr. Avens, whatever. Avens insisted that the court can't chop up the 14th Amendment and make a tossed green salad out of it because it doesn't like the original recipe. If it doesn't like the original recipe, it's got to get a new recipe. The way you get a new recipe is Article 5. Mr. Avens did not prevail. The New York law was overturned. Beginning in 1966, Avens published a series of law review articles with the subtitle, The Original Understanding. In each, disagreeing with Alexander Bickle's influential analysis, he purported to demonstrate that members of the 39th Congress would have opposed the decisions of the Warren Court. And so, for instance, he defended whites-only clubs. A law compelling a private club not to discriminate, far from being an enforcement of the 14th Amendment as originally understood, is a violation of this amendment as originally intended by its framers, for it constitutes the taking of liberty without due process of law, Avens wrote. David J. Mays and James Kilpatrick, keen for the imprimatur of an academic authority, especially one from the North, for the Virginia Commission on Constitutional Government, arranged for Avens to edit a collection they wished to publish. With Avens as editor, the commission published a nearly 800-page volume of excerpts from the congressional record during debates over the Reconstruction Amendments. The book should look as neutral as possible, Avens wrote Mays, because once we lure them in with an interest in history, we can deliver the punch much more effectively. That punch was a sustained attack on integration. Published in 1967 and heavily advertised in the National Review, its preface, prepared by the Commission, stated that its belief in the absolute necessity for adherence to the will of the governed as announced in the Constitution leads it to the further belief that such result can only obtain by interpreting every portion of the Constitution, including the amendments thereto, in accordance with the intent and understanding of the framers. The founder of Americans for Constitutional Action wrote Avens a fan letter. In 1967, when Lyndon Johnson nominated Thurgood Marshall to the court, Avens was working as staff for Strom Thurmond, who later praised him as probably the greatest living authority on the legislative history of the so-called Reconstruction Amendments. Avens prepared a list of 60 questions for Thurmond to pose to Marshall, whose purpose was to show how ignorant he is of the legislative history of the 13th, 14th, and 15th Amendments. Thurmond questioned Marshall for more than an hour, administering a constitutional history exam riddled with arcana. Thurmond: What is the significance, if there is any in your view, in the interpretation of the 13th Amendment that it was first rejected by the House of Representatives, which did not have a two-thirds Republican majority, and finally proposed only because of a switch of votes of a group of Union Democrats? Marshall: I am not familiar with whether the facts are correct, and I have no opinion on it. Thurmond's exam continued. each question more obscure than the last. Thurmond. What theories were then current in the Republican Party which gave support to the position that the Civil Rights Act of 1866 could be constitutionally passed by Congress to enforce the Privileges and Immunities Clause of Article 4, Section 2 of the original Constitution? Marshall. I don't remember. Thurmond. Of what significance do you believe it is that in deciding the constitutional basis of the Civil Rights Act of 1866, Congress copied the enforcement provisions of this legislation from the Fugitive Slave Law of 1850? Marshall. Senator, I just don't remember those debates, which were very voluminous, and I have not looked at them and have not researched that point since either 1953 or 1954. I have not been called upon to do so. Evans was pleased. Marshall, as I expected, was utterly ignorant, he wrote to David J. Mays. This made him look pretty stupid. In the same letter to Mays, Evans endorsed the idea of deporting to Africa discontented American blacks who participated in riots. Of course, the first sentence of the 14th Amendment makes them all citizens, he admitted, but the need to relocate them may give rise to a redetermination of the validity of the amendment itself. Before closing, the senator had posed several of Evans's questions on constitutional interpretation. Thurmond. Do you believe that the Supreme Court is bound, in construing the Constitution, to refrain from amending it in the guise of interpreting it? Marshall. I agree. Thurmond. Do you agree that if the Constitution was intended by the framers, those that wrote it, to mean one thing, the Supreme Court is not entitled to hold that it means something else? Marshall. I would say I am in general agreement with that statement. But what if they did? Thurmond wanted to know. What if the justices knew the Constitution meant one thing, but decided it meant something else? Marshall said he could not believe the justices would ever do that, but if they did, the only recourse would be a constitutional amendment. Sam Ervin interrogated him along the same lines. Is it not the role of the Supreme Court simply to ascertain and give effect to the intent of the framers of this Constitution and the people who ratified the Constitution? Yes, Senator, Marshall answered, with the understanding that the Constitution was meant to be a living document. Against the opposition of Southern senators, Marshall's nomination went to the full Senate, where, in an hour-long speech, Thurmond argued that Marshall was unqualified to sit on the court due to his lack of knowledge of the Constitution. Marshall was confirmed in the full Senate by a vote of 69 to 11. Top-tier law reviews routinely rejected Evans's submissions as bizarre. He went on to found 2 law schools, both of which were denied accreditation by the American Bar Association. His work on the 14th Amendment was almost universally derided by more established scholars who associated it with the far right. One reviewer of Evans's 1968 collection of debates over the Reconstruction Amendments accused him of selectively choosing excerpts to support his own positions, coming very close to charging Evans with academic fraud. Another reviewer concluded, the view that the Constitution must be construed according to the intent and understanding of the framers has been unkindly but accurately described as a filiopietistic notion that can have little place in the adjudicative process of the latter half of the 20th century, if indeed it ever did. And indeed, as a faithfully followed dogma, it never did. But for all the agitation over Brown v. Board and the civil rights legislation of the 1950s, the real challenge to written constitutionalism and the philosophy of amendment would be another case, Griswold v. Connecticut, from 1965, in which the Supreme Court struck down a state ban on contraception as unconstitutional. Griswold and the chain of cases that followed in its wake, especially Roe v. Wade, would become in the 1970s, for intent doctrine proponents, the new Brown. It would also come to stand for the court itself. By 2009, when asked to name a Supreme Court decision, an overwhelming 84% of those who could name a case named Roe. After a precipitous drop, the second most named case was Brown at 9%. The Anti-Civil Rights Amendment. Birch Bayh dedicated himself to abolishing the Electoral College in 1968, just after he decided to run for re-election, a decision that had been by no means obvious in the aftermath of the assassinations of Martin Luther King Jr. in April and of Robert F. Kennedy that June. In his campaign announcement, Bayh said he wanted to deal with America's unfinished business. That could have meant anything. But in August, speaking before the tumultuous and violent Democratic National Convention, he committed himself to putting an end to a constitutional menace, the danger of electing a president who has fewer votes than the fella he's running against. Turning to the Electoral College was a natural progression for Bayh after the 25th Amendment. Both concerned the peaceful transfer of power. In both cases, Bayh was drawing on decades of discontent with a system riddled with problems. As he liked to point out, Truman did in fact beat Dewey in 1948, but given the quirks of the Electoral College, a change of 30,000 votes in 3 states would have given the victory to Dewey. No one expected the 1968 election to be anything but a mess. After Minnesota Senator Eugene McCarthy, running as an anti-war candidate, challenged Johnson for the Democratic nomination, Johnson withdrew. The Southern segregationist George Wallace ran as a law and order independent. Bobby Kennedy was widely expected to best McCarthy, but after he was assassinated, Democratic Party leadership would all but hand the nomination to Vice President Hubert Humphrey at the convention, even though he had not entered a single primary. We're living in troubled times. We're living in a dangerous world where the stability of the United States of America is really the most important thing facing us, Bayh said at the convention. And we need to know that the president is the person elected by the people. Outside, thousands of anti-war activists had gathered. They'd been surrounded by police and riot gear. It's extremely important that when the President of the United States is elected, we know with confidence that he is the President of the United States. Bayh had held hearings on the Electoral College in his subcommittee in February 1966. As the hearings began, he rejected a direct national popular vote out of hand. Instead, he supported a narrow amendment, supported by Johnson, that would have closed off the possibility of a faithless elector by eliminating the role of the elector. After all, a state clerk could file a state's Electoral College vote. This measure had widespread support. Even the Virginia Commission on Constitutional Government found it unobjectionable. But by the close of the hearings, Bayh had changed his mind. He now supported a national popular vote as the only possible solution. He held hearings once again in 1967, this time inviting an MIT lawyer and engineer to present his alleged mathematical proof, calculated by computer, of the manifest unfairness of the Electoral College. Support for what came to be called the Bayh Amendment was not, at least at the start, a partisan affair. Republicans were deeply alarmed by the results of the 1968 election, in which votes for Wallace had nearly rendered an Electoral College win for Nixon impossible. Bayh opened new hearings on January 23, 1969, just as soon as the next session of Congress began. The House opened hearings only 2 weeks later. Bayh hoped to use the same strategy here that he'd use for presidential disability and succession. He sought the support of the American Bar Association. It obligingly formed a commission on Electoral College reform and published a report in which it assessed various narrower reforms. Calling the Electoral College archaic, undemocratic, complex, ambiguous, indirect, and dangerous, it strongly endorsed the reform that in a poll of more than 3,200 state legislators, more than 59% supported a direct national popular vote. Bayh's biggest problem at this point was the NAACP. Before the Civil War, the Electoral College had benefited slaveholding states. During the Jim Crow era, it had continued to benefit the South. In 1944, the South had only 12% of the nation's population, but more than 25% of its Electoral College vote. Blacks were typically barred from voting in the South, so this benefit did not accrue to them. Nevertheless, the NAACP had opposed proposals to abolish the Electoral College since at least 1950, when an amendment calling for the proportionate reform passed the Senate. Because of the Great Migration, the black population in the North, where blacks could vote, was clustered in cities in a fairly small number of states. In 1950, the executive secretary of the NAACP had written to both the Republican and Democratic leaders of the House to express opposition to the amendment. The purpose of this amendment is to destroy the effectiveness of the Negro vote in pivotal states, the association stated. In 1956, when the Senate was once again to vote on a proportionate amendment, the NAACP organized a national campaign to defeat it, dubbing it the Anti-Civil Rights Amendment. Roy Wilkins, executive secretary, telegrammed branches in the states with the largest black populations. Most urgent, you write or wire your senators to oppose Electoral College amendment due on Senate floor this week. Proposed amendment drafted in part by Daniel of Texas and Thurmond of South Carolina is designed to reduce power of Negro vote in northern states while increasing influence of southern states where Negroes have little vote. Americans for Democratic Action, too, had opposed the amendment, calling it a concerted effort to curb the political influence of liberal labor forces in the presidential nomination and election process. When the amendment came up for a vote in the Senate, it failed to achieve the two-thirds majority by 37 to 48, with 11 not voting. Of the 19 senators who signed the Southern Manifesto just months later, 17 had voted for the Electoral College amendment. For all that had changed between 1956 and 1966, including that after the 1965 Voting Rights Act, blacks now could vote in the South, the NAACP refused to alter its position on an Electoral College amendment. This opposition was a feature of a position long taken by the NAACP, which was to oppose virtually all constitutional amendment proposals as either direct assaults on racial equality or distractions likely to delay genuine and achievable reform. In the 1940s and 50s, the NAACP had opposed a constitutional amendment prohibiting the poll tax, the chief mechanism used to bar blacks from voting in the Jim Crow South, on two grounds: that it was merely a GOP ruse to court black voters without having to deliver anything, since ratification of such an amendment was impossible, and that pursuing a constitutional amendment to abolish poll taxes would interfere with abolishing poll taxes by statutory means. The NAACP's Roy Wilkins held on to this position even in 1962, when the poll tax amendment was making its way through Congress. Kefauver wrote to Wilkins to try to disabuse him of his impression that ratification was impossible, that the process would bury the proposal in state legislatures for the next 40 years, by pointing out that the 23rd Amendment had just been ratified, and very quickly. But Wilkins was unmoved. By the mid-1960s, when the NAACP and other civil rights organizations were busy fighting proposed constitutional amendments that included Dirkson's campaign to overturn reapportionment and a proposal to make amending the Constitution easier, they dug in their heels against the abolition of the Electoral College. At its annual meeting in 1967, the NAACP formally supported LBJ's modest amendment, the elimination of the faithless elector, but strongly and unalterably opposed any proportionate or direct popular vote plan, objecting to any change that will divide electoral votes in the states in accordance with the percentage of support received by the candidates. The American Bar Association pleaded with the NAACP to change its position, arguing that over time a program of direct election of the president would be highly advantageous to the Negro community. By 1969, the reform had also earned the support of the National Municipal League, which also tried to convince the NAACP to reassess its position, to no avail. Yet the NAACP's objections could not alone have thwarted the by-amendment's passage through the Senate. The greater obstacle was the decision of Southern senators to oppose a measure they had long supported, partly in an attempt to punish By for his opposition to Richard Nixon's Supreme Court nominees. Bye. Here come the judge. In May 1968, as part of his Southern strategy, Nixon had secured the support of Strom Thurmond and other Southern conservatives by promising to nominate a white Southerner to the Supreme Court. With Warren retiring, Johnson had proposed promoting the liberal justice Abe Fortas to the chief justiceship, but the Senate Judiciary Committee had objected, and a series of scandals reported in the press and the threat of impeachment led to Fortas's eventual resignation. Once Nixon took office, he nominated Minnesota Judge Warren Earl Burger. In the spring of 1969, the Senate confirmed the new Chief Justice 74-3, replacing Earl Warren with Warren Earl. In August, to replace Fortas, Nixon nominated Clement F. Haynesworth, Jr., a 56-year-old federal judge from South Carolina on the Fourth Circuit Court of Appeals. Bayh, meanwhile, had been attempting to work on the Electoral College Amendment. He opened hearings on the Electoral College in his subcommittee on January 23, 1969, 3 days after Nixon's inauguration. The House Judiciary Committee opened hearings on February 5th and soon voted 29-6 in favor of an amendment quite close to Bayh's. Inauspiciously, 4 of those opposed came from the South. In September 1969, the House passed the amendment in a bipartisan 338-70 vote, though 47 of those opposed were Southerners. In the midst of these developments, the Senate Judiciary Committee undertook to review Nixon's Supreme Court nominee. Haynesworth was strongly opposed by the very labor unions who were Bayh's staunchest supporters. Nixon had pledged to nominate a strict constructionist to the court, which was his way of thumbing his nose at the Warren Court. It also turned out that Haynesworth had insisted, as late as 1967, that the 14th Amendment did not prohibit segregation. Bayh, slowly and with some reluctance, undertook to lead the opposition against Haynesworth in the Senate Judiciary Committee. In terms of seniority, it didn't make much sense for him to be the man to carry the axe, but the 2 more senior Democrats on the committee were up for re-election. Ted Kennedy was reeling from Chappaquiddick, and as the New York Times put it, Bayh is a master of the gentlemanly shiv. Bayh sharpened his shiv. However fearful he was, according to his chief counsel on the Subcommittee on Constitutional Amendments, of damaging bipartisan relationships, essential to his most important objective, the passage of electoral reform, he proceeded all the same, gathering together a coalition of more than 100 labor, welfare, and civil rights organizations. Press scrutiny and investigations into Haynesworth conducted by Bayh's staff turned up allegations of ethical and financial impropriety, and especially his failure to recuse himself in cases involving his stock holdings and his directorship of corporations. "I didn't want to be against the guy," Bayh later said, describing it as the most distasteful thing I've ever had to do in the Senate. But he waged a relentless campaign against him, alleging that at least 4 times the judge had sat on cases involving cases in which he had a financial interest. Massachusetts Republican Edward W. Brooke, the first black U.S. senator elected since Reconstruction, broke ranks with his party to work with Bayh to defeat the nomination. Bayh's campaign against Haynesworth earned him a national spotlight. There was talk of presidential possibilities. By October 1969, Bayh's campaign had so eroded support for Haynesworth that the Washington Post urged Nixon to withdraw the nomination. Nixon refused. In November 1969, the Senate defeated the nomination 45-55, with 17 Republicans voting no. Nixon, apoplectic, directed his chief Southern strategist, Harry Dent Sr., to look farther south and further right. True to his word, in January 1970, Nixon nominated Fifth Circuit Judge G. Harold Carswell, a man Bayh believed was not worthy of carrying Clement Haynesworth's briefcase. Born in Georgia, Carswell had moved to Florida in 1949. Eisenhower had appointed him to the federal bench in 1958, and Nixon had placed him on the Fifth Circuit Court of Appeals in 1969. Haynesworth had committed ethical improprieties. Carswell was a dogged segregationist. The NAACP alleged that on his bench, his record was tainted by racial bias, especially in his treatment of black lawyers. In private life, he had advocated for a whites-only golf club and imposed a racially restrictive covenant when he sold his house. A month before Nixon nominated him to the Supreme Court, Carswell had told this joke at a meeting of the Georgia Bar Association. I was out in the Far East a little while ago, and I ran into a dark-skinned fella. I asked him if he was from Indochina, and he said, "Nah, sir, I's from outo Georgia." The head of the AFL-CIO called his nomination a slap in the face to the nation's Negro citizens. Carswell was also a slovenly thinker and a weak and slow writer, whose opinions, as Bai's staff eventually discovered, had been overturned by higher courts more often than they were upheld. The chances of defeating a second Nixon nomination seemed slim, and few in the Senate were eager to take on the fight. Bai wanted above all to get his Electoral College amendment passed, but he had amassed tactics and ties in the campaign against Hainsworth. In a meeting in his office with aides and supporters where Bai said there was no stomach left for another battle, no one wanted to take this on. Carswell had made a speech in 1948 when, at 29, he was running for a seat in the Georgia legislature, in which he had said, "I yield to no man in the firm, vigorous belief in the principles of white supremacy, and I shall always be so governed." When Bai went around the room for comments, most people seemed to think it wasn't worthwhile or even fair to hold someone to account for something he'd said at 29 in what was arguably a very different America. Clarence Mitchell, executive director of the NAACP, was nearly the last to speak. "Gentlemen," he said, "I respect where you're all coming from, but in my lifetime of experience, I found that once a person ever feels that way, they never, ever really change their mind." Bai agreed to lead the campaign to defeat Carswell. The Senate Judiciary Committee held 5 days of hearings beginning on January 27, 1970. Feminist organizations, including the National Organization for Women, opposed Carswell's nomination, mostly on the grounds of his court's refusal to rehear a case involving a woman who alleged that she had been denied a job because she had young children. Hawaii Democratic Congresswoman Patsy Matsu Takemoto Mink called his nomination an affront to the women of America. Mink charged the judge with a lack of sensitivity for women's struggle for equality. And all 9 black members of the House opposed the nomination. Michigan Democrat John Conyers, speaking on their behalf before the Senate Judiciary Committee, said, "I am here to prevail upon you to establish the basic principle that any person of a racist or segregationist persuasion is per se unqualified to serve on the Supreme Court." In a letter placed into the record by Bai, 457 lawyers stated that aside from the judge's record of white supremacy and ugly racism, he does not have the legal or mental qualifications essential for service on the Supreme Court or any high court in the land, including the one where he now sits. All this while, Bai was trying to plot a strategy to get his Electoral College amendment onto the Senate floor. On February 3rd, he made a motion to tie a vote on Carswell to a vote on the Electoral College amendment. Strom Thurmond opposed the motion. "The enemies Bai made in the Hainsworth fight may unify to thwart him on this," the New York Times observed in a long profile the next week, commenting on the possibility of a Bai presidential bid in 1972. But Bai said he was tired of getting the old shaft, and he was finished being a nice guy. He threatened to filibuster any vote on Carswell until the committee agreed on a date for a Senate vote on the Electoral College amendment. The committee voted 10-2 to bring the Electoral College amendment to the full Senate for a vote by April 24th, and it voted 13-4 to send the nomination to the Senate. Bai and 3 other Democrats voted against. During the Senate debate, which lasted nearly a month, Ed Brooke again opposed Nixon's nominee. "I cannot in good conscience support confirmation of a man who has created such fundamental doubts about his dedication to human rights," Brooke said. Bai called Carswell incredibly undistinguished and read from Carswell's 1948 speech. What likely really doomed the nomination was a remark made by one of his supporters, Nebraska Senator Roman Rushka. "Even if he was mediocre, there are a lot of mediocre judges and people and lawyers," Rushka said. "They are entitled to a little representation, aren't they? And a little chance? We can't have all Brandeises and Cardozos and Frankfurters and stuff like that there." On April 8th, the Senate defeated the nomination 45-51. Nixon then said, in a speech written by Pat Buchanan, "I have reluctantly concluded that it is not possible to get confirmation for a judge on the Supreme Court of any man who believes in the strict construction of the Constitution, as I do, if he happens to be from the South." He vowed not to nominate another Southerner. Days later, Carswell resigned from the bench and ran for the U.S. Senate. Supporters printed bumper stickers that read, "Bye, bye, bye, here come the judge." Carswell never made it to the Senate. He lost in November. Whatever support Bye had among Southerners in the Senate for abolishing the Electoral College began to wither in the face of the defeat of Nixon's two nominees. In May 1969, the Subcommittee on Constitutional Amendments voted 6-5 against his proposal, with 3 Southerners voting no, and instead favoring a district plan. In the Senate Judiciary Committee, Eastland delayed consideration of the proposal, and Thurmond threatened to filibuster any vote in the Senate. Only Bye's threat to filibuster a vote on the Carswell nomination had secured the promise of a full Senate vote. The Judiciary Committee voted 11-6 in favor of Bye's amendment, but in a minority report, 4 Southerners, Eastland, Irvin, Thurmond, and Arkansas Senator John McClellan, warned that abolishing the Electoral College would endanger minority rights. "The Electoral College is one of the South's few remaining political safeguards," wrote Alabama Senator James Allen in October 1969. "Let's keep it." And they did. An Indian Manifesto. In 1965, the Standing Rock Sioux activist Vine Deloria, Jr. went to Washington to meet with members of the Senate Judiciary Committee, including Birch Bayh. Deloria had thick, dark hair, horn-rimmed glasses, and an eviscerating wit. No 20th century Native American would be more important in restructuring the constitutional relationship of indigenous peoples and the federal government. Born in 1933 in South Dakota, just outside the reservation of the Pine Ridge Oglala Sioux, Deloria served in the Marines in the Korean War, studied at Iowa State and at Illinois' Lutheran School of Theology, and then, only 30, became the head of the National Congress of American Indians. He was a theologian and a scholar, an intellectual and a politician, a revolutionary, and a constitutionalist. "This organization I run is kind of a miniature United Nations, with everybody taking his shoe off and hammering on the desk," Deloria explained to the Senate Judiciary Committee's Subcommittee on Constitutional Rights in June 1965. That was his way of making sure the senators didn't lump all Native peoples together. In the 1960s, when Birch Bayh chaired the Judiciary Committee's Subcommittee on Constitutional Amendments, Sam Ervin chaired the Subcommittee on Constitutional Rights, which in 1965 held hearings and prepared a report on Indian tribes and the Constitution. Ervin served on Bayh's committee, and Bayh served on Ervin's. Their work on Indian tribes and the Constitution did not involve proposing a formal constitutional amendment, nor did it have much in common with the Supreme Court-centered litigation strategy of the civil rights movement. Indian problems aren't civil rights problems, as Helen Peterson, Deloria's predecessor as head of the NCAI, pointed out in 1957, and integration, Peterson warned, was a form of assimilation likely to wipe out tribes which 50 years from now we will be trying to resurrect. But the Indian rights movement of the 1960s and 70s would nevertheless radically shape Americans' ideas about the Constitution, as well as American Indians' amending of their own constitutions. As the legal scholar Maggie Blackhawk of the Fond du Lac Band of Lake Superior, Ojibwe, has argued, Native advocacy before Congress created a distinctive kind of constitutionalism, legislative constitutionalism. After allotment, after the Indian New Deal, after termination came, in June 1961, a Declaration of Indian Purpose, the result of a meeting of more than 400 delegates from 90 tribes at the University of Chicago. The declaration, in tepid and obliging language, asked the federal government to abandon the termination policy and reorganize the Bureau of Indian Affairs to better provide services to recognized tribes. Younger Indians considered the document an example of appealing to the great white father again, as Clyde warrior Ponca later said. Really, we like you, Big Daddy. Keep sending us things. That summer, they founded the National Indian Youth Council. Indian activists didn't share the same goals as civil rights activists, but given the monumental legislative gains of the 1964 Civil Rights Act and the 1965 Voting Rights Act, younger Indian activists decided to borrow from the civil rights movement's vocabulary and strategies. And so Deloria went to Washington, testifying before the House and Senate 8 times between 1965 and 1968. Senator Ervin's subcommittee had first turned to the matter of Indians' constitutional rights in 1961 in response to the Declaration of Indian Purpose. It had held hearings in Arizona, California, Colorado, Nevada, New Mexico, North Carolina, North Dakota, and South Dakota, meeting with representatives from 85 Indian tribes, and something of a reprise of the congresses that John Collier had held in 1934. The subcommittee had drawn up a legislative package of 9 bills, including a bill to protect the constitutional rights of American Indians, essentially extending the U.S. Bill of Rights to Indians, sponsored by Ervin and Bai, that attempted to draw a line between tribal and federal jurisdiction in matters of constitutional rights. Appearing before the subcommittee in 1965, Deloria offered lukewarm support to the legislative package, but he had a much bigger claim to make, a claim essentially about Indian law and unwritten constitutions. What is the tendency among Indian tribes to alter and amend their tribal customs and traditions to meet the changing needs of a more modern society? One senator asked him. Deloria insisted that tribal governments were not vestiges of the past, but laboratories of the future. Ervin, in 1968, attached an Indian civil rights bill as an amendment to the Fair Housing Act. Deloria suspected Ervin of using Indian rights to kill fair housing. But if that was Ervin's plan, it backfired. Both passed. The Indian Civil Rights Bill incorporated modified versions of the First through Eighth Amendments to the U.S. Constitution into tribal governments. As Deloria would argue, the imposition of a constitutional order based on individual rights as a protection against government was a poor fit for Native societies based on mutual ties and obligations of community. Deloria's critique of the kind of constitutionalism the U.S. government wanted Native tribes to adopt led him in 1967 to begin studying law at the University of Colorado. In 1969, he published a blockbuster book, Custer Died for Your Sins, an Indian Manifesto. Part history, part philosophy, Deloria's book made a series of central arguments about the consequences of centuries of broken treaties, swindling, and betrayals that characterized the federal government's relationship with Indians, with the result that, as he wrote, under the laws and courts of the present, there is no way for Indian people to get the federal government to admit they have rights. The year Deloria's manifesto came out, 79 members of an organization called Indians of All Tribes began a 19-month-long occupation of Alcatraz, claiming possession under the terms of a treaty from 1868, issuing a proclamation that began, "We, the Native Americans, reclaim the land known as Alcatraz Island in the name of all American Indians by right of discovery." As Deloria would remark, in 1969, non-Indians began to rediscover Indians. The nation had been beset by political violence, police brutality, race riots, political assassinations, the growing militancy of the anti-war movement. Under these circumstances, Deloria pointed out, Indians seemed to be everyone's favorite cause. Conservatives embraced us because we didn't act uppity, refused to move into their neighborhoods, and didn't march in their streets, he wrote, with his characteristic acerbity. Liberals loved us because we were the most oppressed of all the people who had ever been oppressed, and besides, we generally voted Democratic. Deloria, who graduated from law school in 1970, became a constitutional theorist, publishing in 1974 the book Behind the Trail of Broken Treaties, an Indian Declaration of Independence, which examined a 1972 demand for a nation-to-nation constitutional order, the 20 Points position paper, which had been principally drafted by Hank Adams of the Assiniboine Sioux. He also brought a new voice and a decidedly different vantage point to the deepening critique of the Constitution that had become prevalent, in quite different ways, on both left and right. In October 1969, McGeorge Bundy, a professor of government at Harvard who had served as national security advisor in the Kennedy and Johnson administrations and had been a chief architect of U.S. involvement in the Vietnam War, delivered an address at Mount Holyoke College in Massachusetts, in which he described the divisions in the United States as sharper, more bitter, more violent, and even perhaps more dangerous than anything we have known since the Civil War. Bundy made a prediction. It is not unthinkable that this country may need a new constitution. Deloria used Bundy's speech as a jumping-off point for a remarkable treatise on the new Constitution. The U.S. Constitution was founded to protect property and had been revised to protect rights, Deloria argued. But either way, it rested on a commitment to individualism and yet understood people of color only as groups: Indians, blacks, Mexicans, Chinese. We have never had a peoplehood in this country because we have always been tied to a barren conception of man, he wrote. He didn't think a new constitution was necessary, but he did think that we the people ought to be reread to mean we the peoples. Deloria and other Native activists had an uneasy relationship with a growing environmental movement that at the time was seeking to amend the U.S. Constitution and state constitutions. The modern environmental movement began in 1962 when Rachel Carson published Silent Spring. Its uneasy relationship with Indians had to do with environmentalists' tendency to romanticize them while failing in any meaningful way to act as political allies. In June 1969, the massively polluted Cuyahoga River in Cleveland caught fire. Deloria related a story about a non-Indian who told him he was really sorry about what had happened to Indians, but it was for the best because whites had better ideas about what to do with the land. After giving that notion some consideration, Deloria wrote, he decided it was probably right, because after all, how many Indians could have thought of creating an inflammable river? Our peace with nature. The environmental movement did not succeed in amending the U.S. Constitution, though it had some success in the states. But it did inaugurate a new chapter in the idea of amendment as improvement. Environmentalists rejected the 20th century idea of progress as economic growth and technological innovation. But in the 1970s, they could conceive of no way to constitutionalize this critique except by seeking a constitutional right to a decent environment. On January 19, 1970, Wisconsin Senator Gaylord Nelson, the proud son of the little town of Clear Lake, introduced into Congress a proposed constitutional amendment to read, "Every person has the inalienable right to a decent environment." Nelson had dedicated himself to environmental protection both as governor of Wisconsin and since arriving in the Senate in 1962. In September 1969, 2 months after men from Earth landed on the moon, Nelson came up with the idea of Earth Day. Inspired by the teach-ins of the anti-war movement, he proposed a day of reflection, study, and action. He had bipartisan support. After the Cuyahoga River fire, Congress passed the National Environmental Policy Act, establishing the Environmental Protection Agency. And 3 days after Nelson called for a constitutional amendment, Nixon, in his 1970 State of the Union, ushered in the 1970s as the environmental decade. The great question of the decade, he said, was, shall we make our peace with nature and begin to make reparations for the damage we have done to our air, to our land, and to our water? Proponents of Earth Day challenged an 18th century idea of progress as moral improvement, a 19th century notion of progress as technological advance, and the 20th century's obsession with economic growth. Earth Day is a commitment to make life better, not just bigger and faster, read a full-page ad in the New York Times. It is a day to re-examine the ethic of individual progress at mankind's expense. It was not clear then, and it would not be clear a half-century later, whether this crucial commitment could be reconciled with the frame of government adopted in Philadelphia in 1787. The first Earth Day took place on April 22, 1970. It was the largest political protest in American history. 20 million Americans, 1 in every 10, marked the day in one way or another. The House and Senate adjourned for the day, governors all over the country declared it a holiday, school children went out into the woods and studied ecosystems, college students picked up trash, parts of New York City banned cars for the day. Protesters wore gas masks and surgical masks to draw attention to air pollution. In a speech in Washington, civil rights leader James Farmer tied the burgeoning environmental movement to racial justice. The garbage, the trash, the carbon monoxide, the junk, who suffers most from it if it is not the poor? And so the poor, especially the ghettoized poor, the black and the brown and the red, stand to benefit first from any successes in cleaning up the environment. In Albuquerque, Chicano activists made the same argument, tying together racial justice and environmental justice. We're going to make people understand that the kinds of things that come from air pollution and water pollution are the same kinds of things that cause racism, that cause poverty, and that cause hunger in this country, said one rallier. So we're all going to be marching today, okay? Unidos, marchemos, unidos, venceremos, viva raza, viva! Nelson, in a speech in Colorado, called on the 92nd Congress to operate as an ecology Congress. Our goal is not just an environment of clean air and water and scenic beauty, Nelson said. Our goal is a new American ethic that sets new standards of progress, emphasizing human dignity and well-being, rather than an endless parade of technology that produces more gadgets, more waste, more pollution. As for how to pay for it all, Nelson proposed ending the space program to fund environmental programs. The 92nd Congress did become the Ecology Congress, passing the Clean Water Act and the Clean Air Act. But it drew the line at amending the Constitution, which meant that future Congresses, or the Supreme Court, could roll back every one of these measures. Few constitutional amendments required a more radical restructuring of fundamental law than environmental amendments. Nelson's was not the first Environmental Protection Amendment, and his was not especially well drafted either, a problem that plagued many quixotic amendments. What is a decent environment? But while environmental protection and environmental rights provisions were becoming a feature of constitutions all over the world beginning in the 1960s and 70s, taking off after the 1972 Declaration of the United Nations Conference on the Human Environment, the United States has never adopted one. In this underdevelopment, as in so many other constitutional matters, American states more closely follow the model of national constitutions. In 1971, inspired by Nelson's proposed federal amendment, Pennsylvania became the first state to enact an Environmental Protection Amendment, guaranteeing a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. It was ratified in a popular referendum by a 4-1 margin. In the weeks and months and years after that first Earth Day, people from all over the country flooded Birch By's Senate office with letters and petitions endorsing Nelson's environmental amendment. A woman from Vicksburg, Michigan, wrote in to say she thought it was as important as any other right in the Bill of Rights. Adding this amendment to the Constitution, wrote a woman from Balch Springs, Texas, would be a greater wonder than landing on the moon. But that amendment, like the environmental movement itself, faced an army of opponents that included battalions of conservatives, black activists, and feminists. Despite the support of the Republican president, who supported environmental measures mainly to outflank Edmund Muskie, conservatives opposed it. The John Birch Society, noting that April 22, 1970, was Vladimir Lenin's 100th birthday, called the protests a communist plot. The National Review ridiculed the entire environmental movement as merely the latest new left fad. Fallout, civil rights, Vietnam, ghettos, hunger, poverty, they've lost their kicks, and something fresh must be added, its editorial page asserted. And anti-pollution has got everything it takes. As for Earth Day, the National Review described it as, exciting petition campaigns and civic assemblies to save the swamp, ban bangs, deter detergents, suppress sulfides, annul algae, muzzle monoxide, clobber corporations, you name it. Curiously, a half-century later, originalists would blame FDR for the failure of the Environmental Amendment in the 1970s, arguing that if he had not abandoned Article 5 as a method of constitutional change in 1937, the practice could not have languished, and Nelson would have succeeded. This is plainly a considerable rewriting of the historical record. The environmental agenda faced a still harsher criticism from civil rights activists, despite the endorsement of leaders like James Farmer. The reformist solutions tended by the current ecology movement emerge as somewhat ludicrous from the Black perspective, declared the Black sociologist Nathan Hare. The real solution to the environmental crisis is the decolonization of the Black race, defeating white supremacy. And in truth, the major environmental organizations with roots in wilderness conservation and land protection did not express much interest in social justice or what would later be called environmental justice. A 1971 survey of members of the Sierra Club asked whether the club should actively involve itself in the conservation problems of such special groups as the urban poor and the ethnic minorities. 41% strongly disagreed with the statement. Only 15% strongly agreed. Feminists certainly did not, as a bloc, object to an Environmental Protection Amendment, but they objected to giving it priority over an Equal Rights Amendment. They wanted the 92nd Congress to be the Gender Equality Congress. Birch Bayh supported Nelson's amendment, but Nelson made his push for hearings in Bayh's Subcommittee on Constitutional Amendments in the winter and spring of 1970, just when proponents of the Equal Rights Amendment were pressing for hearings on that amendment. They had protested in the hall outside his hearings on the Electoral College Amendment, and by the end of February, Bayh had announced that he would hold hearings on the ERA in May. Bayh's wife Marvella had been pressing him to hold those hearings for 5 years. They had every reason for high hopes. Bayh's subcommittee seemed to be getting things done. Bayh had succeeded with the 25th Amendment and seemed well on his way to succeeding with the 26th. Under pressure from the student anti-war movement, Congress had passed a law lowering the voting age from 21 to 18, but the Supreme Court declared that Congress had no power to change voting qualifications in state elections. By February 1971, Bayh's subcommittee had presented a report recommending what became the 26th Amendment. Urged on by the hope of squaring this away in time for the 1972 elections, both the House and Senate had passed the amendment that spring, and it had been ratified by summer, breaking all records for speed. This, however, would not be the fate of the Equal Rights Amendment or of the Electoral College Amendment. The fact that it is so old. Birch Bayh failed to get the Electoral College Amendment out of the Senate Judiciary Committee by just a handful of votes in 1969. Years later, after the agony of battles over amendments about abortion and equal rights, he tried one last time, only to confirm what he must have suspected, that the window for amending the Constitution had closed. What had given him a spark of hope was the closeness of the 1976 presidential election. Had 20,000 votes in Hawaii and Ohio gone the other way on Election Day that year, Gerald Ford would have been the elected president instead of Jimmy Carter. After watching the returns, Birch Bayh called Oklahoma Senator Henry Bellman, a fellow advocate of the direct national vote, to ask, "Henry, do you think we ought to give it another try?" On January 10, 1977, as soon as the 95th Congress began, Bayh, still in the Senate and still chair of the Subcommittee on Constitutional Amendments, introduced his Electoral College Amendment all over again. Carter's victory, Bayh told his colleagues, had been 0.01% of the popular vote closer than in 1960 and closer than in 1968. During hearings in the Judiciary Committee, the head of the League of Women Voters expressed a certain exasperation. "I admit to being somewhat hard-pressed to find something new to say on this subject," she said. In yet another kind of déjà vu, Bayh had a hard time getting the committee to hold a vote. Except this time the opposition came not from Southern segregationists, but from the new Reagan conservatives. Reagan, who had lost the Republican nomination to Ford, declared that the national popular vote would almost certainly result in presidential elections being decided by swing votes in a handful of the largest cities. Meanwhile, civil rights leaders, including Vernon Jordan, strange bedfellows to the likes of Strom Thurmond and Ronald Reagan, continued to insist that abolishing the Electoral College would do something quite the opposite by diluting black voting power in large northern states. In vain did Carl T. Rowan plead with his fellow black Americans to stop letting the foes of electoral progress hide behind the pretense that they are looking out for those poor black folk. In the summer of 1977, Birch Bayh held committee hearings. By now, Jimmy Carter had endorsed the amendment, and so had Gerald Ford, who had supported it since 1969. And so had Republican senators and presidential aspirants Howard Baker and Bob Dole. A February 1977 Gallup poll reported that Americans had favored a change to the Electoral College since 1948 and since 1966 had supported a direct popular vote. In 1977, a poll found that 73% of Americans favored Bayh's amendment, with only 15% opposed. Support crossed party lines, enjoying the favor of 79% of Republicans, 82% of independents, and 71% of Democrats. It had the support of the American Bar Association, the AFL-CIO, the United Auto Workers, the League of Women Voters, and Common Cause. Martin Diamond that year published a book stating his opposition to the reform. Diamond, Daniel Patrick Moynihan would later declare, had almost single-handedly established the relevance of the thought and doings of the American founders for this generation. He was keen to defend the Electoral College before Congress. Bayh called Diamond to testify on the second day of hearings, Friday, July 22, 1977, in room 235 of the Russell Senate Office Building. Speaking to Bayh and his committee, Diamond, 55, confessed that he was puzzled by why so many people seemed to have it in for the Electoral College. "I suspect that part of what people have against the Electoral College," he began, "not Senator Bayh, perhaps, or other members of the Senate, but others around the country, others in the academic profession, part of what scholars have had against the Electoral College is the fact that it is so old. They suspect the old. It must be archaic, it must be outmoded. How can anything devised so long ago for a simpler age, how can anything so old still be good in this unprecedentedly modern time?" It was as if Diamond were offering a rebuttal to a speech FDR had given 40 years before, in 1937. Bayh had an aw-shucks, good-natured wit. He interrupted Diamond. "I just have not heard anybody come before this committee and say the reason they want to get rid of it is because it's been around for 200 years, he said, partly badgering his witness and partly ribbing him. "I've been studying this problem for about 10 years, and never have I had one witness, nor have I read any treatise that says the reason he or she wants to get rid of the Electoral College is that it's old, and that, therefore, we should change it." Diamond testified for half an hour. Then he stepped down and went to sit with the spectators, about 30 in all. A member of the West Virginia legislature came forward to testify. He'd introduced a resolution in his state calling for a constitutional convention to be held in order to consider the Bayh Amendment, the first state to do so. He was just explaining why even West Virginia, a small state, advocated a national popular vote, when there was a commotion in the audience. At 10:53 a.m., Martin Diamond had a heart attack. Bayh and Senator Orrin Hatch both tried to revive him. For 10 minutes, Hatch compressed his chest. Bayh gave him mouth-to-mouth resuscitation. Bayh adjourned the hearings at 11:18 a.m. After a terrible delay, an ambulance finally arrived, but Diamond had died. Said Bayh, "It really shakes you up to think you're trying to breathe for someone and then find out later he's dead." He couldn't breathe life into the Bayh Amendment either. Once again, the Electoral College resisted reform. By then, the grueling public divide over equal rights and abortion had nearly put an end to amendment itself. Chapter 12. A Bill of Rights for women. 200 years is enough. Ratify the ERA. Banner carried in Atlanta, 1976. Patsy Takemoto Mink, beaming and with a lei draped around her neck, took to the stage in Houston on November 19, 1977, at a meeting that is the closest the United States has ever come to holding a second constitutional convention, unless you count the Confederate Convention in 1861. This constitutional convention, 2,000 delegates elected from the states and territories, was for women. Instead of meeting in an 18th century two-story Georgian brick elegance in Philadelphia, this convention met in the 9,000-seat Albert Thomas Convention Center, a flat-topped beige pancake of a building that could be easily mistaken for a parking garage. Mink, 49, was there that day as a delegate from Hawaii. "This conference, for me, is the culmination of a life's work," she said. Its goal, she said, was for women to become persons under our Constitution. Born in Maui in 1927, the grandchild of Japanese sugarcane workers, Patsy Matsu Takemoto had listened to FDR's fireside chats on the radio as a little girl with her father, a civil engineer. When the Japanese bombed Pearl Harbor in 1941, he, like thousands of Nisei, had been interrogated, suspected of being a Japanese spy. Denied admission to medical school, Takemoto had gone to the University of Chicago Law School as an international student, graduated and married in 1951, given birth to a daughter, and then joined the law faculty at the University of Hawaii. She was elected to Hawaii's Territorial House in 1956 after campaigning with the slogan, "Think, vote Mink." She'd fought for statehood, complaining to Congress that the reason for delay in admitting Hawaii is because of Hawaii's large Oriental population. In 1959, she'd only just taken her place in the Territorial Senate when Hawaii became a state. After she lost a race for Hawaii's new seat in Congress to Daniel Inouye, whose campaign spread a rumor that Mink's daughter was mentally retarded, Mink debuted on national television at the Democratic Convention in 1960. Southern segregationists had threatened to walk out of the convention to protest the party's plank advocating civil rights, but Mink, taking the stage, said, "I cannot sit silent in this historic moment without defending what I consider to be the truly greatest plank in the Democratic platform." Commentators focused on her appearance, one calling her a lovely Oriental doll. But Mink was the new face of a Democratic Party that had driven from its rank segregationists like David J. Mays. When she won a seat in Congress in 1964, she became the first woman of color in the House. She went on to serve 6 terms. Her early and sustained opposition to the Vietnam War, at a time when a new Asian American political movement was being born, proved particularly powerful and also controversial. Critics, tarring her a communist sympathizer, dubbed her Patsy Pink. Patsy Takemoto Mink insisted that she wasn't a women's liberationist, a term that hinted at radicalism. But she's best remembered for what she did for women's equality, and especially for her advocacy on behalf of poor women and working mothers. Early in 1970, she testified before the Senate Judiciary Committee during the Carswell hearings, explaining the consequences of the kind of discrimination against working mothers that she saw in his decisions. She supported both the Equal Rights Amendment and the legalization of abortion, the two constitutional issues crucial to the question of female personhood. She co-authored Title IX, banning gender discrimination in higher education. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. In 1975, the bicentennial of the American Revolution, her advocacy proved crucial in gaining congressional funding for a national convention for women. No issue has proved a greater challenge to the 1787 Constitution than the status of women under the law. despite Abigail Adams's having sent her husband a list of female grievances in 1776, reminding him that all men would be tyrants if they could, demanding that men drafting constitutions remember the ladies, and warning him that women will not hold ourselves bound by any laws in which we have no voice or representation. No early state constitution addressed those grievances in any way at all. At the Constitutional Convention in 1787, Madison had declared it to be a fundamental principle that men cannot be justly bound by laws in making which they have no part. He did not mention women, nor did any other delegate. Instead, they used the word person or persons nearly 200 times, and used those words as well in the Constitution itself. This had caused some perplexity in 1866 during the Senate debate over the 14th Amendment, when Jacob Howard, a Republican senator from Michigan, traded heated words with Reverdy Johnson, a Democrat from Maryland, about the meaning of person in the text of the amendment. Howard quoted a gloss that Madison had written about a speech he had given in 1787. Under every view of this subject, it seems indispensable that the mass of citizens should not be without a voice in making the laws which they are to obey and in choosing the magistrates who are to administer them. Johnson then asked Howard whether he meant to suggest that women are persons. Mr. Johnson: females as well as males. Mr. Howard: Mr. Madison does not say anything about females. Mr. Johnson: persons. Mr. Howard: I believe Mr. Madison was old enough and wise enough to take it for granted that there was such a thing as a law of nature, which has a certain influence even in political affairs, and that by that law women and children were not regarded as the equals of men. Mr. Madison would not have quibbled about the question of women's voting or of an infant's voting. He lays down a broad democratic principle that those who are bound by the laws ought to have a voice in making them. And everywhere, mature manhood is the representative type of the human race. The Constitution makes no distinction of sex, Victoria Woodhull had argued in 1871, attempting to found an equal rights doctrine on the back of the 15th Amendment. Congress had rejected her argument. The 19th Amendment had guaranteed that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. And while a doctrine might have evolved from that language to include women in the full meaning of personhood, it had not. Instead, the 19th Amendment had been doctrinally abandoned, a constitutional orphan, as one legal scholar has called it. The Civil Rights Act of 1964 prohibited discrimination based on race, religion, color, or national origin, and at the last minute, and in a failed attempt to defeat the bill, sex had been added to that list. But as Patsy Takemoto Mink pointed out in 1977, women were still not persons under the Constitution. In the 1970s, the silence of the Constitution on the subject of women was met with deafening discord, a series of heated political debates over the Equal Rights Amendment and abortion that divided women and reshaped the Democratic and Republican parties and American political culture itself. These debates also illustrate the American pattern of alternation between constitutional change by way of amendment and constitutional change by way of judicial interpretation. Except that these two issues also broke the pattern, because they really can't be reconciled with a constitution written for individual rights-bearing men. Whether or not the framers had ever intended for women and children to be persons constitutionally speaking, they certainly made no provision for the biological fact that women sometimes have beings living inside their bodies, including fetuses that at a certain stage of pregnancy can survive outside their mother's bodies. The Constitution cannot contain them. Nor was it possible to separate equal rights from abortion. Calls to liberalize abortion laws in the states had come from doctors and clergy and from Republican legislators up until the mid-1960s. But equal rights and abortion had both been added to a feminist agenda in November 1967, when the National Organization for Women drafted and ratified a Bill of Rights for Women. Notably, equal rights rose to the top of that agenda. Interest in abortion trailed far behind. Now, resolved to campaign for the ERA by a vote of 82-3 over the strenuous objections of labor organizers, including some who left the meeting, and by a vote of 57-14, now called for the repeal of all laws penalizing abortion. The ERA was the Bill of Rights for Women's first article, abortion, its last. Feminists sought to achieve these two goals by different strategies: equal rights by way of constitutional amendment, and the repeal of abortion laws by lobbying in the states. In both efforts, feminists saw remarkably speedy results. The states began liberalizing or abolishing abortion bans in 1967. The Johnson administration issued a report the next year recommending that all states do so. By the end of 1970, 14 states had reformed their abortion laws. In 1972, Congress passed the Equal Rights Amendment and sent it to the states for ratification, and less than a year later, in Roe v. Wade, the Supreme Court declared all remaining state laws prohibiting abortion before the second trimester to be unconstitutional. But by 1977, when 20,000 women met for the National Women's Convention, the ERA's momentum had flagged, and Congress had enacted the Hyde Amendment, a restriction tacked onto a spending bill prohibiting the use of federal funds for abortion, except to save the life of the mother. If feminists sought constitutional change by both amendment and interpretation, anti-feminists and the Right to Life movement sought to halt that change by steady and determined grassroots and national organizing, whose aim was to defeat one amendment, the ERA, and to pass another, a Right to Life amendment. By the time New York Congresswoman Bella Abzug used a gavel once wielded by Susan B. Anthony to call the National Women's Conference to order in Houston, 145 Right to Life amendments had been introduced into Congress. Even as the Women's Conference was meeting, thousands of women opposed to both Roe v. Wade and to the ERA held their own convention across town. 12,000 anti-feminists and Right to Life activists gathered for the pro-life, pro-family rally at Houston's Flying Saucer-style stadium, the Astro Arena. The star of the slate of speakers was Phyllis Schlafly, age 53, a political genius, a Catholic mother of 6, and leader of the largest campaign ever waged to defeat a constitutional amendment. Born in St. Louis, Schlafly had been a leading conservative strategist since the 1950s, when she was an ardent anti-communist. In a campaign funded by H.L. Hunt, Dan Smoot's one-time boss, she'd made a failed bid for Congress in 1952 and had become instead a Republican power broker, battle general of the millions of suburban housewives who were the foot soldiers of a conservative Republican army. Her support for Goldwater had in large part earned him the nomination in 1964, for which liberal Republicans had never forgiven her. In 1967, as the incumbent vice president of the National Federation of Republican Women, she failed to earn the presidency. She'd come late to the ERA, but she brought to the campaign her extraordinary tactical skills, an unmatched mailing list, and the shrewd observation that the best way to defeat the amendment was by attaching it both to abortion and to gay rights. In Houston, delegates at the National Women's Conference adopted a plank for lesbian and gay rights. At the counter-rally, one protester held up a sign that read, "ERA is 90% gay." Schlafly took to the stage in her signature blonde French twist, wearing a red stop sign button on her red sweater dress. Stop ERA stood for Stop Taking Our Privileges, but it was also a callback to William F. Buckley's National Review's cri de coeur. Stand athwart history and yell, "Stop." Schlafly knew what she wanted to stop, and she knew how to stop it. She was at the time in law school, months away from completing her JD. "The American people and the American women do not want ERA," Schlafly said crisply into the podium microphone. "They do not want abortion. They do not want lesbian privileges." She would change the law. She would save the Constitution. In the early 1970s, Americans' political future might have seemed to lie with women like Patsy Takemoto Mink, who sought the Democratic presidential nomination in 1972, vying with New York Congresswoman Shirley Chisholm, the first black woman to run for president. But the wind was behind not their backs, but Schlafly's. After Houston, Schlafly reported in her newsletter, The Phyllis Schlafly Report, that the showdown between the National Women's Conference and the pro-life, pro-family rally had been a turning point in the war between feminists and anti-feminists. The antis were winning. In the longer sweep of American history, there would be many more skirmishes and many more wins for Schlafly and for American conservatism. Ronald Reagan would ride to the White House in 1980, tied to her apron strings. By 1982, a decade after the Equal Rights Amendment passed Congress, it would be defeated, and the pro-life movement would abandon its campaign for a right-to-life amendment in favor of seeking to overturn Roe v. Wade in the courts by allying with a new brand of constitutional conservatism, calling itself originalism. Equality of rights under the law. Birch Bayh did not want to hold hearings on the Equal Rights Amendment, but on February 17, 1970, as his subcommittee was holding a vote on the voting age amendment, the 42-year-old Pittsburgh librarian Jean Witter and some 20 other members of NOW disrupted the meeting. Witter's frustration was immense. NOW had adopted its Bill of Rights for Women in 1967, and nearly 800 bills proposing an equal rights amendment in Congress had been introduced between 1960 and 1970, but efforts to make any headway on the ERA in the House had been blocked by the chair of the House Judiciary Committee, Emanuel Seller, and Witter determined that starting out in the Senate was her best hope. Bayh, fuming, conceded. 10 men served on Bayh's subcommittee. But aside from the chair, only 2 turned up when Bayh's promised hearings opened on May 5, 1970. Eastland had called for a full meeting of the Senate Judiciary Committee to begin at the same hour. Bayh, in his opening statement, said he hoped the hearings would prick the national conscience. For 3 days, a parade of feminists from Gloria Steinem and Betty Friedan to Shirley Chisholm took their seats before the scant remnants of Bayh's subcommittee. Press coverage was hardly sympathetic. The women who walked into the Senate caucus room wore everything from miniskirts to midi frocks, the New York Times reported, and not a single male showed up in the audience. Patsy Takemoto Mink's House Committee on Education and Labor held hearings on Title IX the next month. A number of people testified at both sets of hearings, since they involved many of the same fundamental issues of discrimination. Legislators, in short, were pursuing equal rights on multiple fronts, on the theory that trusting the courts to interpret the 14th Amendment as guaranteeing women equal protection of the law was simply too risky. New federal statutes were needed, and so was a new constitutional amendment to make sure the courts honored those statutes. In August, Michigan Representative Martha Griffiths, who testified at Mink's Title IX hearing, instituted a discharge petition to force the bill out of the House Judiciary Committee. Mink supported equal rights, but she declined to sign Griffith's petition. Instead, she circulated a Dear Colleague letter to members of the House, arguing that the ERA could have adverse consequences for poor women and mothers of young children could be forced out of the home into the job market against their will. Mink took the position once taken by Florence Kelley that women still required protective labor legislation. But her preferred solution was to seek a guarantee that no statutes that applied either to men or to women separately would be narrowed by the ERA, but instead would be broadened. She wrote to Griffiths to ask that she considered adding language to the proposed amendment to read, provided that any state or federal law which confers rights, benefits, or privileges on one sex only shall be construed to be extended to apply to both sexes equally. This Griffiths would not do. When Griffith's discharge petition succeeded and the amendment was finally debated in the House, Mink rose to introduce her amendment to the ERA. California had a minimum wage law that applied only to women, she explained. With her amendment, the revised ERA would mean that men in California would benefit from the minimum wage law, too. Griffiths had assured her that this amendment is not needed because it is implicit in the constitutional amendment as presented. Mink read her amendment into the record as a clarification, but had decided not to withhold her support. The unmodified ERA passed 352-15. Back in the Senate Judiciary Committee, Sam Ervin objected to the amendment, agreeing only to hold more hearings in 1971. He had opposed equal rights for women since he was first elected to the Senate in 1954. If he couldn't stop the amendment, he wanted to cripple it. Irwin wanted to add to the proposed amendment language exempting women from the draft and requiring ratification within 5 years of passage. Bayh managed to defeat the draft exception and to negotiate for a 7-year ratification window. He also, to the great consternation of now, drafted a new version of the amendment. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex, and introduced it into the full Senate. Bayh's version prevailed. On March 22, 1972, after 2 years of wrangling and after another House vote, 354 to 23, the Senate passed the ERA 84-8. These massive vote margins gave advocates every expectation of swift ratification. Less than half an hour later, Hawaii, once ruled by Queen Liliuokalani, became the first state to ratify it. 4 more states ratified within 48 hours of the Senate vote, and by the end of the year, a total of 22 had ratified. No one had any particular reason to expect opposition, not even Birch Bayh, who'd wrangled with Irvin over the Electoral College and seemed to understand the challenge of amending the Constitution better than any living American. But the bottleneck in Bayh's experience had been the Senate, not the states. Of all the amendments Bayh had championed, the ERA was, he'd come to believe, the one least likely to encounter real opposition in the states. Maybe some other folks thought of it, Bayh would later say, looking back. I didn't. Martha Griffiths didn't either. Both Griffiths and Bayh expected the ERA to achieve ratification quickly, possibly even faster than the 26th Amendment, which had taken only 100 days, a record. That's why they hadn't put up much of a fight against an expiration date, which turned out to be a fateful miscalculation. It also appears to have been unnecessary. The amendment would have passed without acceding to this demand by its opponents. And no one seems to have given any thought to the idea that given the very high public support for the ERA, as measured by public opinion surveys, ratification by state conventions, rather than by state legislatures dominated by men, might have been a better path. Because then came the great deceleration. 8 states ratified in 1973, 3 in 1974, 1 in 1975, none in 1976. In 1977, only 1. Meanwhile, 5 states voted to rescind their earlier ratifications, an action whose constitutionality has been questioned. Notably, resistance was strongest in the South. Heading toward the 7-year deadline in 1979, the amendment was 3 states short of the required 38. Jean Witter, after her experience lobbying the Senate, went to law school, and when the ERA appeared likely to fail of ratification by its 7-year deadline in 1979, it was Witter who wrote the legal memo arguing that the deadline could be extended by another 3 years, another action whose constitutionality has been questioned. The Equal Rights Amendment would have prohibited discrimination on the basis of sex, but its supporters understood it as fighting, too, what the black constitutional theorist Pauli Murray called Jane Crow. In a statement to the Senate Judiciary Committee during its second round of hearings in 1971, Murray told the story of her grandmother, born in slavery, the progeny of rape by a white master, and of her own life. The road over which I have traveled is the experience of most Negro women in America, she said. Born in genteel poverty, I have shared the experience of domestic workers, service workers, lower-paid clerical workers. Tracing the history of everything from sexual violence to employment discrimination, she told the committee that the black woman stands almost alone and must appeal to the fundamental law of the land to give her a footing upon which to build some semblance of stability for herself and for her children. Black women, she told the Senate Judiciary Committee, have as a group the most to gain from the adoption of the Equal Rights Amendment. Murray argued for the ERA as essential to the future of a liberal constitutional democracy. The adoption of the Equal Rights Amendment and its ratification by the several states could well usher in an unprecedented golden age of human relations in our national life. The ERA would not have ushered in a golden age, but it would have comprehended women within the nation's fundamental law. Ruth Bader Ginsburg and other feminists argued for the existence of a de facto ERA, the series of statutes and cases that together operate to prohibit discrimination on the basis of sex. But the ERA was a constitutional settlement that would have established equality in a way that no statute or court decision ever could. If its advocates had spent a little time studying the history of early amendment and anti-amendment campaigns, especially the campaigns for and against the suffrage and child labor amendments, one historian has argued, they would have better anticipated the strength of the opposition, and they would have better understood both the necessity of waging an early, sustained, and targeted ratification effort in the states. There is no end to the what-ifs, but perhaps no lesson from history could have prepared advocates of the ERA for what became ratification's greatest obstacle, the inseparability of equal rights from Roe v. Wade. Ladies, have you heard? Phyllis Schlafly started working against the Equal Rights Amendment even before it got out of Congress, at the behest of Sam Ervin. Ervin, having hobbled the amendment with a deadline, knew that all he needed to do was slow down the pace of ratification. In December 1971, Schlafly had declined an invitation to debate the ERA because at that point she didn't know what side she was on. But Ervin and others persuaded her to come out against it, not least because the National Federation of Republican Women, which had spurned her, had come out in favor of it. He sent Schlafly copies of his Senate speeches, which she then printed and distributed across the country. Dedicating herself to the task, she began offering up her own objections. In February 1972, she devoted the whole issue of her Phyllis Schlafly report to What's Wrong with Equal Rights for Women. Suddenly everywhere we are afflicted with aggressive females on television talk shows, yapping about how mistreated American women are, she wrote. But the truth is that American women never had it so good. Why should we lower ourselves to equal rights when we already have the status of special privilege? Schlafly and Ervin needed only to defeat or even only to delay ratification in 13 states. At a time when ERA proponents were celebrating and engaging in national politicking, Schlafly carefully plotted out a grassroots strategy, state by state. That December, she faced Birch Bayh in a television debate moderated by Barbara Walters. Bayh complained that debating a woman with absolutely no legal training and no legislative experience made him want to commit mayhem. His contempt led Schlafly to decide to go to law school. Birch Bayh might have seen what was coming if he had more carefully read his mail. His office kept excellent files on the letters he received from constituents over the course of his 14-year tenure as chair of the subcommittee on constitutional amendments. His archives are stuffed with letters, postcards, and telegrams supporting or opposing amendments of all stripes. A lot of people sent him their own personal proposals for amendments. They may be pretty bad ideas, warned a man from Louisiana, sending along a few actually pretty good ones. Other senators who got nutty amendment ideas in the mail asked Bayh to handle them. Eastland fobbed off onto Bayh a constituent who proposed an amendment that would lead to the development of a United States of intergalactic America. We receive and we review thousands of proposed amendments each year, a Bayh staffer solemnly wrote back under Bayh's name, but your interesting suggestion is one which has never before come to our attention. Nothing would serve the communists more than direct elections of the president, one Indiana constituent warned the senator. Another opponent of the Electoral College Amendment complained that it would give too much political power to people living in cities who are not representative of our finest citizenry. The more successful and controversial the amendment, the greater the quantity of Bayh's correspondence. But no topic generated more mail to his office than the Equal Rights Amendment, and much more of it was con than pro. It also tended to take the form of stock letters, even fill-in-the-blank letters, as letter writers, following instructions from coordinated letter-writing campaigns pioneered by the John Birch Society spin-off the network of patriotic letter writers, simply copied out language printed in newsletters or newspapers. Stop ERA generated Dear Candidate letters urging candidates and later office holders to preserve the legal rights of women and the dignity of womanhood by voting no on the ERA, and then carried those letters by the basketful to legislators' offices. Schlafly's campaign against the ERA was in many ways a rerun of the Woman Patriots campaign against the child labor amendment in the 1920s. And it was equally effective, or no, it was far more effective. Where Mary Kilbreth and Woman Patriot had warned voters that under the terms of the child labor amendment, no parent could require a child to wash the dishes or chop firewood, Schlafly warned women that under the terms of the Equal Rights Amendment, women would be drafted, there would be no girls' and boys' bathrooms in schools, and divorced women would lose their rights to custody and alimony. Voters' confusion about these claims is nicely illustrated in the letters received at Birchbye's Senate office. In 1974, a woman from Texas sent him a very alarming leaflet she'd received, put out by the conservative Christian organization Women Who Want to Be Women, and distributed through church newsletters, and asked, "Is this description of the ERA true?" Anyone could believe Phyllis Schlafly, who knew how to point out the elitism of the feminist movement and its vicious contempt for women who enjoyed housekeeping and preferred to stay at home with their children. On television, she was unbeatable. She was smart and relentlessly strategic. In her newsletter and to conservative audiences, she denounced her opponents with precision and delight. To television audiences, she sold happiness and contentment like so much laundry detergent. In 1974, when she went on the Phil Donahue show in a trim red dress, she was funny, and she smiled a lot, and she made the host in his polka dot tie and trademark helmet of gray hair look anguished and needy, which is also how she painted feminists. "Everybody's got problems, but you don't have to look to the Constitution to solve it," she said, as if she were pleasantly scolding a willful child. That she was misrepresenting the consequences of the ERA pained but also seemed to paralyze the liberal Donahue, whose shoulders sagged as he begged the audience, "Help me out here." Her critique of the women's liberation movement, "They're selling you sisterhood, but what about motherhood?" was sharp and straightforward, and to Donahue's audience of mostly middle-class housewives, it rang true as a bell. "The whole thing is erected on a lie," Schlafly said. "The lie that women are not persons." This description of the ERA was not true. Donahue did not challenge it. The right to privacy. In 1965, in Griswold v. Connecticut, Justice William O. Douglas, writing for the majority, argued that a fundamental constitutional right to privacy exists, even though the word privacy does not appear in the Constitution. Instead, it is to be found in the penumbra, or shadow cast by other words in the Bill of Rights and in the 14th Amendment. The court found that a Connecticut law banning contraception, even for married couples, violated that right. Perhaps not irrelevantly, Douglas, 67, had been married 3 times, including in 1963 to a 23-year-old woman who had written a college paper about him. In 1966, shortly after another divorce, he was married for the 4th and final time to a 23-year-old college student. Meanwhile, the doctors, lawyers, and clergy, mostly men, who were advocating for the liberalization of state abortion laws to protect a woman's life or to allow for termination in case of a grave fetal defect or in instances of rape, were having considerable success. Colorado, North Carolina, and California passed reform laws in 1967, Maryland and Georgia in 1968, Arkansas, Delaware, New Mexico, Kansas, and Oregon in 1969, South Carolina and Virginia in 1970. But advocates were discovering that simply reforming those laws was insufficient. Lifting certain restrictions made it easier only for women who had the resources to find a doctor willing to perform an abortion. And environmentalists concerned about population growth began to push not for the reform of abortion laws, but for the repeal of all restrictions on abortion, especially after the publication of Paul Ehrlich's best-selling book, The Population Bomb, in 1968. Alaska, Hawaii, New York, and Washington repealed all restrictions on abortion in 1970. The sexual revolution played a part in the calls for decriminalization of abortion, but not a major part. In 1968, affiliates of Planned Parenthood, then a Republican-dominated family planning service provider, not a feminist organization, voted to support a campaign not to reform but to repeal all state abortion laws. The next year, activists founded the National Abortion Rights Action League, or NARAL. Shirley Chisholm agreed to serve as its honorary co-president, and the California Supreme Court overturned that state's abortion restrictions, arguing that the fundamental right of the woman to choose whether to bear children follows from the Supreme Court's and this court's repeated acknowledgement of a right to privacy. Not until the late 1960s did abortion become a leading issue not only for doctors, lawyers, and clergy interested in public health, family planning, and population control, but also for feminists. In a speech in Chicago in 1969 at a national conference sponsored by the Illinois Citizens for the Medical Control of Abortion, Betty Friedan said, "There is no freedom, no equality, no full human dignity and personhood possible for women until we assert and demand the control over our own bodies, over our own reproductive processes." Nixon, like other leaders of the Republican Party, including George H.W. Bush and Ronald Reagan, had supported abortion. But he began reconsidering his position after his strategist Kevin Phillips advised him in 1969 that the GOP could recruit alienated Democrats to their party, including both white Southerners and Catholics. By 1971, Nixon, citing the sanctity of human life, instructed the Department of Defense to reverse its position on abortion, implemented only the year before, allowing military hospitals to perform abortions. In a memo on dividing the Democrats, Nixon advisor Pat Buchanan told him that abortion was a rising issue and a gut issue with Catholics. By 1972, Schlafly had joined that effort in her first published attack on the ERA, in which she charged that women's libers are promoting abortions instead of families. In the years when abortion was becoming a feminist issue, the GOP was courting Catholics by beginning to oppose it, and Schlafly was linking abortion to the ERA. Feminist legal theorists were exploring several possible routes to secure equal protection of the laws beyond what had been put in place under the 1964 Civil Rights Act. The ACLU's Equality Committee, led by Pauli Murray, reported in 1968 that clarity of the law has not been achieved in the area of discrimination based on sex, and began considering how to firmly and permanently establish that women were persons under the 14th Amendment. In 1969, a brilliant young law professor from Brooklyn, Ruth Bader Ginsburg, mother of two, began volunteering for the ACLU, where, building on the earlier work of Murray and Dorothy Kenyon, she founded a women's rights project. Ginsburg was not enchanted by right-to-privacy arguments. Instead, following Murray's line of argument, she wanted to convince courts that the Equal Protection Clause of the 14th Amendment, "No state shall deny to any person within its jurisdiction the equal protection of the laws," prohibited not only discrimination by race, but also discrimination by sex. Victoria Woodhull had attempted the same thing a century before with no luck. Ginsburg scored her first victory in 1971 in a case called Reed v. Reed. In 1972, she was hired by Columbia. Columbia Law snares a prize in the quest for women professors, the New York Times announced, while working on a case involving an Air Force lieutenant, Susan Struck. When Struck became pregnant, she was told she would need to have an abortion to terminate the pregnancy, or else she would lose her job. In Struck v. Secretary of Defense, Ginsburg argued that the Air Force's policy violated Struck's 14th Amendment rights, since no man was forced to leave the Air Force if he were to have a child. Struck v. Secretary of Defense was consistent with the underlying logic of the Equal Rights Amendment. It sought to establish the constitutional equality of men and women. If the ERA had been ratified before Struck became pregnant, the Air Force policy would have quite plainly violated the Constitution's latest amendment. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. But that was not what happened, and not only because the ERA was not ratified. Before the case was heard, the Department of Defense changed its policy under Nixon's direction, and the case was dismissed. Struck v. Secretary of Defense did not involve a right to privacy. It involved a reading of the 14th Amendment's Equal Protection Clause. But a right to privacy did lie at the heart of the abortion case the court heard instead of Struck, Roe v. Wade. Roe v. Wade, like Brown v. Board of Education, was argued twice, first on December 13, 1971, and then again on October 11, 1972. Between those two dates, on March 22, 1972, Congress sent the ERA to the states. And on the same day, the Supreme Court handed down a decision in Eisenstadt v. Baird, extending the right to contraception, by way of a right to privacy, to unmarried people. Easily forgotten in the storm that followed the court's decision in Roe is just how widespread was support for abortion in 1972, and how little that support divided along partisan or religious lines. To the degree that it did follow party lines, Republicans were more likely to support the decriminalization of abortion than Democrats. In a Gallup survey conducted in the summer of 1972, Americans were asked whether they agreed with the statement that a decision to have an abortion should be made solely by a woman and her physician. 64% of those surveyed said yes, including 56% of Catholics, 68% of Republicans, and 59% of Democrats. Justice Harry Blackmun, who would write the Roe decision, clipped out that poll and slipped it into his case file. Abortion did not begin as a partisan issue. Partisans made it into a partisan issue. This effort began before Roe as part of the Nixon campaign's effort to woo alienated Democrats. The people who are alienated are the ones who don't want pot, who don't want abortion, who don't want to pay 1 more cent in taxes, reported Kevin Phillips in 1972. But it intensified after Roe, when GOP strategists made abortion into a partisan issue by demonizing Roe, the court's method of judicial interpretation, and eventually the court itself. In Roe v. Wade, the 21-year-old Texas plaintiff, Norma McCorvey, who was called in the court documents Jane Roe, sued Dallas County District Attorney Henry Wade, alleging that the state's ban on abortion violated the 14th Amendment. A key difference between the two cases was that Susan Strzok wanted to have a baby, while Norma McCorvey wanted to have an abortion. Ginsburg had believed the Strzok case was a better platform on which to erect an argument about reproductive choice. McCorvey, who had relinquished custody of 2 earlier children, was represented by a young Texas lawyer, Sarah Weddington, recently graduated from the University of Texas Law School. In 1970, a lower court had ruled in McCorvey's favor, deeming the Texas abortion ban a violation of the fundamental right to choose whether to have children. This decision did not come in time for McCorvey, who gave birth to a daughter and gave her up for adoption. Weddington and her colleagues, in the brief they submitted to the Supreme Court in Roe v. Wade, placed their argument in line with Griswold and Eisenstadt. The Constitution does not specifically enumerate a right to seek abortion or a right to privacy, they wrote. That such a right is not enumerated in the Constitution is no impediment to the existence of the right. Although the Supreme Court held oral arguments in Roe v. Wade in December 1971, the bench was short 2 justices. The Chief Justice decided to postpone re-argument until 2 new justices had been appointed. In the meantime, the very line of argument that McCorvey's lawyers made in their brief came into question in a law review article that is generally credited as founding the modern era of the doctrine of original intent. In the spring of 1971, Yale Law School professor Robert Bork delivered a lecture at Indiana University's law school. The lecture appeared in the Indiana Law Journal that fall, in time to warn the justices against ruling in favor of Jane Roe. All Supreme Court decisions which involve women are unconstitutional. Robert Bork had frizzy red hair and a pointy Don Quixote mustache and beard. His deep-set eyes gave him, even in early middle age, a look of exasperated weariness. Born in Pittsburgh in 1927, the same year as Patsy Takemoto Mink, Bork served in the Marine Corps during the Second World War, and again in the early 1950s. He and Mink overlapped at the University of Chicago Law School, and had also married within months of one another. Mink joined the faculty of the University of Hawaii Law School. Bork joined the law faculty at Yale. From there, their paths diverged. Bork was an expert in antitrust law, though he delighted in writing for a broader public as a contributor to Fortune magazine and the New Republic. He worked for both the 1964 Goldwater campaign and the 1968 Nixon campaign. He opposed key decisions of the Warren Court, including its one-man, one-vote decisions, and he also opposed both the 1964 Civil Rights Act and the Equal Rights Amendment. In his 1971 article, Bork sought to offer a sustained critique of judicial activism by looking at several cases, but especially at the court's 1965 decision in Griswold v. Connecticut. The right to privacy does not exist, Bork argued. The court had invented it. A legitimate court, he wrote, must be controlled by principles exterior to the will of the justices. These principles must be neutral principles, not an expression of the values cherished by the justices. Because a court that makes rather than implements value choices cannot be squared with the presuppositions of a democratic society. In Griswold, the court had made decisions that were not neutrally derived from the text of the Constitution and the intent of its framers, and that ran counter to the text and history of the Constitution and to the political practice of Americans from colonial times up to the day the court invented the new formula. The original intent doctrine that Bork proposed had been espoused by conservatives since Brown v. Board of Education, in the clenched-jaw television appearances of Dan Smoot, and in the quiet but determined advocacy of David J. Mays. Still, before the 1970s, it had had limited purchase either on the court or in public discourse. Strom Thurmond's constitutional history quiz, administered to Thurgood Marshall during his 1967 confirmation hearings, had been an embarrassment. But 4 years later, in the fall of 1971, when the Senate Judiciary Committee held hearings for 2 new justices, interest in original intent doctrine had moved from the fevered mind of Alfred Evans to the scholarly musings of Yale Law School's distinguished Professor Bork. This wasn't only about partisanship and political power. Johnson nominated Marshall while Nixon nominated Rehnquist and Powell, and the Democratic majority in the Senate was slimmer in 1971 than it had been in 1967. It was also about the difference between discrimination on the basis of race and discrimination on the basis of sex. Nixon had wanted to nominate a woman. Now had demanded that he do so, reiterating a demand that women had been making since Florence Kelley first complained about the Supreme Court's monopoly of men in 1924. A half-century later, of the nation's 10,000 judges, fewer than 200 were women, and 97% of lawyers were men. Nixon had chosen one woman, Mildred L. Lilly, a California Court of Appeals judge, a Catholic, and a conservative Democrat. White House counsel John Dean told Nixon aide Bob Haldeman, who told Nixon, that Lilly's a goddamn jewel. But when Chief Justice Warren Burger heard what Nixon was contemplating, he wrote a letter to Nixon's Attorney General, John Mitchell, telling him that if Nixon appointed a woman, Burger would resign from the bench. Nixon relented. In November 1971, the Senate Judiciary Committee considered Nixon's 2 nominees, William Rehnquist and Lewis Powell, in a single set of hearings. Nixon called it his double play. Bork submitted a letter in support of Rehnquist to the committee, praising his commitment to the commands of the Constitution, interpreted in the light of its text and its history. During questioning, Rehnquist told the committee that judges were limited by the language used by the framers and by the historical materials available, and that he, for one, would not disregard the intent of the framers. Much attention was given during the process to a memo Rehnquist had written in 1952 while a clerk for Robert Jackson during deliberations over the school segregation cases. "I think Plessy v. Ferguson was right and should be reaffirmed," Rehnquist wrote. He insisted that this had been the justice's view, not his own. 7 representatives of right-to-life organizations testified and asked that the committee inquire into the nominees' positions on abortion and reject them if they did not agree that a constitutional right to life existed. The right-to-life activists who spoke at the hearings did not know how the nominees stood on this question, and they neither opposed nor supported them. They simply wanted the committee to concern itself with the question. They did not inquire as to what the framers intended. That line of inquiry would not have helped their cause, because while the widening influence of a Borkian doctrine of original intent posed a problem for anyone hoping to repeal state laws regulating abortion under a constitutional right to privacy, it also posed the very same problem for people hoping to defeat those efforts by citing a right to life. Neither phrase can be found in the Constitution. There's a right to life in the Declaration of Independence, but there is no right to life in the Constitution, in the same way that there is no right to privacy in the Constitution. Neither is an enumerated right, though the argument can be made that both rights are implied. The right to life slogan of the anti-abortion movement began as a religious teaching, when opposition to abortion came chiefly from the Catholic Church, especially after the Church in 1968 issued an encyclical in which Pope Paul VI condemned both abortion and contraception. Mapping a religious commitment onto a rights-based constitutional order is a complicated undertaking. Like abolitionists before them, to whom right-to-lifers often compared themselves, they found support in the Declaration of Independence. Testament to the right-to-life's movement indebtedness not to the Constitution, but to the Declaration of Independence, can be found in the Declaration of Purpose of Americans United for Life. We believe, in the words of the Declaration of Independence, that all men are created equal, and thus that to be true to its heritage, this nation must guarantee to the least and most disadvantaged among us an equal share in the right to life. Ginsburg looked to the Equal Protection Clause of the 14th Amendment to argue for a right to abortion. Right-to-life lawyers looked to its Due Process Clause. In 1967, Thomas L. Schaefer, professor and later dean of Notre Dame Law School, and an expert on legal ethics, argued that abortion violated a fetus's 14th Amendment rights in the sense that the right to due process is a person's right not to be deprived of one's life by the state without due process of law. But this line of argument required establishing that a fetus is a person. Also, making Schaefer's argument required engaging in the same act of interpretation, leaning on implied rights, that the court had done in Griswold and Eisenstadt. A brief by the Americans United for Life would note this shared method of constitutional interpretation when, citing Griswold and its penumbra, it attempted to define the right to life as implicit in other, more explicitly protected rights. What right-to-life arguments could not do was to cite the framers' original intentions. The framers, in short, had no answers. The most strenuous objection to Rehnquist and Powell came from Now, and it did involve the framers' intent. Now's president objected to the two candidates, both because they were men, and because they were known to favor a mode of constitutional interpretation that was unjust for women. How fair could it be to interpret the Constitution exclusively according to the original intent of the framers, she asked, when women were excluded from the writing, the content, and intent of the Constitution? Jean Witter went further, arguing, it is possible to make a case that all Supreme Court decisions which involve women are unconstitutional, since there has never been a woman on the Supreme Court. Despite the newsiness of Bayh's fierce and remorseless opposition to Nixon's earlier nominees, Rehnquist and Powell's nominations did not explode on a partisan battlefield, even though Rehnquist's position on Brown was the subject of considerable discussion. Rehnquist's elevation to Chief Justice in 1986 would be more controversial. A new era of battle over Supreme Court nominees would turn on neither abortion nor segregation, though it would not begin until some years after Roe, a case that was first argued 1 week after the Senate confirmed Powell, 89-1, and 3 days after confirming Rehnquist, 68-26. On Rehnquist, Birch Bayh voted nay. How about the fetus? In October 1972, when the Supreme Court met for re-argument in Roe v. Wade and a companion case, Doe v. Bolton, with Rehnquist and Powell now on the bench, Justice Byron R. White asked Norma McCorvey's attorney, Sarah Weddington, whether it was critical to her case that a fetus not be a person. Weddington, speaking in a slow Texas drawl, tried to turn from that question about fetal personhood back to the matter of women's rights. Weddington: it seems to me that it is critical first that we prove this is a fundamental interest on behalf of the woman, that it is a constitutional right, and second. White: Yes, but how about the fetus? Weddington tried to move on, but White pressed her. White: Under the federal Constitution, is the fetus a person for the purpose of the protection of the Due Process Clause? Weddington: All the cases, the prior history of the statute, the common law history, would indicate that it is not. White: Well, what if? Would you lose your case if the fetus was a person? Weddington didn't have any real answer to that hypothetical, and neither did the court. On January 22, 1973, Justice Harry Blackmun issued the opinion for the court's 7-2 majority. The Constitution does not define person in so many words, and the 14th Amendment refers to persons born, and no case has ever held that a fetus is one. For what Bork had cherished as the political practice of Americans from colonial times, Blackmun had little use. He offered a survey of the history of criminal statutes relating to abortion dating to antiquity, only to set it aside. Instead, citing Griswold, he held that state laws banning abortion were unconstitutional violations of an unenumerated but implied right to privacy, and he determined that restrictions on abortion after the first trimester through viability were allowed only when reasonably related to the health of the mother. Rehnquist, joined by White, wrote a dissent in which he averred that the majority had managed the seemingly impossible feat of leaving this area of the law more confused than it had found it, pointing out that the majority had discovered, within the scope of the 14th Amendment, a right that was apparently completely unknown to the drafters of the amendment, and in applying different rules to different stages in a pregnancy, had written a ruling that partakes more of judicial legislation than it does of a determination of the intent of the drafters of the 14th Amendment. In an influential article in the Yale Law Journal that appeared within months of the decision, law professor John Hart Ely, who was neither a conservative nor an originalist, nor a supporter of the right to life movement, eviscerated the opinion as lacking any real foundation in the Constitution. Ely called Roe a very bad decision and a terrible example of judicial overreach. He compared the court's construction of a right to abortion to the invention of a liberty of contract in Lochner. Few women sat in legislatures, he admitted, a fact I believe should bear some relevance, even without an equal rights amendment, to the appropriate standard of review for legislation that favors men over women, but no fetuses sit in our legislatures. As the Yale scholar Reva Siegel would later observe, Ely failed to explain how all male legislatures were constitutionally adequate to represent either. Reproductive rights lawyers jubilantly celebrated the decision, and though they expected backlash, they hoped that, unlike the decision in Brown v. Board of Education, the clarity of Roe would defeat a campaign of massive resistance. I think we envision not having to go through what blacks had to go through after Brown, said one advocate, because in Roe and Doe, the court was quite clear in terms of what the state could or could not do, whereas they never drew up desegregation plans in Brown. This attitude nurtured complacency, when in truth, Roe inaugurated massive resistance on a scale and for a duration unseen in the aftermath of Brown. Would you lose your case if the fetus was a person? Justice White had asked. Within a month of the court's decision in Roe, a coalition of predominantly Catholic right-to-life organizations, led by the National Right to Life Committee, half of whose original funding came from the U.S. Catholic Conference, decided to undertake a concerted campaign to press Congress for a constitutional amendment specifying that life begins at conception and that a fetus is a person. That spring, North Carolina Republican Senator Jesse Helms introduced a right-to-life amendment identical to one introduced in the House by Larry Hogan Sr. of Maryland. Unlike the strategy pursued by opponents of Brown v. Board nearly 2 decades before, they opposed any amendments that returned abortion to the states, the National Right to Life Committee resolving that such an amendment would reaffirm the court's decision. Wrote one Catholic bishop, "It is the considered judgment of legal scholars that the only way to provide a constitutional base for legal protection of the unborn is by amending the Constitution." In pursuing a constitutional amendment, the Right to Life movement placed itself in somewhat of the same dilemma as had abolitionists in the decades before the Civil War. The two movements, in fact, have much in common, including that both were moral crusades. To call for an amendment is to concede that you lack a constitutional right and need an amendment to establish it. But given the difficulty of amendment, as FDR had learned the hard way with the child labor amendment, it can be more strategic to try to persuade the Supreme Court to change its mind and to find the right you're looking for somewhere in the Constitution. Either way, nothing about the right-to-life position aligned with the doctrine of original intent. Before Roe, the right-to-life movement had involved a loose array of organizations, but Roe accelerated the movement's development, especially under the aegis of national organizations that included Americans United for Life, a public law firm, and the National Right to Life Committee, which after January 1974 newly had financial support from the National Committee for a Human Life Amendment, a corporation formed by the nation's Catholic bishops. The movement suffered from divisions and disagreements, especially over the language for a constitutional amendment. It was interested in hiding the prominence of the Catholic Church and its activities, but its opposition to Roe was felt passionately and deeply and urgently. Members lobbied Congress. They asked their supporters to write and call their representatives in Washington. Birch Bayh received 80 letters a day urging him to hold hearings on a right-to-life amendment. The destruction of unborn children. On January 22, 1974, the one-year anniversary of Roe v. Wade, anti-abortion activists held a March for Life in Washington. By then, 27 proposed amendments either banning abortion or sending the issue back to the states had been introduced into Congress. In March, Birch Bayh, pressed by Catholic bishops, finally opened subcommittee hearings to consider two right-to-life amendments, one proposed by Helms and one introduced by New York Senator James L. Buckley, William F. Buckley's brother, elected as a member of New York's Conservative Party. Both amendments would have prohibited abortion nationwide and would have established that life begins at conception. The Buckley Amendment included an exception for the life of the mother. The Helms Amendment did not. The Buckley Amendment defined persons as all human beings, including their unborn offspring, at every stage of their biological development, and hence guaranteed a constitutional right to life. The Helms Amendment specified that it extended the 14th Amendment's guarantees of due process and equal protection of the law to any human being from the moment of conception. Although leaders of the National Committee for a Human Life Amendment feared that the hearings were only a delaying tactic, right-to-life groups began organizing in the states in hopes of winning a ratification battle in the years to come. "We're going to be here as long as it takes," the head of the National Right to Life Committee told the press in March 1974. That may be 5 years or 10 years. Bayh, who had helmed so many of these hearings, was plainly nervous. "There are more strong emotions and deep convictions on both sides of the issue than any issue I've seen before this committee since I've had the privilege of being its chairman," he said to begin. The House Judiciary Committee, consumed by impeachment proceedings and their aftermath, delayed holding abortion hearings until August. As the hearings opened, Bayh asked Helms if he truly meant for his amendment to render contraception unconstitutional. Helms was puzzled, even confused. Bayh attempted to explain the issue that certain methods of contraception, like the IUD, stop implantation rather than ovulation or fertilization. "Well, the chairman has expertise in this subject that I apparently don't have," Helms admitted. Belle Abzug, one of only 16 women in the 435-member House, pointed out in her Senate testimony that there was not a single woman in the Senate, and these are amendments aimed exclusively at women, which have been introduced by men and submitted to a legislative body consisting entirely of men. Bayh himself was personally opposed to abortion, and during his time in the Senate did not waver from that position. He was also overwhelmed both by the moral difficulty of the issue and by the prospect of an amendment that would have overturned a Supreme Court decision. Yet early on, long before the issue of abortion had become a partisan one, Bayh's position, moral anguish, political caution, was not an unusual one, and it also earned him at least some support from the Catholic Church and from within the emerging pro-life movement. Thomas L. Schaeffer, the dean of Notre Dame Law School, who had developed the idea that abortion violates a fetus's 14th Amendment right to due process, was appalled by the fury of the movement to which he belonged. The less vocal right-to-life people are much more quizzical about when life begins than public discussion would suggest, Schaeffer wrote to Bayh privately. Schaeffer also took this position publicly in an op-ed for the South Bend Tribune, in which he noted both that Bayh gave pro-life advocates more time at hearings and that he appeared to be personally keen for an amendment but was being careful not to push too hard or too fast. I yield to none in my opposition to legalized abortion, and in my efforts to see overruled the Supreme Court's decision, Schaefer wrote elsewhere. It is clear to anyone who has discussed this issue with Senator Bayh that he also favors substantial modification of the court's ruling, and that he is deeply disturbed at the destruction of unborn children, and that he favored an amendment but was obligated to consider it with the gravest deliberation. Bayh, however, was playing both sides, and seems to have had genuine sympathy with both sides too. He was all this time still stumping for the Equal Rights Amendment, which he had introduced into the Senate and whose ratification he hoped to take credit for. Arguably, Roe was killing the ERA. Schlafly was exceptionally skilled at translating opposition to abortion into opposition to the ERA. The ERA means abortion, she wrote in her newsletter, insisting that if ratified, the ERA would make it impossible to ban or in any way restrict abortion. But it wasn't just anti-ERA groups that linked the ERA and abortion. Now did that sometimes too. And feminist lawyers in defending abortion rights in the states tended to cite equal rights amendments, which gave fuel to ERA opponents who wanted to argue that the ERA, if ratified, could be used to advance abortion rights. Sarah Weddington, who in 1975 became president of the National Abortion Rights Action League, met with Bayh and urged him to derail the Right to Life amendments, telling him that women cannot take advantage of opportunities guaranteed under the ERA if they cannot control their fertility. Weddington was correct, and Bayh may well have agreed with her. In any event, the earliest stage of opposition to Roe ended in failure. Members had introduced an amendment to an appropriations bill that would have banned the use of federal funds for abortion. In June and again in November 1974, Bella Abzug, Shirley Chisholm, and Patsy Mink led a successful campaign to defeat it. On September 17th, Constitution Day, 1975, the Subcommittee on Constitutional Amendments decided against reporting any Right to Life amendment to the full Judiciary Committee. Bayh, in a speech to the Senate, cited as among the reasons for the subcommittee's decision the degree to which the proposed amendments would prohibit the use of certain forms of contraception. I am, and always have been, personally opposed to unrestricted abortion, Bayh would write in letters to inquiring constituents for years, quoting from his Senate speech. It is not a question of my personal views, nor the personal views of any members of the subcommittee. The question is whether we, as elected representatives, feel that amending the Constitution to impose one conception of life on all our citizens is indeed the most responsible course of action. I have concluded that it is not. Each of us must make that decision for herself or himself. The new constitutionalism. The Right to Life movement's early response to Roe v. Wade took place in the shadow of a scandal that would undo the Nixon administration. The Senate Watergate Committee, chaired by Sam Ervin, opened hearings in May 1973, after which there ensued a constitutional crisis not resolved until Nixon's resignation more than a year later. Nixon had appointed Bork as Solicitor General in 1973, and he then served briefly as acting Attorney General. In that role, he executed Nixon's order to dismiss the Watergate Special Prosecutor, Archibald Cox. But the polarized response to the Supreme Court's decision was also set against another sweeping and sometimes radical challenge to the constitutional order, generally from the left, that regularly made headlines in the late 1960s and early 1970s and contributed to the sense that the constitutional order was unraveling. A new brand of revolutionary constitutionalism had been set forth by the anti-war Students for a Democratic Society under the mantra, "Let the people decide." So many different groups seeking social change spoke in constitutional terms that in 1969, McGeorge Bundy himself had wondered whether the United States needed a new constitution. In 1971, NBC ran a television special examining both a long list of proposed amendments before Birch Bayh's Subcommittee on Constitutional Amendments and the seemingly very real possibility of a new constitutional convention. Revolutionary constitutionalism often included calls for a new kind of constitutional convention, of the sort that women would hold in Houston in 1977. In 1970, the Black Panthers called for a revolutionary People's Constitutional Convention to meet in D.C. After Howard University refused to host the convention, the plan began to fall apart. The convention, though, did take place, and if it did not draft a constitution, it did issue a series of resolutions and declarations that mainly indicted the evils of capitalism, imperialism, and racism, even as it endorsed the very basis of modern liberalism. All people from all communities have the right to write their own constitutions. In March 1972, 4,000 black delegates from all 50 states attended a black national convention in Gary, Indiana, whose leaders included Amiri Baraka, where they considered a draft of a national black political agenda that called for proportionate racial representation in Congress and a new national constitutional convention to be held within 12 months because the existing system cannot affect the changes that are necessary. It was in some ways the realization of the first colored convention held a century and a half before, in 1829. Angela Davis was there, and Betty Shabazz, and Bobby Seale, and Coretta Scott King. Shirley Chisholm, who was seeking the Democratic nomination for president, was not, and the convention elected not to endorse her. "To hell with both parties," declared Reverend Jesse Jackson in a keynote speech that brought the convention to its feet on its first day. "Cut us in or we'll cut out." But the Black National Convention was also divided and disjointed. Ethel Payne, who reported from the convention, compared it to the French Revolution and its leaders to Robespierre. On the convention's third day, Baraka chaired a session meeting in the gymnasium of West Side High School, whose purpose was to ratify the agenda. Dispensing with Robert's Rules of Order, Baraka proposed running the meeting by African consensus. But Coleman Young and the UAW-heavy Michigan delegation refused to ratify what Young called the Black Magna Carta. The Michigan delegation then walked out. The remaining delegates ratified the agenda and a series of resolutions, including one denouncing school busing and one calling for the handing over of Israel to Palestinians. At the time, 52% of Americans favored an amendment against compulsory busing, with only 33% opposed. 2 years later, 72% would favor an anti-busing amendment. "Have you ever seen the words forced busing in the Constitution?" asked protesters in Boston in 1975. The Congressional Black Caucus then publicly distanced itself from the convention, issuing instead its own Black Bill of Rights. The NAACP, reviewing the preamble of the Gary Declaration, deemed it to be not an acceptable document for the NAACP. Bayard Rustin scoffed that the entire convention had been a meaningless exercise in which nothing constructive had been accomplished. And the editor of the Chicago Defender called the convention a babble of ideologies, half-baked dilettantism, and infantile assumptions. That fall, caravans of Indians traveled from all over the country to Washington in what was known as the Trail of Broken Treaties, organized by the American Indian movement's Russell Means, Oglala Lakota, and Dennis Banks, Ojibwe. They met in Minnesota and wrote a 20-point position paper calling on the federal government to recognize its treaty obligations, return a minimum of 110 million acres of land, and honor indigenous rights. The caravans arrived as planned during the week of the presidential election, only to find that previously scheduled meetings with federal officials, including at the Bureau of Indian Affairs, had been canceled. Nearly 1,000 Indians then occupied the BIA offices, barricading themselves inside for days. In February 1973, weeks after the Roe decision, some 200 AIM activists, mostly Oglala Lakota, began occupying the Pine Ridge Reservation in the South Dakota village of Wounded Knee, where in 1890 U.S. troops had massacred hundreds of Lakota men, women, and children. Their standoff with U.S. Marshals lasted 71 days. The occupations led by AIM, combined with a call for self-determination, led to a new wave of constitution writing among Native nations, beginning in 1975 when many rewrote or amended their Indian Reorganization Act constitutions. By 1977, a stunningly courageous disability rights movement had commanded the attention of the press, too. The movement had origins in the 1960s, and in 1973 achieved a landmark success with the passage of a federal Rehabilitation Act whose Section 504 barred discrimination against people with disabilities in any program receiving federal funds, the first civil rights legislation for disabled people. Instrumental in its passage was Judy Heumann, a 25-year-old elementary school teacher who in 1972 led a protest in Manhattan that had stopped traffic. Born in Philadelphia, Heumann, who contracted polio at 18 months, had earned a master's degree in public health at the University of California at Berkeley, but had been denied a teaching license in New York on the argument that in a wheelchair she would be encumbered in a fire evacuation. She sued, and the Board of Education had settled. But by 1977, the promise of Section 504 had not been realized. The American Coalition of Citizens with Disabilities staged a nationwide protest with rallies in 10 cities and sit-ins at regional offices of the Department of Health, Education, and Welfare. At the office in San Francisco, more than 100 activists staged an occupation that lasted 26 days, even as the authorities disconnected electrical service and water. The Black Panthers, urged on by Brad Lomax, whose multiple sclerosis had confined him to a wheelchair, provided food to the protesters. After the sit-in ended, 12 activists, including Heumann, went to Washington. "I can tell you that every time you raise issues of separate but equal, the outrage of disabled individuals across this country is going to continue," she told members of Congress. "There will be more takeovers of buildings until finally maybe you begin to understand our position. We will no longer allow the government to oppress disabled individuals. We want the law enforced." The gay rights movement, too, achieved landmark successes in the 1970s, including anti-discrimination ordinances in dozens of cities. But in 1977, after Dade County, Florida passed a gay rights ordinance, following dozens of other cities, the singer and born-again Christian Anita Bryant had launched a movement that she called Save Our Children to overturn such measures. "Homosexuals cannot reproduce, so they must recruit," Bryant warned, claiming that lesbians and gay men were attempting to entice children, especially by teaching in public schools. Dade County repealed its ordinance, and other cities followed. Black power, red power, women's liberation, disability rights, environmentalism, gay rights. There seemed to be a lot of revolutions going on, all of which strengthened the growing conservative movement. During the bicentennial of the American Revolution, many Americans' views were clouded by uncertainty about the future of the United States. Constitutional mandates enacted by the federal government influenced Americans' lives in 1,000 ways, many of them involving the most intimate aspects of their world. As the political scientist and ERA activist Jane Mansbridge would remark in Why We Lost the ERA, Americans who were not participants in these movements were easily persuaded that amending the Constitution would introduce only more uncertainty into their lives. And it wasn't hard to understand why. If equal protection could mean busing white children to black neighborhoods, if due process could bar punishing people who everyone agreed had committed serious crimes, and if the penumbra of the Bill of Rights gave women a right to abortions, Mansbridge wrote, one did not have to be a certifiable paranoid to suppose that guaranteeing men and women equality of rights under the law might turn out to have substantive consequences that legislators who supported the amendment had not anticipated, and that many of them would have opposed. Who knew what an amendment might do? Justice for American Women. The call for the National Women's Conference, another revolutionary constitutional convention, began in June 1975, when Patsy Takemoto Mink and Bella Abzug traveled to Mexico City as delegates to the United Nations World Conference of the International Women's Year. The IWY, which advocated equality for men and women, but was run and dominated by men, was hobbled by dissension and disunion, and in the end it adopted an anodyne and unachievable 10-year plan of action with the goal of ending discrimination against women and girls. But to Phyllis Schlafly's great consternation, Mink and Abzug introduced legislation into Congress seeking funding to hold a National Women's Conference, which, as Mink wrote, might be one way to carry forward some of the concepts adopted at the Mexico meeting. Seeking votes, they pledged that the National Conference is not a stage for ERA or for abortion reform. This proposal had the support of Nixon's successor, the mild-mannered former football star Gerald Ford, and especially of his wife, Betty Ford, a strenuous supporter of both reproductive rights and the ERA. Do you tend to agree or disagree with Mrs. Betty Ford when she said she favors passage of the Equal Rights Amendment on women's rights? A poll asked in 1975. 70% of Americans favored passage, with only 15% opposed. The president established a national commission on the observance of International Women's Year to be chaired by the Republican feminist Jill Lepore. Furious that everyone on the commission was a feminist, Schlafly called Ruckelshaus a pro-abortionist and pro-ERAer known to many as the Gloria Steinem of the Republican Party. Schlafly derided all such status of women commissions as sows, her answer to feminists who called male chauvinists pigs. Mink and Abzug wanted to hold the National Women's Conference in 1976 to mark the bicentennial of the Declaration of Independence. And although they secured $5 million in funding from Congress, there were worries about the process, which involved a series of state meetings to elect delegates that, as one feminist warned, might stir up protests by Schlafly and ERA opponents. The bill was approved in December 1975, though Ford insisted that the state conferences not begin until after the November elections. Proponents of the Equal Rights Amendment had expected a lightning-fast ratification. When that didn't happen, they set their sights on July 4, 1976, the 200th anniversary of the Declaration of Independence. That didn't happen either. Ruckelshaus's IWY Commission published a nearly 400-page report to form a more perfect union, Justice for American Women, on July 1, 1976, just in time for the bicentennial's 4th of July fireworks over the Washington Mall and on town commons all over the country. Although the report enthusiastically endorsed the ERA, most of its discussion involved debunking claims made by its opponents that it would invalidate rape laws, end alimony, deprive divorced mothers of the custody of their children, and require all-sex bathrooms. The IWY Commission also opposed any proposed constitutional amendment denying or limiting the option of legal abortion services, and, with the exception of 3 members, endorsed Roe v. Wade. Public opinion surveys continued to report that Americans were evenly divided on an amendment banning abortions, except to save the life of the mother. Support for the ERA fell to 57%. That summer, at the Republican National Convention, Schlafly nearly persuaded the GOP to drop the ERA from its platform. Only an intervention by Ford, at the behest of GOP feminists, thwarted the effort. But Schlafly did succeed in convincing Republicans to add to their platform a right-to-life statement drafted by Jesse Helms. We affirm our support of a constitutional amendment to restore protection of the right to life for unborn children. In a remarkable shift within the party, Reagan, who as governor of California in 1967 had signed a liberal abortion law, courted the support of Catholics and the emerging Christian right by taking a strong stand against abortion. Given the strength of Reagan's support, Republican feminists could not stop the right-to-life plank, and Ford, keen to defeat Reagan for the nomination, refused to stand in its way. At the Democratic National Convention held in Madison Square Garden, Jimmy Carter, a born-again Christian from Georgia, promised to secure the ratification of the ERA, and while he opposed abortion, he pledged that he would not support a right-to-life amendment. Carter promised to do for women what President Johnson did for blacks, Abzug said. The Democrats' abortion plank was hardly a celebration of reproductive rights, venturing only that it is undesirable to attempt to amend the U.S. Constitution to overturn Supreme Court decisions in this area. But 40-year-old Texas Congresswoman Barbara Jordan, in a mint green suit, electrified the convention when she delivered a show-stopping address. She was both the first woman and the first Black American to deliver a keynote speech. "We are a people in search of a national community," she said, with a sternness that resounded across the hall. "We are attempting to fulfill our national purpose, to create and sustain a society in which all of us are equal." Carter did not inspire such awe, but he narrowly defeated Ford. And if his support for Roe was limited, he avidly supported the Equal Rights Amendment. Both he and his wife Rosalind campaigned for the ERA. A phone call from the First Lady at the request of Birch Bayh is said to have given the ERA the last vote it needed to secure ratification in Indiana in January 1977. Only 3 more states were now needed. But that spring, Arkansas, Oklahoma, Virginia, North Carolina, and Florida all very narrowly voted no. Idaho voted to rescind its earlier ratification, and even the Carters' home state of Georgia failed to ratify. On abortion, too, feminists were losing ground. "It is my view that the issue will gradually die down," Mink wrote in 1974. But it did not. In 1976, Abzug and Mink, having for 2 years defeated amendments to appropriation bills that would have barred the use of federal funds for abortion except to save the life of the mother, at a time when Medicaid was funding more than 300,000 abortions annually, lost that fight. Illinois Congressman Henry Hyde had reintroduced the measure, which passed the House 207 to 167. This amendment is inappropriate, unconstitutional, discriminatory, and cruel, said Mink in a House floor speech. And though women in the House tried to convince the Senate to defeat it, the Hyde Amendment passed. Passage of the Hyde Amendment gave the Right to Life movement hope of further gains, as if it were a harbinger of the Human Life Amendment. Congress renewed the Hyde Amendment in 1977, and in June of that year, the Supreme Court had upheld its constitutionality in a 6-3 opinion in Maher v. Roe, after Robert Bork, as Solicitor General, prepared a memo arguing that the fact that a woman has a qualified right to an abortion does not imply a correlative constitutional right to free treatment. That September, Patsy Mink addressed the 1,200 delegates to a conference of the National Women's Political Caucus meeting in San Jose. The tragedy of denial of funds for abortions under Medicaid is that we are denying women basic constitutional rights, Mink said. But in Congress, feminists didn't have the votes to defeat it, nor did they have the votes on the court. And Robert Bork's view of constitutional interpretation had found a new convert. Government by judiciary. In October 1977, a Harvard law scholar named Raoul Berger published a blockbuster called Government by Judiciary, The Transformation of the 14th Amendment. No book on the Constitution, with the possible exception of Charles A. Beard's Economic Interpretation of the Constitution, 1913, has elicited such a storm of controversy, remarked one well-positioned observer. To great acclaim and with uncanny timeliness, Berger had during the Watergate crisis published books on impeachment, 1973, and executive privilege, 1974. His work had contributed to the downfall of Richard Nixon, although as one reviewer wrote at the time, his constitutional theory appeared far more compatible with the constitutional approach of those who would have impeached Earl Warren than with that of those who would impeach Richard Nixon. He made memorable appearances testifying in Congress. In a hearing about Nixon and executive privilege in 1973, he told the Senate, "You don't need more hearings, you need more gumption. You'll be treated like office boys until you stand up and kick them in the slats." Originally a professional violinist, he'd become a professional pugilist. He'd also become an academic star and media darling, profiled in the New York Times, Newsweek, and The Atlantic. Berger was born in Russia, grew up poor in Chicago, and pursued a career as a professional violinist for decades before he went to law school in his mid-30s. Chicago law firms refused to hire Jews, but he won a fellowship to study at Harvard Law, and then, in 1938, went to Washington to work first at the Securities and Exchange Commission and then at the Justice Department. He did not begin teaching law until he was 61. Gary Wills described him as a man who has felt an outsider all his life, an intense driver with a set of grievances. A New Deal liberal who had worked in both the FDR and Truman administrations, Berger regarded segregation as a blot on our society. He nevertheless believed that Brown v. Board of Education had been wrongly decided. In doing so, he offered a full-throated indictment of judicial activism of the Warren Court and specifically castigated Warren for his failure to defer to the original intention of the framers of the 14th Amendment. The evidence, so far from being inconclusive, seemed to Berger perfectly clear. The framers did not mean for the 14th Amendment to end segregation in schools or anywhere else. To interpret the amendment in diametrical opposition to that intention is to rewrite the Constitution, Berger concluded, accusing Warren of an act of amendment. The court had thus assumed a power not granted in order to correct an evil that the people were and remain unready to cure. Such a usurpation was the very sort of thing that paved the way from Weimar to Hitler. Berger had encountered some friction in his attempt to get the book published with his longtime publisher, Harvard University Press. He'd received a detailed and perceptive and quite critical reader's report that charged him with breaking no new real ground and failing to fully support his claims. Berger takes criticism both from the left and from the right, not only with equanimity, but with a gamecock's happy pugnacity, Wills had remarked. He did more than take criticism. He welcomed it, stirred it up, egged it on. In a truly ferocious 8-page reply to his anonymous reader, in which Berger threatened to withdraw the book from the press, he laid out his argument against the two then-leading interpretations of the 14th Amendment. Jacobus Tenbrook's argument that the amendment had anti-slavery origins and therefore broader applications — Berger called this theory wishful thinking — and Alexander Bickle's theory that although the 39th Congress did not intend to end segregation, it left the amendment open-ended to allow for its possibility. Berger charged Bickle with endorsing the view that words are to mean one thing when passed and precisely the opposite a century later. Once Berger learned the identity of the reviewer, the very distinguished legal historian James Willard Hurst, he wrote him a much softer and more obliging reply. In an illuminating postscript, he revealed his broader aim in writing the book, in the form of a warning. The present generation will cheerfully concede the history and say we can't be bound by the dead hand of the past. They are for elitist rule, the highly educated plus a fortuitous warren. That is in the process of changing under the Berger impact. A few days before the book's publication date, Berger appeared in a riveting episode of William F. Buckley's Firing Line. Sitting in red vinyl swivel chairs, their black-laced shoes toe-to-toe, the two men wore matching gray suits and pale blue shirts. Buckley, leaning back in his chair, a clipboard in his lap, was at 51 at the height of his powers and irrepressibly delighted. Introducing his guest, Buckley observed that many opponents of the court's interpretation of the 14th Amendment had been unsavory segregationists and assorted anti-civil libertarians. One thinks of Dan Smoot and Alfred Evans. But quietly, however, the scholarly juices have been running, and here was a Harvard professor, the 76-year-old Berger, become apostate. The white-haired Berger came in his boxing ring best, keen to emphasize the attacks he anticipated. "I expect to be torn limb from limb," he said. Repeating the heated reply he'd made to Hearst's reader's report, he said that his historical research was both groundbreaking and irrefutable, but predicted that the academic community is going to find it very hard to face up to the facts here. As for the Dan Smoots and white citizens' councils of the world, Berger took no pleasure in their company. "I have been a lifelong liberal," he said. "I find myself in bed with people I detest." Buckley used the occasion of inquiring into the nature of Berger's dispute with other scholars to explain what would soon be called originalism. "You make a great deal in your book over the whole question of original intention," he said. "You point out that we ask this question of wills and contracts, and then you apply that method to the 14th Amendment." This was Buckley's great talent, the art of explanation. If words in a will or a contract are ambiguous, what do? You try to discover the author's intent. Why should this method not also apply to the Constitution? Buckley next drew from Berger his larger claim about the danger of government by the judicial rather than the legislative branch. "Is your objection to the distortion by the Supreme Court of the 14th Amendment a formalistic objection in the sense that you as a scholar know perfectly well that it was not intended that they should exercise these rights?" he began. "Or is it also, as a philosopher, in believing that your liberties are strategically better protected by the legislature than by the judiciary?" Berger gently objected to the question. "I don't think there's anything formal at all about insisting that the democratic system depends on representative assemblies that the people can elect and cast out, presidents that they can elect and cast out. Are you saying that we are better off giving such powers to Congress because there is reason to believe that representative democracy will better serve its people if there is a closer tie between ruled and ruler?" Berger conceded that point as an obvious truth, but allowing that Jim Crow was wrong and insisting that the Supreme Court had no right to end it while its victims had every reason to want to end it, he urged not legislation, but amendment. George Washington said, "If our constitutional system requires change, let it be by amendment." He said, "No matter how beneficial the change is, change by usurpation is the method by which every democratic system has been destroyed." Not long after Government by Judiciary came out, Berger said constitutional law professors all over the country had deemed him a moral leper. The published reviews suggest no such development. Instead, Berger's thesis was quite effectively dismantled and demolished in shrewd reviews by distinguished lawyers, legal scholars, and political scientists in Commentary magazine, calling attention to the inherent contradiction between Berger's notion that the immutable Constitution is all that protects our liberties and his view that the slightest change in constitutional interpretation calls for an amendment. The New Republic, arguing that Berger had disingenuously supposed the framers to have had meaningful intentions about a social, ideological, and even physical reality they could not have begun to imagine. The New York Times, Berger's argument fails on its own terms, for neither the text nor the history of the amendment supports his view. Political Science Quarterly, to equate a constitution with a will or a contract or a statute strikes me as a very odd thing to do. And the American Political Science Review. For each generation to apply the great principles embodied in the Constitution to new and varied objects and situations is not, as Berger believes, to make shambles of constitutional law. Rather, it is to act in the only way appropriate, to use the principles and goals of our fundamental law as directive and binding guides to our ever-changing condition as a nation. He was uniformly denounced, if not ridiculed, by historians for his fairly shocking naivete or downright ignorance of the methods, sources, and rules of evidence in historical research, including in the American Historical Review. Berger misinterprets and misuses historical evidence in Reviews in American History, castigating both his lack of nuance as a reader of history and the narrowness of his research, grounded exclusively in the published debates of the 39th Congress, the words of which he accepts throughout in absolutely literal fashion, and in the Journal of American History. Berger seems incapable of distinguishing between the artificial lawyer's convention called legislative intent and the multiplicity of social forces and individual motivations that actually produce congressional action, or of understanding that while the former is properly sought only in the official record, the latter are unlikely ever to be fully revealed there. Raoul Berger was not torn limb from limb. Mr. Berger never ducked an intellectual battle, the New York Times would write in his obituary. He spent years responding to his critics and rebuttals published in the form of 40 law review articles as well as a book. That didn't make him right, but it did exhaust his opponents. And by the end of the 1970s, for all that Raoul Berger insisted that the only way to change the Constitution was to use Article 5, nothing in his work improved the prospects of amending the Constitution. Federal financing of a foolish festival for frustrated feminists. Beginning in February 1977, some 130,000 American women participated in meetings held in all 56 states and territories to elect delegates to the National Women's Convention. Like the Black National Convention of 1972, the project harkened back to the alternative constitutional conventions of the 19th century. But no convention had ever taken place on so grand a scale. As a percentage of the U.S. population, participation in the 1977 state women's conventions was roughly equal to participation in the all-male conventions held in the 1780s to ratify the Constitution. Women from all walks of life met in hotels and civic centers and in the halls of college campuses, in meetings that were both federally funded and open to the public. Much of the funding was used to cover the travel and lodging costs of women who couldn't afford to pay their own way. Everyone was given a copy of the Ruckelshaus's Committee's report to form a more perfect union, Justice for American Women. There were audio tapes for the blind. A Spanish edition was made available, including to 600 women who met in Puerto Rico. New Jersey sent out notices folded into telephone bills. North Dakota spread the word in beauty parlors. Georgia handed out information at basketball games. From the start, conservatives warned that the project was attempting to counterfeit a national consensus in favor of the ERA, abortion, and lesbian and gay rights. James Kilpatrick called it Bella's boondoggle, a national whoop-de-doo whose purpose was to use federal tax dollars to fund, if not abortion, then the ERA. Schlafly denounced it as federal financing of a foolish festival for frustrated feminists. Each meeting was another deliberation where, unlike in state legislatures, which were almost entirely composed of men, women voted on the key constitutional issues of the day. 1,000 women showed up for Vermont's meeting in the middle of a snowstorm. Nearly 800 women out of a state population of 10,000 showed up in Alaska. 11,000 women turned up for New York's meeting in Albany and waited in line for up to 8 hours to cast ballots. At Rhode Island's conference held on the campus of Brown University, where elections were overseen by the League of Women Voters, the ERA was approved by a vote of 439 to 337, and a right to life amendment was rejected, 359 to 385. A resolution in support of lesbian and gay rights passed as well. At California's raucous 6,500-person meeting held on the campus of the University of Southern California, gay men turned up to support gay women, and that meeting too supported the lesbian and gay rights resolution. There were about 2,000 lesbians in attendance wearing all kinds of lesbian T-shirts, Schlafly wrote, reporting that gangs of lesbians whose shirts asked, "How dare you presume I am a heterosexual," had stalked conservative women and even threatened them with violence. Public opinion polls counted 1 in 5 American women as followers of Schlafly's agenda. Schlafly and other conservative women organized in advance of the meetings, forming and training IWY citizens review committees, hoping to ensure that conservative voices would be represented. Conservatives managed to defeat a handful of motions in state conferences, and they even prevailed in a few delegate elections. The Ohio Conference voted in favor of ERA, but a coalition of right-to-lifers and Stop ERAers elected a delegation in which 4 out of 5 members were conservative. In most state meetings, conservative women were vastly outnumbered, but in some states they showed up in force. And in 9 of the 56 state and territorial meetings, they prevailed. In Birch Bayh's Indiana, conservatives won 31 out of 32 delegate seats. Patsy Takemoto Mink's home state of Hawaii, the first to ratify the ERA, elected a majority conservative delegation that was also 63% Mormon, in a state in which Mormons comprised only 3.2% of the population. A Honolulu newspaper reported that the Mormon Church had sent busloads of Mormon women to the meeting. Nor did the meetings escape violence. In Montgomery, Alabama, a supporter of Schlafly walked up to a black college student who was arguing for abortion rights and slapped her in the face, shouting, "God is going to punish you." In the end, about 15% of the nearly 1,500 elected delegates opposed the ERA. At state conference after state conference, women endorsed the resolutions put forward by the national leadership, which included support for both the ERA and for abortion rights, tying the two even more closely together. This arguably achieved exactly the opposite of what Mink and Abzug had aimed for. It diminished what remained of the support among pro-life women for the ERA and strengthened the coalition between the Right to Life movement and Stop ERA. In 1975, the National Right to Life Committee had voted down an anti-ERA proposal. In 1977, that proposal passed. After the last meeting adjourned, Schlafly dedicated the entirety of the Phyllis Schlafly Report to an account of the process. Calling it a front for radicals and lesbians, she alleged that everything from the naming of the commission, which included admitted lesbian Jean O'Leary, a former nun who had founded a lesbian rights organization in New York in 1972 and led a coalition of lesbian and gay activists to a 3-hour meeting at the White House, to the elections in the states, coordinated by a staff that was 100% pro-ERA, had been rigged. Having persuaded the Right to Life movement to oppose the ERA, Schlafly's next piece of business would be to ensure that the GOP fell in line with her anti-ERA, anti-abortion agenda. But first, she went to Houston. 2468, ratify in every state. On the stage, behind Rosalind Carter, Betty Ford, and Lady Bird Johnson, a green banner reading, "Woman," had been draped across a blue curtain as the National Women's Conference opened on Saturday morning, November 18th, 1977. On the floor, women waved signs naming their delegations and wore emblems to designate them. New Yorkers carried apples. Californians wore gold bandanas. Puerto Ricans wore jibaro hats. Runners in tube socks and sneakers arrived bearing a torch that had been carried runner by runner all the way from Seneca Falls for 2,600 miles and across 14 states, while by the side of the road, women and girls gathered to chant, 2468, ratify in every state. The head of the Girl Scouts called the meeting to order with a gavel once used by Susan B. Anthony. Presiding officer Bella Abzug, in a floppy brown felt hat, gave the opening address, her half-moon glasses sliding down her nose, as she called on the delegates to make American democracy what it should have been 200 years ago. Barbara Jordan delivered the keynote and did not disappoint. "Women are human," she said, hunched over the podium, "and humans need human rights. The cause of equal and human rights will reap what is sown November 18th through November 21st, 1977, she said, charging her audience with a solemn duty. What will you reap? What will you sow? The organizers had presented a plan of action of 26 planks, each to be introduced by a hand-picked delegate. Before the voting, they met in caucuses, including minority caucuses, an African-American caucus, a Hispanic caucus, an Alaskan Native caucus, an Asian and Pacific American caucus, and more. But delegates objected to being ghettoized, and their objections to the plan of action's lack of attention to their interests proved to be the most powerful and lasting critique. They formed a coalition minority caucus, whose leader, Maxine Waters, introduced an amended plank that passed by voice vote. A Republican mother of 8 introduced the reproductive freedom plank. Sarah Weddington spoke on abortion. Conservative women got little speaking time, but during that debate, the National Right to Life Committee's Ann O'Donnell, a delegate from Missouri, argued against the plank, which she considered a betrayal of feminism. If we do not drive this flaw from what is called the feminist movement, this flaw would be responsible for the death of the women's movement. Over the protests of pro-life women who held up giant posters of fetuses, the reproductive freedom plank passed 5-1. On Saturday evening, in time for primetime television, Ann Richards, a rising star in Democratic Texas politics, introduced the most important plank of the conference. The Equal Rights Amendment should be ratified. When the resolution passed, the crowd went wild, chanting, "Ratify the ERA," and to the tune of "The Yellow Rose of Texas," singing, "The ERA was passed today." The next day, to the surprise of many, the irascible grande dame of second-wave feminism, Betty Friedan, endorsed the lesbian and gay rights plank, and it too passed. Of the 26 original resolutions, only one, calling for a cabinet-level Department of Women, failed. Conservative women had been doubtful about holding their own conference, a kind of anti-conference. Schlafly had initially opposed the idea, favoring disrupting the main conference instead. But Lottie Beth Hobbs from Texas, and head of Women Who Want to Be Women, expected to be able to bring a big enough crowd to Houston to make a strong showing. Over at the pro-life, pro-family rally, buses arrived from all over the country. Many women brought their children. Unlike the National Women's Conference, which was remarkable for its racial and ethnic diversity, the pro-life, pro-family rally was overwhelmingly white. It also had the character of a religious revival. Looking back, it marked not the triumph of feminism, but the rise of the new right. For all the jubilation of the thousands of women who gathered in Houston in November 1977, for the largest constitutional convention in American history, that gathering represented the high point of the campaign for the Equal Rights Amendment. Indiana's ratification proved to be the last. Nor did any other amendment make headway. Birchbuy's subcommittee on constitutional amendments died. James Eastland, in one of his last acts as chair of the Senate Judiciary Committee before resigning in 1978, dissolved it. Partly this was a result of efforts to modernize the Senate, and partly it was a result of the Legislative Reorganization Act of 1977. Also, the chair of the Subcommittee on Constitutional Rights hadn't been reelected, so Eastland decided to merge it with Buy's old subcommittee, dubbing the new one the Subcommittee on the Constitution. Of the constitutional amendments still under consideration in Congress, abolishing the Electoral College had by far the broadest popular support, polling with 73% approval, compared to the ERA with 57%, an anti-busing amendment 51%, and an anti-abortion amendment 33%. Buy finally got his Electoral College amendment out of committee again in the summer of 1979, but on the Senate floor it was defeated 51-48. Southerners and Reagan conservatives voted against it, but so did liberals, responding to pressure from civil rights organizations. Patsy Takemoto Mink, who left the House to seek a seat in the U.S. Senate, was defeated. In 1979, Carter fired Bella Abzug. In 1980, she managed to get planks supporting both gay rights and federal funding for abortion onto the Democratic Party's agenda. At the GOP convention, Schlafly controlled the agenda, and both Reagan and his vice presidential choice, George H.W. Bush, both of whom had earlier supported both abortion and the ERA, opposed them. Jesse Helms drafted a GOP platform that drove feminists from the party. But in November, Reagan defeated Carter in a landslide for which the pro-life movement fairly took credit. Republicans, who had not held a majority in either the House or the Senate since 1954, took back the Senate and gained seats in the House, where, as Patsy Takemoto Mink wrote in a note, 51% of the House are regarded as conservative. Feminists fought for the ERA till the bitter end. For years, it had needed only 3 more states. In May 1982, 7 women in Illinois went on a hunger strike to try to convince the legislature to pass it. And in June, 17 people chained themselves to the Illinois Senate chamber. Opponents of ERA protested the protesters by eating candy bars in front of them. Police arrived to remove the fasters with bolt cutters. On June 22nd, when the Illinois legislature voted, the ERA failed to achieve the required supermajority by only 4 votes, even though polls showed that 62% of Illinois voters supported it. With delight, Schlafly announced that the ERA had gone the way of the child labor amendment. In 1982, having failed ratification by the required number of states by the 10-year deadline, the ERA was declared dead. Efforts to get it out of Congress all over again came to a vote in the House the next year, but it was defeated 278 to 147, 6 votes short of 2/3. By then, the pro-life movement had given up on constitutional amendment. No one could get a constitutional amendment passed in this particular America. Opponents of abortion began to look instead to the courts. For this campaign, they did not look to the constitutional theorizing of Robert Bork or Raoul Berger. They looked to a whip-smart Catholic judge from Queens. Chapter 13. The Constitution is Dead. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms when serving in the militia shall not be infringed. Amendment to the Second Amendment, proposed by retired Supreme Court Justice John Paul Stevens, 2018. Bushy-browed, pipe-smoking, piano-playing Antonin Gregory Scalia, Nino, the scourge of the left, knew how to work a crowd. He loved opera, he loved theater, he loved show tunes. In high school, he played the lead role in Macbeth. I have no spur to prick the sides of my intent, but only vaulting ambition. Act 1, Scene 7. As clever as he was combative, Scalia, short and stocky, was known too for his slightly terrifying energy and for his eviscerating sense of humor. He studied Greek for 5 years, Latin for 6. He loved nothing better than a dictionary. He fished and hunted, turkeys and ducks, deer and boar, alligators. He played tennis. He argued to win. He seemed to read more, to write more, even to say more than anyone else on the federal bench. He was one of the Supreme Court's sharpest writers ever, and he was among its severest critics. It's hard to get it right, he'd tell his clerks, sending back their drafts. They had that engraved on a plaque. Few justices have done more to transform American jurisprudence, not only from the bench, but also from the seminar table, the lecture hall, and the eerie velveteen intimacy of the television stage. He gave one speech so often that he kept its outline scribbled on a scrap of paper, tucked in his suit pocket. The Constitution is not a living document, he'd say. It's dead, 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 dead. Antonin Scalia was the first professor to be nominated to the Supreme Court since Felix Frankfurter. He'd been a judge for only 4 years. Most of his published writing consisted of law review articles and speeches, not opinions from the bench. He grew up in Queens, the only child of an Italian immigrant who'd become a professor of Romance languages. He inherited his first gun from his grandfather, who grew up hunting in Sicily and used to take little Nino to Long Island to shoot rabbits. As a kid, he played street hockey on roller skates. A devout Catholic, he attended a Jesuit military school where he was on the rifle team. He used to ride the subway from Queens to Manhattan, carrying his .22 carbine target rifle. When I was growing up in New York, people weren't afraid of people with guns, he'd say. He went to Georgetown and then to Harvard Law School. In the 1960s, he was a Goldwater conservative. He served in the Nixon and Ford administrations and taught on the law faculty of the University of Virginia and the University of Chicago before Reagan appointed him to the D.C. Court of Appeals in 1982. On the first day of his confirmation hearing, he was welcomed by the 83-year-old committee chair, Strom Thurmond, a one-man timeline of the political and constitutional history of the 20th century. Thurmond had been a Democratic governor of South Carolina, the Dixiecrat Party's 1948 presidential candidate, a drafter of the Southern Manifesto, and after 1964, when he endorsed Barry Goldwater, a Republican. No one in the U.S. Senate had more fiercely fought for segregation and against civil rights, or more expansively used Judiciary Committee meetings to advance a doctrine of original intent. That the elderly Thurmond had become a standard-bearer for a Republican Party headed by Ronald Reagan suggested just how far the GOP had shifted to the right. And nothing better illustrated the journey that the doctrine of original intent had taken from the 1950s to the 80s than the contrast between Thurmond's interrogation of Thurgood Marshall in 1967 and his welcoming of Antonin Scalia in 1986. "You've got a lot of children there," said the South Carolina senator affably. "I believe you have 8 of them here?" Scalia, 50, was a father of 9. "All 9 are here," he told Thurmond, beaming. "I think we have the full committee." Thurmond counted himself as having 4 children, but in fact he had 5. Only after his death at nearly 101 in 2003 would a 78-year-old black retired school teacher, Essie Mae Washington Williams, reveal that Strom Thurmond was her father. He'd gotten her mother pregnant in 1925, when she was 15, and working for his family as a maid. Thurmond had very few questions for Scalia. He did ask him about the difference between serving on a circuit court and on the Supreme Court. "There's no one to correct your mistakes when you're up there," Scalia answered, "except the constitutional amendment process." That process was by then no more than a chimera. Members of Congress had proposed more than 2,100 constitutional amendments between 1980 and 2020. Congress, more polarized with each passing year, approved none. In roughly that same stretch of time, state legislatures introduced almost 5,000 amendments and passed nearly 4,000. Even the states, though, were getting sheepish. Rhode Island's Constitutional Convention in January 1986 would be the last full-dress constitutional convention held in any American state. The more difficult it became to amend the Constitution, the more politicized were nominations to the Supreme Court. Scalia's, though, was a breeze, partly because liberals had decided to focus their efforts at questioning the elevation of William Rehnquist to the Chief Justiceship. Also, Scalia was witty. He was charming. He had been exceptionally well briefed. Aides had peppered him with questions in practice sessions and provided him with memos with titles like "Likely Areas of Interest Arising Out of Your Writings," warning him about Roe v. Wade. "You've probably said a little more on this topic than you think." In 1978, Scalia had said that in his view, the Supreme Court, in cases like Roe, had found rights where society never believed they existed. In a typed, numbered list in Scalia's briefing packet titled Talking Points, number 1 was abortion. Scrawled below in black ink were 2 tips. 1, professional, not adversarial. And 2, don't get sucked in. Thurmond, after a friendly chat with the nominee, yielded the floor to Edward Kennedy, who, without so much as a hello, jumped in. Kennedy: "Judge Scalia, if you were confirmed, do you expect to overrule Roe v. Wade?" Scalia: "Excuse me?" Scalia had also been advised by the White House that senators had been frustrated by the answers provided by Sandra Day O'Connor during her nomination hearings. When asked about Roe v. Wade, she gave answers that some senators found to be non-responsive. Scalia would have to tread carefully. Roe was the new Brown. Up until O'Connor's appointment in 1981, the pro-life movement had remained unwavering in its dedication to overturning Roe with a constitutional amendment. It had placed many on the table, starting in 1972. Jesse Helms introduced a human life bill into the Senate in 1981. It would have declared life to begin at conception. Still, the pro-life movement had pursued other avenues to end or limit the practice of abortion, including by restricting the use of federal funding and making abortion more difficult to obtain in the states by imposing waiting periods, consent requirements, and all manner of obstacles. There was one other way to overturn Roe. In 1980, the GOP had vowed in its party platform to appoint judges at all levels of the judiciary who respect traditional family values and the sanctity of innocent human life. Reagan, in his 2 terms in office, would appoint more than 400 federal judges, amounting to half the federal judiciary, more than any other president in history. All were screened for their views on abortion. Reagan's administration had other influence on the judiciary as well. Later Supreme Court Justices Roberts, Thomas, and Alito all worked in the administration. Screening judges for their views was at the time both novel and controversial. Members of Reagan's Justice Department defended the practice by insisting that they were screening instead for originalism, which they then described as the only legitimate method of judicial interpretation. As an assistant attorney general put it in a memo to the attorney general, the idea of original intent must not be marketed as simply another theory of jurisprudence. Rather, it is an essential part of the constitutional framework of checks and balances, emphasizing that, contrary to allegations, we are not choosing judges who will impose a right-wing social agenda upon the nation, but rather those who recognize that they, too, are bound by the Constitution. All seemed to be going as planned. In 1981, Reagan appointed Robert Bork to the D.C. Court of Appeals. Roe v. Wade is an unconstitutional decision, a serious and wholly unjustifiable judicial usurpation of state legislative authority, Bork said at his confirmation hearings. To opponents of abortion, O'Connor's hearings were far less reassuring. O'Connor, at 51, said she was personally opposed to abortion, but then added, "I am not going to be pregnant anymore, so it is perhaps easy for me." This response had alarmed pro-lifers and greatly contributed to the movement's decision to abandon constitutional amendment in favor of influencing the nomination process. The intensity of right-to-lifers on the issue of judicial power should not be underestimated, a Reagan advisor reported. Ronald Reagan, Phyllis Schlafly, and Republican strategists hoped to make the GOP the party of the pro-life movement as a way to expand the party's base, bringing in Catholics and white evangelicals. Part of the process of party realignment that had begun under Nixon in 1968, it happened very slowly. Not until 1979 were Republican members of Congress more likely to vote against abortion than Democrats. That year, Jerry Falwell founded the Moral Majority, and a new evangelical Christian right joined the moral crusade against abortion. Only after Republicans in Congress began aligning with their pro-life movement did the rest of the party follow. But again, only gradually. Republicans were more pro-choice than Democrats until at least 1990. Only during Reagan's presidency did this effort begin to involve attacking the legitimacy of the court's decision in Roe. During the confirmation hearings for John Paul Stevens in 1975, the first justice named to the court since Roe and by a Republican president, replacing the most liberal justice, William O. Douglas, no one asked him even a single question about Roe. That would change under Reagan. Reagan's courting of the new right proved crucial to his landslide re-election in 1984, after which he appointed Edwin Meese as his Attorney General. Meese's Justice Department would soon fill up with young lawyers who were members of a new organization known as the Federalist Society, formed in 1982 by law students at Yale, studying with Professor Bork, and at the University of Chicago, studying with Professor Scalia. Keen to avoid the word conservative, they chose instead to emphasize the original intent of the framers, and in naming the organization honored both the original Federalists and a Reagan doctrine known as New Federalism, which sought to transfer power from the federal government to the states. They also adopted a decidedly non-original silhouette of James Madison as their logo. Bork's son found the nose on the actual Madison too ugly. Their first meeting at Yale in April 1982 featured 20 speakers, all white male academics and judges, including Bork and Scalia. Some Yale law students perceived the meeting to be hostile to both reproductive rights and civil rights. 2 years earlier, an underground feminist organization, sneaking into the law school at night, had hung paper plates on which were drawn women's faces over the faces of portraits of Yale faculty, all aging white men. The Federalist Society was a reaction. In 1982, a poster objecting to the Federalist Society symposium warned, "New federalism means old bigotry. Support civil rights." Mary Dudziak, a second-year law student, picketed. She carried a handwritten sign with the feminist slogan, "If men could get pregnant, abortion would be a sacrament." Soon after Meese took office in 1985, he announced that the official policy of the Reagan Justice Department would be to pursue a jurisprudence of original intention as the only legitimate and properly democratic method of constitutional interpretation. Meese, who hired the founders of the Federalist Society and trained them up as a farm team, aimed to sell originalism not only to the legal community, but also to the public, as a modest and humble deference to the wisdom of the framers, in contrast to the unrestrained imperiousness, the judicial oligarchy of the Supreme Court. This strategy raised liberals' hackles, and it raised historians' hackles too. Justice William Brennan, in a speech delivered at Georgetown, called the doctrine of original intent arrogance cloaked as humility, and speculated that proposals endorsing the idea must inevitably come from persons who have no familiarity with the historical record. What really rankled was Meese's claim that original intent was democratic, since it was quite clear that having failed in their efforts to amend the Constitution, conservatives had changed course, instead using judicial selection to pursue objectives they could not achieve by democratic means. The aim is now to accomplish in the courts what the administration failed to persuade Congress to do, namely adopt its positions on abortion, apportionment, affirmative action, school prayer, and the like, wrote the political scientist David O'Brien in the Los Angeles Times. Nor did Meese's jurisprudence escape censure as realpolitik. Mr. Meese's version of original intent is a patent fraud on the public, wrote the historian Arthur M. Schlesinger, Jr. in the Wall Street Journal. The Attorney General uses original intent not as a neutral principle at all, but only as a means of getting certain results for the Reagan administration. He is shamelessly selective. He was also undeniably effective. Before Reagan moved into the White House, the pro-life movement had not been especially interested in originalism, on the theory that there is no right to life in the Constitution any more than there's a right to privacy. But after Reagan pledged to use opposition to Roe as a litmus test in appointing federal judges, litigation seemed a far better approach than amendment. In 1984, Americans United for Life held a conference called Reversing Roe v. Wade Through the Courts. 2 years later, NARAL observed in a report on the Scalia and Rehnquist nominations that the pro-life movement, having failed to amend the Constitution, had turned to a legislation-litigation strategy. How this played had become clear. In 1985, an oral argument in Thornburg v. American College of Obstetricians and Gynecologists, a challenge to the constitutionality of a Pennsylvania law drafted by Americans United for Life, the Meese Justice Department directed Acting Solicitor General Charles Freed to ask the court to overturn Roe and to base the government's argument on original intent. Freed obliged. A young Samuel Alito, working in the Office of Legal Counsel and having stated his opposition to abortion in his application for the position, worked on the brief. There is no explicit textual warrant in the Constitution for a right to an abortion, Freed's brief read. It is true, of course, that words, and certainly the words of general constitutional provisions, do not interpret themselves. That being said, the further afield interpretation travels from the point of departure in the text, the greater the danger that constitutional adjudication will be like a picnic to which the framers bring the words and the judges the meaning. And offering a statement of method, he asserted that constitutional interpretation retains the fullest measure of legitimacy when it is disciplined by fidelity to the framers' intent, as revealed by history. Freed's brief, which asked the Supreme Court to take away a constitutional right, elicited a storm of protest, including from 4 former Solicitor Generals. Only narrowly did the court decide against overturning Roe. On June 11, 1986, the court issued its decision in Thornburg, declaring Pennsylvania's law unconstitutional in a 5-4 decision in which Warren Burger, who had joined the majority in Roe, now dissented. 6 days later, he announced that he was resigning to devote himself to the celebration of the Constitution's bicentennial. And so it had come to pass that in August 1986, Antonin Scalia sat before the Senate Judiciary Committee and stumbled over Senator Kennedy's question. "Excuse me?" Kennedy repeated the question. "Do you expect to overrule Roe v. Wade?" Scalia said it would be improper to answer a question about any case that he might one day have to act on. Thurmond interrupted to bolster that position. "I agree with you." Kennedy had been stalling for time, waiting for the committee's ranking Democrat, Joseph Biden, the junior senator from Delaware, to arrive from another meeting. First elected to the Senate in 1972 when he was not yet 30, Biden sought a national stage, but when he got it, he often talked for too long and without making a great deal of sense. "Obviously, I don't know what the hell I'm talking about," he once said in the middle of remarks at the Judiciary Committee. Biden, who had lost his first wife and young daughter to a tragic car accident just before taking office, was a devout Catholic, but he was opposed to a constitutional ban on abortion. In 1983, he had considered making a play for the 1984 Democratic presidential nomination. He would make his first bid in 1988. As Scalia's briefing materials warned, Biden had gradually lived down his early reputation as an enfant terrible and positioned himself to be an influential Democrat for decades to come. Biden was affable, goofy even, and Thurman liked working with him so much that he called him "my Henry Clay." Biden and Scalia had much in common. Gregarious and animated Catholic middle-aged men from industrial eastern cities with young families and thinning hair and big dreams and funny jokes, though Scalia's humor was more studied. He once famously began an opinion with this sentence: "This case involving legal requirements for the content and labeling of meat products such as frankfurters affords a rare opportunity to explore simultaneously both parts of Bismarck's aphorism that no man should see how laws or sausages are made." Biden gave the judge his wide smile, told him he'd read all the speeches of his that he could find, wished he'd had him as a professor, and said he was pretty damn interested in this newly enunciated doctrine of original intent. He began by asking Scalia about a speech he'd given 2 months before at a conference hosted by Mies days after the court's decision in Thornburg. Scalia had known when he delivered that speech on June 14, 1986, that he was being considered for a position on the court. Warren Burger had visited the White House on May 27th to tell Reagan he intended to retire and to give him a list of possible replacements for the Chief Justiceship, including Scalia and Bork. By June 12th, Reagan had decided to nominate Rehnquist for the Chief Justiceship and leaned toward replacing Rehnquist with Scalia, mainly because he was nearly a decade younger than Bork, though there was some concern about his temper. Scalia was scheduled to meet with the president on June 16th. Scalia, the wise guy, started out his speech with a long setup for a joke about how he'd been trying to figure out something he could say that would be sufficiently obnoxious, and an angel, who sounded a bit like Robert Bork, had dared him criticize the doctrine of original intent. Riffing on the flap between Mies and Brennan, Scalia cataloged the weaknesses of the doctrine of original intent, including by pointing out that the early Supreme Court could not possibly have followed it, since Madison's notes were not available until 1840. What people who talked about original intent must mean, then, Scalia argued, essentially offering Mies a way out of the box he'd locked himself in, and for which Brennan had thrown away the key, was not the original intent of the framers, but of the Constitution. It is not that the Constitution must mean this because Alexander Hamilton thought it meant this, and he wrote it, but rather that the Constitution must mean this because Alexander Hamilton, who for Pete's sake must have understood the thing, thought it meant this. The doctrine of original intent, Scalia concluded, just needed a better name. He proposed the doctrine of original meaning. Biden, noting Scalia's reputation as a provocateur and a devil's advocate, seemed baffled by the distinction between original intent and original meaning. Scalia, guarding his words, said he'd be happy to explain the distinction, but it wouldn't be worth it since it's not a big difference. Scalia did say that he was averse to the idea of a living constitution, but he managed to evade most other queries. As for that June speech, Biden told Scalia wearily, "I just hope you do not mean it." Scalia did mean it. He spent 30 years on the Supreme Court. He didn't live to see Roe overturned, but he would have been gratified by the court's 2022 opinion, written by Samuel Alito, Dobbs v. Jackson Women's Health Organization, in which the majority determined that the Constitution makes no reference to abortion and no such right is implicitly protected by any constitutional provision. 2 years later, 2 award-winning journalists would explain the fall of Roe, the nod is to the fall of Rome, as the result of a vast right-wing conspiracy, writing about how secretly an elite strike force of Christian lawyers and power brokers orchestrated a campaign to end abortion rights and remake American womanhood. There was no secret elite strike force. There was no conspiracy. There was only electoral politics social movement organizing, and the inevitable consequences of the abdication of amendment in favor of the Constitution as scripture and the court as its priests. Kicking the amendment habit. Originalism in the 1970s and 80s, which is sometimes referred to as the old originalism, was an outsider's game. Like the progressives who criticized the conservative court of the Lochner era, originalists criticized the Supreme Court for judicial overreach, charged the justices with amending the law, including by creating new rights, and insisted not only that Article 5 amendment is the only legitimate method of constitutional change, because it is the only democratic method, but also that originalism is the only legitimately democratic method of constitutional interpretation, because it shackles judges and justices to the writings of delegates and representatives elected to the Constitutional Convention, to ratifying conventions, and to Congress. This position turned out to be untenable once originalists gained power in the Justice Department and on the Supreme Court. From the start, though, originalism, which aligned with social conservatism, had existed in some tension with actual proposals for constitutional amendment, especially with fiscal conservatives' interest in seeking constitutional change through a constitutional convention called by the states. Constitutional conservatives had now and again called for constitutional conventions since the days of James Montgomery Beck. Among their more notable efforts was a campaign in 1939 to call a convention to repeal the 16th Income Tax Amendment, and for the entirety of the Warren and Burger courts, there had been calls for a convention in the 1950s to overturn Brown v. Board, in the 1960s to repeal reapportionment, and in the 1970s to secure a balanced budget amendment. The 1960s push had nearly met with success, but that near success had led to dire warnings by political opponents and some legal scholars of unforeseeable and unknowable dangers of what people had, by now, taken to calling a con. Because no federal constitutional convention had been held since 1787, no one knew quite what to expect, and efforts in Congress to establish rules for any such convention had met with defeat. The concern was not so much with a so-called limited convention, a convention to consider one or more specific amendments, but with the possibility of an open or runaway convention, which, after all, is what the Convention of 1787 had been. Delegates to that convention, charged only with the task of amending the Articles of Confederation, had scrapped them entirely. Might not the same thing happen again? In 1963, Charles Black, a distinguished constitutional scholar who had written crucial briefs in Brown v. Board, wrote an influential article in which he warned that, given the states' rights backlash against Brown, amendments put forward at a constitutional convention would return us to a confederacy. Nevertheless, by 1967, in an effort led by Everett Dirksen, Congress had received 32 out of the needed 34 state petitions calling for convention to amend the Constitution to allow states to apportion representation in one chamber on a basis other than population. The campaign stalled when members of Congress questioned whether all the petitions had been properly drafted or remained in force and could be counted, and when Dirksen died in 1969, the apportionment convention movement died with him. The idea for a balanced budget amendment had been floated in the 1950s by the Campaign for the 48 States, but only really took hold during the economic malaise of the 1970s as a response to rising federal debt and unchecked federal spending, and earned broader support during the Great Tax Revolt of 1975. Interest accelerated in 1978 when California voters ratified a constitutional amendment known as Proposition 13, limiting the state's property tax. Patsy Takamoto Mink reported in an Americans for Democratic Action newsletter that the political climate is stirred by backlash against government programs, government spending, and government regulation, and that liberals, having expended their energies on single issues from abortion rights, gay rights, gun control, to Proposition 13 and the ERA, have little time left over in which to organize against the attack. By 1979, 28 states had called for a convention to adopt a balanced budget amendment. In The New Yorker, the celebrated but ailing Washington correspondent Richard Rovere predicted that Congress would pass the balanced budget amendment, which would then become the 28th Amendment, except in the improbable event that an anti-abortion or an equal rights amendment is adopted earlier. Rovere, who died later that year, believed that the convention call was a bluff as presumably it had been in 1911 and 1912, when the states managed to convince the Senate to pass the 17th Amendment, and that Congress would pass the standalone amendment in order to avoid the terrifying prospect of a convention. It is at least theoretically possible that another convention could reinstate segregation and even slavery, Rovere wrote darkly. Sounding the alarm that had been sounded in 1963 by Charles Black, Rovere warned that a convention might throw out much or all of the Bill of Rights, free speech, free press, separation of church and state, the prohibition against unreasonable searches and seizures, eliminate the 14th Amendment's due process clause, and reverse any Supreme Court decision the members didn't like, including one man, one vote rule, and perhaps for good measure eliminate the Supreme Court itself. Rovere thought a convention could lead, possibly even to civil war. Any amendments proposed in a convention would still have to be ratified by 3/4 of the states, a break on change, not mentioned by Rovere, which makes the degree of this panic difficult to understand, except insofar as liberals in these decades were far more committed to constitutional change through the courts than through amendment, with the notable exception of the ERA. Still, it was not unreasonable to fear that, as had been done in Philadelphia in 1787, a convention could also change the rules for ratification. Soon after Rovere's piece appeared in The New Yorker, Gallup conducted a nationwide poll asking Americans whether, in the event of a con, they would favor or oppose 6 amendments that might be proposed at such a convention. 65% of Americans favored a convention. Liberals, who could still be found in both parties, had good reason to oppose a convention because, if the polls were right, they would have won on ERA, which they expected to win without a convention, but they would have lost on government spending, prayer in schools, and school busing, and they would have rolled the dice on abortion, a subject about which, in any event, liberals did not at that point hold strong or inalterable views. The control of handgun sales was, in 1979, even less of a strictly partisan issue. That, too, would come later. For both fiscal and social conservatives, a convention looked more promising. After the Gallup results were published, the American Enterprise Institute convened a panel discussion on the subject of a constitutional convention. How well would it work? To which they invited University of Chicago law professor Antonin Scalia. Asked whether the prospect was really all that dangerous, Scalia joked that it was always possible a constitutional convention would eliminate Christmas or pass a bill of attainder to hang Richard Rovere, but he said he wasn't too worried about it, and that he was willing to accept what seems to me a minimal risk of intemperate action. He agreed that there was no way to know how a convention would behave, but asked, "What is the alternative?" The alternative is continuing with a system that provides no means of obtaining a constitutional amendment except through the kindness of Congress, which has demonstrated that it will not propose amendments, no matter how generally desired, that would limit congressional power. The panel discussion offers an interesting glimpse of Scalia before he became a judge and before he became an originalist. When Paul Brest coined the term originalism in a Law Review article in 1980, he did not mention Scalia. Instead, he cited Raoul Berger. Scalia liked to say he had been born an originalist and that the whole purpose of the Constitution was to prevent change. More accurate would be to say that his originalism was born out of his frustration over social conservatives' inability to amend the Constitution by Article 5, and liberals' success at doing so by judicial interpretation. "It is not as though we have a sacrosanct, untouched Constitution," he said during that con discussion in 1979. "The Constitution has been changed, whether we've liked it or not, during the last 200 years, and not merely by the ratification process. Many of the decisions of the Supreme Court have made fundamental alterations without giving us any opportunity to say whether we like them." He didn't like Roe. Nobody in his right mind would want an open convention, he said. But under the circumstances, he'd run that risk for one purpose only, for a convention on abortion. One person who was decidedly unwilling to run that risk was Phyllis Schlafly. Schlafly must have found the results of that Gallup survey horrifying. A convention called for a balanced budget might undo all her work to defeat the ERA, since it could reintroduce and ratify it. Like Rovere, she believed that holding a convention was like playing a constitutional game of Russian roulette. After all, she had only just reported on that extra-constitutional convention in Houston in 1977, where thousands of women elected in meetings held in all 56 states and territories had endorsed an agenda that she despised, including not only the ERA but also gay and lesbian rights and reproductive rights. And now her fellow conservatives wanted to call an Article 5 convention? Schlafly, who had a conspiracy theorist's view of the world, grew more concerned in 1981 when the liberal Gore Vidal, who was among many other things an advocate of sexual freedom, came out in favor of a convention in a provocation in the New York Review of Books. There is more than the usual amount of irony in the fact that our peculiar Constitution is now under siege from those who would like to make it either more oppressive, the right to lifers who want the Constitution to forbid abortion, or from those sly folks who want to make more and more money out of their real estate shelters, Vidal wrote. But no matter what the motive for change, change is now very much in the air, and that is a good thing. Vidal, Schlafly warned, had let the cat out of the bag. Liberals planned to take over the convention, to overthrow the Constitution itself. In 1982, the year the ERA's extended ratification window closed, the Senate passed the Balanced Budget Amendment, which Reagan endorsed, but the House, which held the purse strings, voted it down. By then, 32 states had called for a convention, which would have opened up that ERA window all over again. After we buried the Equal Rights Amendment for the second time, Schlafly later said, we then discovered that there was this silly effort to plunge us into a new constitutional convention. Deploying the infrastructure she'd used to defeat the ratification of the ERA in the states, she went to war to stop any more states from calling for a convention. We had knockdown, drag-out battles just like ERA in Kentucky, Michigan, New Jersey, and Montana, and we beat them, she said. Aside from defeating the ERA and making the Republican Party pro-life, she considered defeating the con in the 1980s her signal achievement. Herein lie the origins of Antonin Scalia's originalism. Faced with an activist, liberal Supreme Court, conservatives considered their very limited options. Social conservatives couldn't get a right-to-life amendment through Congress. Fiscal conservatives couldn't get a balanced budget amendment through the House. Social and fiscal conservatives disagreed about holding a constitutional convention. It was in this context that Antonin Scalia became attracted to originalism, and it was at this moment that the Federalist Society was founded. Originalism did not arise from a belief that amendment was the only democratic way to change the Constitution. It arose from the failure of conservatives to change the Constitution by democratic means. An inherent, fundamental, and inalienable right to exist and thrive. Skittishness about a federal constitutional convention had a knock-on effect. A not unusual number of states held conventions in the 1970s and early 80s. Montana, North Dakota, Tennessee, 1971, Louisiana, 1973, New Hampshire, Texas, Tennessee, 1974, Hawaii, Arkansas, 1978, New Hampshire, 1984, and Rhode Island, 1986. But with the alarm about runaway conventions and a loss of public faith in democratic deliberation, states grew skittish about holding constitutional conventions too. Louisiana's limited and failed, not quite convention in 1992 was the last. Mandated ballot questions asking voters whether they would like to hold a convention appeared regularly on ballots in states across the country. Voters kept answering no. Under the terms of New York's 1846 Constitution, for instance, voters are asked every 20 years, Jefferson's preferred once a generation, whether to hold a convention. New York had earlier held conventions in 1801 and 1821. Voters saying yes led to conventions in 1867, 1894, and 1938, and the legislature itself called for a convention in 1967, but voters said no in 1957, 1977, 1997, and 2017. Scholars started talking about convention phobia. The abandonment of the practice of citizens convening to deliberate over their state constitution and whether it needed amending or replacing reflected a decline in other forms of democratic participation too. Deliberating is a muscle that can easily atrophy. The less frequently people meet and debate, the less able they are to do so. In a public opinion survey conducted in 2016, 40% of Americans agreed with the statement, "I have lost faith in American democracy." More than 2/3 agreed that you need to be very careful in dealing with people, with only 31% agreeing that most people can be trusted. Strikingly, while the states abandoned the practice of constitutional convention, it thrived among Native nations, who gained faith in deliberative democracy as non-natives lost that faith. Between 1970 and 2023, Native American nations held more than 126 constitutional conventions. Many replaced constitutions they'd earlier adopted in 1934 under the Indian Reorganization Act. Many others wrote new constitutions in the wake of efforts begun in 1973 to restore the rights of the more than 9 tribes whose federal status had been terminated during the termination era. A number of people initiated efforts to address Indians' ambiguous relationship with the U.S. Constitution. In 1980, Russell Barsh and James Sackage Youngblood Henderson, Chickasaw, proposed an 8-part constitutional amendment clarifying the status of Indian tribes, defining them as states for all purposes, asserting limited sovereignty, all constitutional powers of state self-government not hereafter expressly delegated to the United States by the vote of 3/4 of the members of an Indian tribe are reserved by that tribe and cannot be divested by Congress, and providing for a tribal Senate caucus of 1 delegate from each tribe and a tribal House caucus of 1 delegate for every 5,000 members of every tribe. 2 senators and 2 representatives would serve as well in the U.S. Senate and House. This proposal met a quiet death. Decades later, the condition of Native nations under the U.S. Constitution remained as ambiguous as it had been when Vine Deloria Jr. first testified before Congress in 1965. In a concurrence in United States v. Lara in 2004, Justice Clarence Thomas remarked that tribes, unlike states, are not part of this constitutional order, and their sovereignty is not guaranteed by it. They both are and are not sovereign at the same time, Thomas asserted, pointing to the muddle of sovereignty cases which he called schizophrenic. In 2009, in a book dedicated to Deloria, Frank Palmersheim, who directed the Dakota Plains Legal Service Clinic in the 1980s and later served as Chief Justice for the Cheyenne River Sioux Tribal Court of Appeals, as well as Associate Justice for the Rosebud Sioux Supreme Court, set aside the amendment proposed by Barsh and Henderson as inelegant and even potentially unworkable. Opposing state-like status for Native nations, Palmersheim instead recommended an amendment to the U.S. Constitution to reconstitutionalize Indian sovereignty. The inherent sovereignty of Indian tribes within these United States shall not be infringed except by powers expressly delegated to the United States by the Constitution. The Congress shall have this power to enforce by appropriate legislation the provisions of this article. Palmersheim made plain that a constitutional amendment was the surest constitutional footing for Indian sovereignty. Then he did the math, and assuming that states without federally recognized tribes would likely support this amendment, suggested that support would be in fact quite high. That proposal, too, was left on the shelf while Native nations within the United States, tied to a worldwide indigenous rights movement, experimented with new constitutional ideas, or rather with constitutionalizing some very old indigenous ideas, including language about the conservation of natural resources and the protection of the environment. The 1985 Constitution of the Poarch Band of the Creek Tribe in Alabama included a section that asserted the tribe's inherent sovereign power to manage and regulate environmental protection on the reservation. In 2005, for instance, the preamble to the Constitution of the Pokagon Band of the Potawatomi Indians, historic dwellers of the Great St. Joseph River Valley, a band of the Potawatomi Indian Nation, expressed a commitment to conserve and develop our natural resources. Native nations in the United States and around the world also began experimenting with granting rights to nature, something akin to the way the U.S. Constitution grants rights to corporations as legal persons. The Anishinaabe of the White Earth Nation, a band of Ojibwe, held a convention and ratified a new constitution in 2009, just as Ecuador and Bolivia were adopting new national constitutions that granted rights to nature. The Anishinaabe of the White Earth Nation are successors of a great tradition of continental liberty, a native constitution of families, totemic associations. Its preamble begins, "The Anishinaabe create stories of natural reason, of courage, loyalty, humor, spiritual inspiration, survivance, reciprocal altruism, and native cultural sovereignty." In 2016, after the Standing Rock Sioux protested the Dakota Pipeline, the Ho-Chunk Nation in Wisconsin amended its constitution, becoming the first Native American nation to grant rights to nature. The amendment reads, "Ecosystems and natural communities within the Ho-Chunk territory possess an inherent, fundamental, and inalienable right to exist and thrive." The Ponca Nation in Oklahoma adopted a similar amendment to its constitution the following year. In 2018, the White Earth Nation passed a law granting rights to wild rice, a sacred crop that had for decades been threatened by Minnesota's violations of Ojibwe treaty rights, but that had become newly threatened in the 2000s by the introduction of genetically modified rice. The 2018 law read, "Monoman, or wild rice, within all the Chippewa ceded territories, possesses inherent rights to exist, flourish, regenerate, and evolve, as well as inherent rights to restoration, recovery, and preservation." When an oil company began building a pipeline in Minnesota in 2021, the tribe sued the Minnesota Department of Natural Resources in White Earth Tribal Court for violating the rights of Monoman. The suit failed, but it would not be the last attempt to enforce rights of nature in tribal and non-tribal courts. In marked contrast to the constitutional generativity among indigenous peoples in the United States and around the world, an increasingly originalist Supreme Court pursued a policy of constitutional restoration. The right to bear arms. The history of originalism as advanced by Scalia has everything to do with abortion and everything else to do with guns. If I'd been required to identify the Ninth Amendment when I was in law school or in the early years of my practice, and if my life depended on it, I couldn't tell you what the Ninth Amendment was, Scalia once said. That used to be the case with the Second Amendment, too. It began to change once Reagan took office. Many Americans own guns that they use for marksmanship and especially for hunting, both for recreation and for supplying their families with food. American police have also for a very long time carried guns, so have criminals, serial killers, and would-be assassins. Since the founding of the Republic, towns, cities, and states have routinely passed gun safety measures, and from the earliest days of the polling industry, Americans have consistently supported those measures. In 1938, for instance, Gallup found that 84% of adults supported a law requiring owners of handguns to register with the government. In 1967, that percentage was 73%. But support for strict gun control measures began to erode in the 1960s. In 1959, Gallup reported that 60% of adults supported a law banning the possession of handguns, except by the police. By 1975, that support had fallen to 41%. By 2023, it was 25%. Declining support for strict gun control measures tracks with the polarization of the parties. The politicization of guns did not begin until the 1970s, when guns became a weapon in party realignment and in the fight over the federal judiciary. American gun owners and non-owners alike became so many pawns in the party's struggle for power. As partisanship strengthened and polarization worsened, guns and abortion became the defining constitutional issues in the life and death, winner-take-all fury of modern American politics. On the left, abortion would come to mean freedom, and guns to mean murder, and on the right, guns would come to mean freedom, and abortion to mean murder. That neither of these statements can be defended didn't matter, since they succeeded in what political campaigns were most eager to use them to do: get voters to the polls. 1 in 3 Americans owns a gun, 1 in 4 American women will have an abortion in her lifetime. In 1975, the District of Columbia passed a law that all but banned the possession or sale of any handgun. That year, there were 2 assassination attempts on President Ford. The National Council to Control Handguns proposed a national ban. In 1976, the California legislature debated a similar bill. Opponents of the bill proposed a state constitutional amendment guaranteeing a right to keep and bear handguns, rifles, and shotguns. According to that public opinion survey from 1979, nearly 2/3 of Americans supported a constitutional amendment to control the sale of handguns, though this by no means seemed necessary. The first federal firearms laws in the 1930s had been upheld by the U.S. Supreme Court in 1939 in United States v. Miller. In an 8-0 decision, the court agreed with the government's argument that the Second Amendment is restricted to the keeping and bearing of arms by the people collectively for their common defense and security, and that the language of the amendment establishes that the right is not one which may be utilized for private purposes, but only one which exists where the arms are borne in the militia or some other military organization provided for by law and intended for the protection of the state. In any case, the court had long read the Second Amendment as concerning only the keeping of guns for military purposes and limiting only the federal government, not the states. Of nearly 300 state gun control laws in place by the year 2000, nearly 40% had been passed before 1970. Calls for Congress and the states to pass legislation restricting the sale and ownership of guns began in 1963, after the assassination of John F. Kennedy. Nearly 80% of Americans supported mandatory handgun permits. Support was particularly strong among Catholics. 150 gun control bills were introduced in the states and 18 into Congress. To counter these proposals, the argument was floated that the Second Amendment might protect an individual's right to own a gun. We should find the lost Second Amendment, broaden its scope, and determine that it affords the right to arm a state militia and also the right of the individual to keep and bear arms, wrote the author of a 1965 article called The Lost Amendment. The Second Amendment was lost in the sense that no one ever bothered to cite it, since it had no real relevance in the modern world. But in 1968, after years of racial violence and the assassinations of Robert F. Kennedy, Martin Luther King Jr., Medgar Evers, and Malcolm X, Congress passed a gun control act that prohibited the selling of guns through the mail and banned certain guns. A House committee reviewing the bill reported that the Second Amendment offered no obstacle because the reference to a well-regulated militia would seem to govern the phrase, the right of the people to keep and bear arms, which means, in its context, the right of the states to organize a militia. The National Rifle Association had endorsed the 1968 Gun Control Act. Until the 1970s, the NRA had been a hunting, sporting, and marksmanship organization whose motto since 1957 had been firearms safety education, marksmanship training, shooting for recreation. But in the mid-1970s, with plans to move to a new recreational shooting center in Colorado, the NRA began organizing in opposition to handgun control laws. The law and order republicanism that had begun under Richard Nixon might have been seen to support gun regulations, but Reagan took a different and libertarian position. He opposed that legislation and also argued that it was unconstitutional. In an article published in Guns and Ammo in 1975, Reagan maintained that the Second Amendment is clear, or ought to be. It appears to leave little if any leeway for the gun control advocate. In 1977, the NRA moved its annual meeting from Washington in protest of the new law and instead met in Cincinnati, where, in a conservative rebellion known as the Cincinnati Revolt, the organization's bylaws were rewritten. The planned move to Colorado was canceled. Remaining in Washington, where it became essentially a lobbying organization, the NRA had a new motto engraved at the door of its building. The right of the people to keep and bear arms shall not be infringed. In 1981, Strom Thurmond appointed Utah Senator Orrin G. Hatch, a former bishop of the Church of Jesus Christ of Latter-day Saints, to Birchbuy's old position as chair of the Senate Judiciary Committee's Subcommittee on the Constitution. Hatch liked to say that in this role, he had been exposed to more proposals to amend the United States Constitution than any other members of Congress since James Madison. Hatch himself had proposed a right to life amendment returning the issue to the states, a school prayer amendment, and an amendment outlawing affirmative action. Reagan considered naming him to the Supreme Court. Hatch's greatest interest was not in a new amendment, but in an old one. Immediately upon assuming chairmanship, he said, he called for a report on the original meaning of the Second Amendment. Even as Hatch's subcommittee was at work, Reagan was shot in an assassination attempt. His press secretary, James Brady, was shot in the head. Reagan maintained his opposition to gun control legislation. Brady became an advocate for it. In February 1982, Hatch's subcommittee published a report called The Right to Keep and Bear Arms. Having undertaken historical research, the subcommittee reported that it had found clear and long-lost proof that the Second Amendment to our Constitution was intended as an individual right of the American citizen to keep and carry arms in a peaceful manner for protection of himself, his family, and his freedoms. That November, after the National Rifle Association waged a well-funded campaign against California's handgun control bill, voters resoundingly defeated it in a statewide referendum. The NRA also funded research that favored its interpretation of the Second Amendment. In 1982, the Reagan administration, preparing for the Constitution's bicentennial, appointed 200 present and former elected officials, scholars, and business and labor leaders to a committee charged with considering possible constitutional reforms. In its final report in 1985, the co-chairs urged Americans not to treat the Constitution as immutable, like the Ark of the Covenant, but to be open to changes, including amendments. It recommended 6, including congressional term limits and bonus seats in the House for the party that wins the presidency. None of these ideas made any headway. It wasn't voters who were opposed to amendments. The hurdle was Congress and conservatives in the Reagan administration. Typical was the recommendation in 1984 of James McClellan, who left his position as a staffer at the Senate Judiciary Committee to become the president of a newly formed Center for Judicial Studies. He urged conservatives to kick the habit of Article 5. There's something fundamentally wrong with our system if we are driven to amend the Constitution so as to restore its original meaning, McClellan wrote. We should resist efforts to add amendments to our fundamental law to correct misinterpretations rendered by the Supreme Court. Better to effect constitutional change under the guise of restoring the Constitution's original meaning. That would require taking over the court. By 1984, guns, like abortion, had become a partisan issue. The Democratic platform called for tough restraints on the manufacture, transportation, and sale of snub-nosed handguns, while the GOP platform opposed gun control. Hatch's report proved to be a landmark in the emergence of originalism. Meese became Attorney General in 1985 and announced that originalism would be the official interpretive position of his Justice Department. Justice John Paul Stevens would later recall that between 1975, when he joined the court, and 1986, when Scalia joined, no judge or justice expressed any doubt about the limited coverage of the amendment. The opinion in Miller held. But in 1986, Congress passed the Firearms Owners Protection Act, which repealed parts of the 1968 Gun Control Act by invoking the rights of citizens to keep and bear arms under the Second Amendment. Robert Bork, for one, did not endorse this theory. Bork was unpersuaded by the NRA. I'm not an expert on the Second Amendment, he said in 1989, but its intent was to guarantee the right of states to form militia, not for individuals to bear arms. From retirement in 1991, Warren Burger, appearing on PBS and holding a pocket constitution in his hands, said that if he were writing the Bill of Rights, he wouldn't include the Second Amendment. Moreover, he said, the NRA's individual rights interpretation was one of the greatest pieces of fraud, I repeat the word fraud, on the American public by special interest groups that I have ever seen in my lifetime. The test of originalism would be whether this interpretation would be accepted by the Supreme Court. Original meaning jurisprudence. At the start of the bicentennial year of 1987, Meese's Office of Legal Policy issued a 200-page sourcebook on original meaning jurisprudence, containing excerpts from the work of Raoul Berger, Robert Bork, Antonin Scalia, and Meese himself, with Brennan as a counterpoint. It alleged that until the 1960s, original meaning jurisprudence had been the dominant form of constitutional interpretation during most of our nation's history. It drew from the speech Scalia had given in June 1986, in which Scalia had elaborated on the obligation for judicial interpretation to be bound by whatever was the most plausible meaning of the words of the Constitution to the society that adopted it, regardless of what the framers might secretly have intended. The Reagan administration pursued a domestic agenda under the banner, "Let's Make America Great Again," whose aim was to roll back social programs and government regulations and to design a foreign policy to bolster American military power in a final confrontation with the Soviet Union. The economy grew, military spending skyrocketed, the national debt nearly tripled, the Cold War ended, and the gap between the wealthiest and the poorest Americans widened. Among his lasting legacies would be a transformation of the judiciary. Not since FDR had a single president replaced so many judges. That Reagan's nomination of Bork was defeated masked a much broader success. During Reagan's second term, Scalia-style original meaning originalism became canonical. Reagan nominated Bork to the Supreme Court in July 1987, but from the start the prospects for the candidate's confirmation were mixed at best. Reagan was a visibly aging lame duck, and reeling too from the Iran-Contra scandal. Republicans had lost the Senate in the 1986 midterms, with the result that Joe Biden, not Strom Thurmond, was now chair of a Democratic Senate Judiciary Committee. Scalia had replaced Rehnquist, which meant that his appointment wouldn't change the balance on the court, but Bork would be replacing the swing voter Lewis Powell. Scalia was warm and witty. Bork was imperious and obnoxious. Bork had also been more public in stating his opposition to the ERA, abortion, and more. Democrats on the Senate Judiciary Committee readied for battle. Biden had been advised not to center his attack on abortion, but instead to call attention to Bork's judicial philosophy, which was a way to both defeat the nominee and to make a broader bid with the public to diminish support for Mises' agenda of originalist jurisprudence. Bork's opponents waged a remorseless and relentless campaign against his confirmation. On the day Reagan announced the appointment, Ted Kennedy made a fiery speech warning about Robert Bork's America. Robert Bork's America is a land in which women would be forced into back-alley abortions, blacks would sit at segregated lunch counters, rogue police could break down citizens' doors in midnight raids, school children could not be taught about evolution, writers and artists would be censored at the whim of government, and the doors of the federal courts would be shut on the fingers of millions of citizens for whom the judiciary is often the only protector of the individual rights that are the heart of our democracy. Bork afterward insisted that there was not a line in that speech which was accurate, but it set off fireworks. The hearings, which lasted for 12 days, were televised, including the 5 days of Bork's own testimony, in which he came across as both high-handed and cold-hearted. And in an unprecedented campaign against a Supreme Court nominee, People for the American Way aired a television ad narrated by Gregory Peck. "He doesn't believe the Constitution protects your right to privacy," Peck warned, urging Americans to contact their senators to voice their opposition. "Because if Robert Bork wins a seat on the Supreme Court, it will be for life. His life. And yours." If Biden didn't lead with abortion, the press did, and so did a 300-member Block Bork coalition, which argued that Bork would turn back the clock on civil rights, women's rights, and workers' rights. Making the case that Bork would have no hesitation in overturning Roe, despite his protestations to the contrary before the committee, Kennedy played an audio recording from 1985 in which Bork had said, "I don't think that in the field of constitutional law, precedent is all that important. And if you become convinced that a prior court has misread the Constitution, I think it's your duty to go back and correct it." In a cover story published on September 21st, 4 days after the We the People parade on Constitution Day, Time magazine warned that if Bork were confirmed, Roe might go. Roe did not go, at least not then. Bork went instead. Although the committee voted against him 5-9, he refused to withdraw, and the nomination went to the Senate where, in a nearly straight party-line vote, he was defeated in October, 42-58. Bork's failed nomination had many consequences. For those in the pro-life movement who still dreamed of a constitutional amendment, that dream died. If Bork had been confirmed, they came to believe Roe would have been overturned. The campaign waged against Bork influenced every nomination thereafter, turning the process into ad money-driven political theater that contributed to the polarization both of Congress and of the electorate. If Bork's nomination had been a referendum on originalism, originalism had in one sense lost. But originalism also won, by being brought so entirely, so dramatically, and so regularly into the public eye. Democrats on the Senate Judiciary Committee gave originalism 115 days of free television time at the height of the nation's celebration of the bicentennial of the Constitution. No nominee since Felix Frankfurter was as schooled in constitutional law as Bork, Raoul Berger would write, and his rejection was a deplorable loss to the court. Bork, who had endured a truly brutal series of attacks, many of them unwarranted, sought his vindication in The Tempting of America, his version of government by judiciary, in which he advanced his brand of originalism, explained that the fight over his nomination was just one battle in a war over the Constitution, and recounted his experience of the process in a tell-all, filled with facts like how stories about him on CBS television ran 8 against him to 1 in favor. The book, while allegedly intended to tamp down the politicization of the Supreme Court appointments, had the effect only of inflaming it. The notorious RBG. In 1989, abortion again came before the court, where Anthony Kennedy had taken the seat that Bork had been denied. Webster v. Reproductive Health Services involved an abortion-restricting 1986 Missouri law. Rehnquist wrote a draft opinion that both upheld the constitutionality of the restrictions and, almost as if as an afterthought, essentially overturned Roe by arguing that the key elements of Roe are not found in the text of the Constitution or in any place one would expect to find a constitutional principle. Liberal Justice John Paul Stevens then dropped out of the majority, circulating a memo in which he said he'd rather not overturn Roe, but if it had to be done, he'd rather give it a decent burial instead of tossing it out the window of a fast-moving caboose. O'Connor agreed, which everyone expected would elicit a strong reaction from Scalia. "The expected Ninogram will arrive this morning," Harry Blackmun's clerk wrote, anticipating Scalia's fury that the majority opinion, while it would hold, would fall short of overturning Roe. Both Blackmun and Scalia, in separate opinions, raised alarms about the legitimacy of the court itself. "We can now look forward to at least another term with carts full of mail from the public and streets full of demonstrators urging us, their unelected and life-tenured judges who have been awarded those extraordinary, undemocratic characteristics precisely in order that we might follow the law despite the popular will, to follow the popular will," scolded Scalia in his concurrence. "I fear for the future," warned Blackmun, in a dissent joined by Marshall and Brennan. "I fear for the liberty and equality of the millions of women who have lived and come of age in the 16 years since Roe was decided. I fear for the integrity of and public esteem for this court. I dissent." 3 years later, in Planned Parenthood of Southeastern Pennsylvania v. Casey, the court again upheld Roe, which had now held for nearly 3 decades. If Scalia had been guarded about Roe in his nomination hearings, he was not guarded afterward. "If you want a right to abortion," he said, "pass a law, and if you don't want it, you had to pass a law against it." The point of the Constitution was to stop change. To change, to evolve, you don't need a Constitution. All you need is a legislature and a ballot box, he said. The only reason you need a Constitution is because some things you don't want the majority to be able to change. Those things are fundamental rights, and Scalia did not believe that a woman's right to decide whether to end a pregnancy, even were her life in danger, was one of them, unlike the right to bear arms. Because neither side in the abortion debate had succeeded in amending the Constitution, the right asserted from Roe to Casey remained vulnerable, and every decision only further widened the divisions between the electorate over fundamental questions about life and death, privacy and equality. Partisans engaged in political rhetoric of extraordinary extremism, under whose terms abortion was either murder or routine medical care. By the end of the 1980s, the parties had sorted themselves over this issue, with all its implications for American constitutionalism. Few were the commentators who would honestly acknowledge that the divided views on abortion were real and deeply felt and irreconcilable. The feminist scholar Joan C. Williams was an exception. The originalism of the new right, Williams observed, was little more than a thinly veiled justification for its efforts to overturn Roe. I, for example, am convinced, absolutely convinced, without hesitation, that the Constitution protects a woman's right to choose abortion as a basic, undeniable political right, a right without which many other political rights are worthless, Williams wrote. And yet I can see how the conclusion that seems so obvious to me can seem foreign, even repulsive to others, a celibate priest, say, or a mother of 5, and I must acknowledge that consensus on this issue is not in the cards. Nor would consensus be in the cards during the presidencies of George H.W. Bush or William Jefferson Clinton. In 1991, when Bush nominated D.C. Court of Appeals Judge Clarence Thomas to replace Thurgood Marshall in what some called the black seat on the court, opponents of the conservative justice again braced for battle, especially because Bush was replacing one of the court's most liberal justices with a man certain to be among its most conservative appointments. This time the hearings took a turn when Anita Hill, a law professor and former colleague of Thomas's, testified before an all-male, all-white Senate Judiciary Committee that Thomas had sexually harassed her. Hill's allegations had come up during an FBI background check on Thomas. Other women had made similar allegations, but Hill was the only one to appear before the committee, where Biden, as chair, failed to restrain Senators Orrin Hatch, Arlen Specter, and Alan Simpson from essentially placing Hill on trial. Thomas, citing his own right to privacy, refused to answer questions about what goes on in the most intimate parts of my private life or the sanctity of my bedroom. Questions about Thomas's qualifications to serve as justice were set aside, overwhelmed by the attention given to allegations of sexual harassment. The Anita Hill-Clarence Thomas hearings set a precedent, prefiguring the airing of charges of sexual assault levied at Trump Supreme Court nominee Brett Kavanaugh in 2018, and the reckless, remorseless, and almost entirely partisan news coverage in which liberal news organizations appeared less interested in reporting on the nomination than in defeating it, while conservative organizations sought only to secure the confirmation. The confirmation process had become a proxy war. The tit-for-tat had begun in 1967 when Strom Thurmond had tried to trip up Thurgood Marshall with obscure questions about constitutional history in an attempt to prove that blacks were racially inferior to whites. Birch Bayh had then defeated the nominations of Hainsworth and Carswell by introducing evidence that they were secretly segregationists. Feminists had defeated Bork by claiming he would turn back the clock on women's rights to overturn Roe. By the time Bush nominated Thomas, sexual harassment was the topic of the day. No longer did views about racial segregation animate the treatment of nominees by both the Judiciary Committee and the press. Now it was views about women and sex. The more polarized the parties had become, and in particular the more polarized the press, the less was the consensus on any of these nominees. The left tended to believe and sympathize with Anita Hill. The right tended to believe and sympathize with Clarence Thomas. After the hearings, nearly as controversial and polarizing as the Bork hearings, the Senate confirmed Thomas 52-48. I wish I could have been there to do with him what we were able to do with Hainsworth and Carswell, Birch Bayh said, near the end of his life. I like to think I wouldn't have let that son of a gun get on the bench. I think he, to this very day, is a blight on the court. But neither Thomas nor his wife Ginny would forget the trial he had endured. Clinton's nomination of Ruth Bader Ginsburg in 1993 lacked scandal, but not controversy. Clinton desperately needed to appoint a woman. Judge Ginsburg, welcome, Biden said softly as the first day of hearings began. And believe me, you are welcome here this morning. Ginsburg was rightly celebrated as the Thurgood Marshall of women's rights. She had first appeared before the Supreme Court in 1973 on behalf of Sharon Frontiero, an Air Force lieutenant, and Frontiero v. Richardson. Frontiero had been denied benefits for her husband that were granted to men for their wives. I ask no favor for my sex, Ginsburg said, quoting the 19th century women's rights advocate Sarah Grimke. All I ask of our brethren is that they take their feet off our necks. In case after case, Ginsburg, as head of the women's rights program at the ACLU, methodically chipped away at discrimination on the basis of sex, each case another small, guarded step. She refused to take cases that would have required her to defend Roe, which she believed to have been badly decided. The court's gender classification decisions overturning state and federal legislation in the main have not provoked large controversy, she explained. While the court's initial 1973 abortion decision, Roe v. Wade, on the other hand, became and remains a storm center. Roe v. Wade sparked public opposition and academic criticism in part, I believe, because the court ventured too far in the change it ordered and presented an incomplete justification for its action. Carter had named her to the D.C. Circuit in 1980. Feminist picked for U.S. Court of Appeals here, announced the Washington Post. She had been a moderate on that court, where she served alongside Scalia and Bork. In 1993, delivering the Madison Lecture at New York University, she'd cited Roe as an example of a bad judicial decision, an illustration of the rule that doctrinal limbs too swiftly shaped, experience teaches, may prove unstable. When Clinton nominated her to the Supreme Court, women's groups refused to endorse her. The women are against her, Clinton said, surprised. Coulda, woulda, shoulda, Now's president said, waving aside Ginsburg's contention that an equal protection case, rather than a right to privacy case, would have established reproductive rights on firmer constitutional ground. Pro-life activists who were at the time bombing abortion clinics, she wrote, don't care about the legal theory. They care about stopping abortion and controlling women's lives. Only the efforts of Ginsburg's husband nudged the nomination back on track. He arranged for all manner of statements of support, including a letter signed by 14 members of the faculty of NYU Law School who had been in the audience for the Madison Lecture and who wrote to say that they were distressed that her remarks at NYU have been misconstrued as anti-choice and anti-women. On the first day of Ginsburg's hearings, Biden told her that he'd read the New York Times on the train to Washington that morning and that finding no scandal about her in the paper was the most wonderful thing that has happened to me since I have been chairman of this committee. The Senate confirmed her 96-3. The fact that she had grave doubts about Roe would be forgotten, and by the left, forgiven. Today, Ginsburg has instead the very unfortunate distinction of being remembered not for her confirmation hearing, nor even for any of her many opinions on the court, but for her refusal to step down. At the start of Barack Obama's second term, the president had asked her to resign, which would have allowed him to nominate a liberal justice to replace her. But Ginsburg expected Hillary Clinton to defeat Donald J. Trump in the 2016 election and liked the idea of the first female president having the opportunity to replace the most important woman ever to sit on the bench. She bet wrong. Instead, Trump won, and when Ginsburg died in September 2020, he replaced her with record-breaking speed with Amy Coney Barrett, a former law professor and judge from the Seventh Circuit known for her acumen and integrity. Senate Republicans, having refused to hold hearings on Barack Obama's appointment of a new justice in 2016 on the argument that 8 months before the election was too close, held hearings on Barrett 8 days before the election in 2020. She was also a constitutional conservative, a mother of 7, and as opposed to Roe v. Wade, as was Antonin Scalia. 2 years later, Barrett joined the 5-justice majority in Dobbs, overturning Roe. Stupid, but constitutional. If elected president, what criteria would you use to select the new Supreme Court justices? A voter asked Vice President Al Gore in a town hall debate in March 2000. Gore was seeking the Democratic nomination in a race against former New Jersey Senator Bill Bradley. I would look for justices of the Supreme Court who understand that our Constitution is a living and breathing document, that it was intended by our founders to be interpreted in light of the constantly evolving experience of the American people, he answered. The right of privacy, just to take one example, was found by Justice Blackmun in the Constitution, even though the precise words are not there. Bradley agreed. He didn't want anyone lopped into an original interpretation of the Constitution as if 1787 is the year 2000. Gore was expected to win the nomination easily, and that spring, rumor in Washington had it that if Gore were to win the presidency, Scalia would resign at age 64. A Gore presidency would eliminate his chance of becoming Chief Justice and ensure that his jurisprudence will never be more than a footnote, one reporter wrote. The Constitution became still more sclerotic. Presidents from Jefferson, Madison, and Jackson to Grant, Roosevelt, and Taft had proposed constitutional amendments. But this practice had fallen off until the 1980s, when Reagan publicly supported 5 constitutional amendments: school prayer, a balanced budget, the right to life, presidential line-item veto authority, and repeal of the 22nd Amendment. That flurry of proposals led to a diagnosis of constitutional amendmentitis. But Reagan's interest in amendments was atypical. Bill Clinton supported only a single amendment, victims' rights, and George W. Bush in 2004, calling for a Defense of Marriage Amendment, was the last sitting president to propose amending the Constitution until Joseph Biden, who, after stepping down from his campaign for re-election in 2024, proposed a constitutional amendment to reverse the Supreme Court's decision granting the president considerable immunity to criminal prosecution in Trump v. United States. Presidencies and presidential elections weren't about constitutional amendments, but they were about Supreme Court appointments. In November 2000, the election between Gore and Texas Governor George W. Bush proved distressingly close. Gore won the popular vote by a mere handful of votes, but victory in the Electoral College turned on the state of Florida. Gore conceded, then unconceded, then asked for a recount in Florida, where Bush's brother Jeb, as governor, had certified the results as a victory for Bush. By the end of the month, the Supreme Court had agreed to hear an appeal from Bush, who wanted the recount stopped. "When you have to call us in, someone has screwed up," Scalia told the Washington Post. "Something has gone terribly wrong." One of Scalia's sons was at the time a partner in the law firm that represented Bush, though he was not involved in the case. In a bitter and unsigned but wholly partisan opinion, a 5-4 majority reversed the Florida Supreme Court and issued a stay, ending the recount and resolving the disputed election in favor of Bush, who was at that point in the counting ahead. The 4 liberal dissenters argued that the Supreme Court ought never to have agreed to review the case. Although we may never know with complete certainty the identity of the winner of this year's presidential election, the loser is perfectly clear, Justice John Paul Stevens wrote in dissent. It is the nation's confidence in the judge as an impartial guardian of the rule of law. At 10 p.m. on December 12th, 5 weeks after the election, the court released its opinion. Instead of reading their opinions from the bench, the justices simply issued them to the press and left the building by way of an underground garage, with no word to dozens of journalists from around the world who were waiting in the crowded press room, as Linda Greenhouse reported in the New York Times. Scalia, widely thought to have been behind the majority's opinion, which did not engage in any originalist argument, may have destroyed his chance of becoming Chief Justice. Rehnquist, in any event, elected to postpone retirement, which would have exposed the court to the unwanted scrutiny of another nomination process. After Bush v. Gore, Scalia, who had generally failed to build a conservative coalition on the court, became more isolated as its centrist jurists, Anthony Kennedy and Sandra Day O'Connor, increasingly sided with the liberals. In Lawrence v. Texas, 2003, the court found laws banning homosexuality to be unconstitutional. Scalia, in a dissent that he read from the bench, said that while he did not agree with the Texas law, he once said he wished all judges were given a stamp that said, "stupid but constitutional," then someone sent him one, the court had no right to overturn it, and was instead taking sides in a culture war. Where did the court find the right to homosexual behavior in the Constitution, he would later ask, on the basis of, the sexual preference clause of the Bill of Rights? Conservatives outside the court proposed a constitutional amendment banning same-sex marriage. Amendments defining marriage as between one man and one woman were first introduced into Congress in 2002. 2 years later, the GOP platform endorsed such an amendment for the first time. But public opinion increasingly favored same-sex marriage. 50% of Americans favored a constitutional amendment banning gay marriage in 2003 that had fallen to 36% by 2008. In 2015, in Obergefell v. Hodges, the court held that same-sex marriage is protected under the 14th Amendment. If Scalia had waved aside Biden's question in 1986 about the difference between original intent and original meaning, by 1996, the justice had settled the matter in his own mind. In a speech he gave 10 years later, he explained the difference. The theory of originalism treats a constitution like a statute, and giving it the meaning that its words were understood to bear at the time they were promulgated, he explained. You will sometimes hear it described as the theory of original intent. You will never hear me refer to original intent because, as I say, I am first of all a textualist, and secondly, an originalist. If you are a textualist, you don't care about the intent, and I don't care if the framers of the Constitution had some secret meaning in mind when they adopted its words. I take the words as they were promulgated to the people of the United States, and what is the fairly understood meaning of those words. Unable to persuade his fellow justices of this view, Scalia brought his case to the public, in books and in a series of interviews and speeches that pundits called the Dead Constitution Tour. "The Constitution is not a living organism, for Pete's sake," he said in a speech he gave regularly. "It is dead, dead." This was usually an effective laugh line, except when Scalia delivered it outside the United States, where it was met with silence and bafflement. "I am first of all a textualist and secondly a originalist," he'd said in 1996. By 2005, he was first of all an originalist. "I have my rules that confine me. I know what I'm looking for. When I find it, the original meaning of the Constitution, I am handcuffed." He pressed his hands together, as if bound. If, for Scalia, originalism was a tool of judicial restraint, it became on the court something altogether different from a pair of handcuffs. Not an 18th century musket or a 21st century assault weapon, but a battering ram. Newsflash: the Constitution means what it says. It wasn't only amendments that Congress couldn't pass in the decades between Reagan and Trump. Legislation stalled, too. And while the economy grew, income inequality, rates of poverty, and maternal and infant death rates all rose. With a handful of notable exceptions, including the Affordable Care Act and the Inflation Reduction Act, neither Democrats nor Republicans, however much they continued to fight over an elusive middle America, were able to make any real headway at turning back the suffering caused by industrial decline, a global marketplace, the alienation caused by the emergence of the Internet and social media, and the public health crises caused by a series of drugs, from crack to over-the-counter opioids to fentanyl sold on the streets. By 2018, for the first time in a century, American life expectancy was consistently falling. College-educated Americans prospered, but high school graduates of the white working class and those with less education found few paths out of poverty in the age of global finance capitalism. Public health researchers coined the term deaths of despair to describe the vertiginous rise in the number of deaths among white working-class adults due to suicide, alcoholism, and drug overdose. Populism had its origins in the indifference to that suffering on the part of the Clinton and Obama administrations. In a politics driven by polarizing culture wars in which cosmopolitan elites favored immigration while blue-collar workers feared it, progressives increasingly viewed the white working class, and especially devout Christians, with nothing short of contempt. You'll go into these small towns in Pennsylvania, and like a lot of small towns in the Midwest, the jobs have been gone now for 25 years, and nothing's replaced them, Obama said in remarks to a fundraiser in San Francisco in 2008. And they fell through the Clinton administration and the Bush administration, and each successive administration has said that somehow these communities are going to regenerate. And they have not. And it's not surprising then they get bitter. They cling to guns or religion or antipathy toward people who aren't like them, or anti-immigrant sentiment or anti-trade sentiment as a way to explain their frustrations. All that anyone remembered from that speech, in which Obama was attempting to offer compassion, was that before an audience of Silicon Valley donor prospects, he had mocked Americans who cling to guns or religion. For people from whom much had been taken by the forces of capitalism, corporate greed, progressive indifference, and the machinations of Silicon Valley, guns and religion meant a great deal. And so did the Constitution, especially as marketed to Americans as something else that progressives were trying to take away from them. The case Scalia had been waiting for finally came before the court in March 2008 in oral arguments in District of Columbia v. Heller, a challenge to D.C.'s 1976 handgun ban. 2 years before, speaking before a turkey hunting association, he'd confessed his personal frustration with the anti-gun attitude in the United States. That attitude of associating guns with nothing but crime is what has to be changed, he said. But as for laws restricting or regulating gun ownership, those could be changed by restoring the original meaning of the Constitution, or at least that was what the Heller case gave him the chance to do. Scalia often talked about the Constitution in the language of James Montgomery Beck, calling it that anchor, that rock, not a living organism and not jello. The work of discovering the original meaning of the Constitution, he believed, was a task sometimes better suited to the historian than the lawyer. But in case after case, he set aside briefs submitted by historians in favor of his own reading of a provincial and narrow set of historical documents, as if this were a reading of history. No application of this method was more consequential than his reinterpretation of the Second Amendment in D.C. v. Heller in 2008, an opinion that Scalia considered to be his originalist masterpiece. "I think it's the most complete originalist opinion I've ever written," he told NPR. The court had before it all the materials needed to determine the meaning of the Second Amendment at the time it was written, Scalia explained. With these in hand, what method would be easier or more reliable than the originalist approach taken by the court? He then set aside briefs written by serious scholars of American history who disagreed with this interpretation. Historians are often asked what the founders would think about various aspects of contemporary life, read an amicus brief submitted by 15 eminent university professors of early American history, including Jack Rakoff, Alan Taylor, Pauline Maier, and Fred Anderson, 2 of whom had won Pulitzer Prizes in history. Such questions can be tricky to answer, but as historians of the Revolutionary era, we are confident at least of this, that the authors of the Second Amendment would be flabbergasted to learn that in endorsing the Republican principle of a well-regulated militia, they were also precluding restrictions on such potentially dangerous property as firearms, which governments had always regulated when there was a real danger of public injury from individuals. Scalia ignored that brief and relied instead on his own study of the distant past. In June 2008, in a 5-4 opinion written by Scalia, in which he was joined by the 3 other conservatives on the court, Clarence Thomas, Chief Justice John Roberts, and Samuel Alito, and by the swing vote Anthony Kennedy, Scalia insisted that the historical record supports the interpretation of the Second Amendment supplied by Orrin Hatch's 1982 report on the right to keep and bear arms, that it protects the right of citizens to bear arms not only in defense of the state and a militia, but also to defend themselves as individuals. Curiously, much in the language of Scalia's opinion in Heller can be read as a treatise on the difference between rights that enter the Constitution as amendments and rights that enter the Constitution by judicial interpretation. The Justice wrote about the Second Amendment that the very enumeration of the right takes out of the hands of government the power to decide on a case-by-case basis whether the right is really worth insisting upon. Abortion was a right that the court had decided case by case since 1973. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all, a fair description of the vulnerable right established by Roe and Casey. But unlike an unenumerated right, an enumerated right, like the right to keep and bear arms, is among those rights enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures or, yes, even future judges think that scope too broad. The day after the court issued its opinion, the Wall Street Journal ran an op-ed by Randy Barnett under the heading, "Newsflash, the Constitution means what it says." Barnett, a Georgetown law professor and author of the book Restoring the Lost Constitution, argued that in the future we should be vetting Supreme Court nominees to see if they understand how Justice Scalia reasoned in Heller and if they are committed to doing the same. This proved prophetic. If Scalia did not endorse the form that originalism had taken among the votaries of the far right, he was pleased by the following it had gained in law schools. "I used to be able to say, with a good deal of truth, that one could fire a cannon loaded with grape shot in the faculty lounge of any law school in the country and not strike an originalist." Scalia, delighted with his triumph in Heller, said at a Federalist Society meeting, "That's no longer true." But the criticism of Heller had been deafening too, beginning with sharply worded dissents written by Justices Stevens and Breyer. Stevens, after he retired from the bench, formally proposed amending the Second Amendment to avoid this misinterpretation, such that it would read, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms when serving in the militia shall not be infringed." Criticism of Heller had also come from conservative quarters. J. Harvey Wilkinson III, a retired conservative Fourth Circuit Court of Appeals judge, argued that Scalia had done exactly what he charged living originalists of doing. He had found in an emanation of the Constitution a new right, a right of self-defense, a right that the court had never acknowledged in more than 200 years since the amendment's enactment. And when the court extended Scalia's Second Amendment interpretation in McDonald v. City of Chicago, 2010, Stevens described Scalia's opinion as a rudderless, panoramic tour of American legal history that was not only bad history but also bad constitutional law. By now, the Second Amendment had come to feature in judicial confirmation hearings. Elena Kagan, nominated to the court by Barack Obama in 2010, was asked so many questions about whether she had ever hunted or even held a gun — she hadn't — that in a private session with a member of the Senate, she promised that if confirmed, she would go hunting with Justice Scalia. And when she was confirmed, she did. He took her to his shooting club in Virginia, after which they went on trips to hunt for quail and pheasants, antelope and deer. On one trip to Wyoming, Kagan later said she shot a deer, but Scalia told her it was the wrong kind of deer, and he could have shot it in his own backyard. If friendships like that between Scalia and Kagan, and more famously between Scalia and Ginsburg, bridged the ideological divide on the court, the political campaign-fueled culture war over abortion and guns was not quieted by the decisions the court issued, including those made after Scalia's death. In 2018, retired Justice John Paul Stevens, frustrated at the court's changed interpretation of the Second Amendment, proposed simply repealing it. But a survey found that 79% of Americans opposed such a repeal, with only 17% in favor. Instead, the reach of the new interpretation was extended with Clarence Thomas's incoherent opinion in the 2022 gun rights case, New York State Rifle and Pistol Association v. Bruen. In Bruen, Thomas invented a new text, history, and tradition test, requiring lawyers to demonstrate the existence of an earlier historical analog to any law that in any way restricted or regulated the ownership of firearms. If no analog could be found, the law violated the Second Amendment. Tradition is a living thing, Justice John Marshall Harlan II once wrote. The Roberts Court disagreed. It turned out, though, that American history is shot through with gun laws at the municipal, county, and state level, rules and restrictions of nearly every kind and variety, which meant that lawyers and organizations all over the country were left to dedicate countless hours to arcane historical research to meet the requirements of Bruen. An entirely new field of the history of firearms law emerged, documenting that if anything could be fairly said of American text, history, and tradition, it was that Americans had always been interested both in owning guns and in imposing rules on their ownership, manufacture, use, and sale. 2 years after Bruen, in United States v. Rahimi, the court would suggest to walk back Bruen by clarifying that its intent was not to suggest a law trapped in amber. Justice Thomas dissented. He very much believed that laws are trapped in amber. But originalism, like the text, history, and tradition test, had become so confused that 7 of the 9 justices found it necessary to offer separate opinions in Rahimi in which they attempted to explain what originalism was or was not, or ever was or wasn't. Without Scalia, and with conservatives having risen to power, originalism disintegrated. What would the founders do? In 2009, "The Constitution means what it says" became the unofficial motto of the anti-tax Tea Party movement. It had been formed in opposition to the bailout plan of the Bush administration and continued by the incoming Barack Obama administration. Tea Partiers objected as well to Obama's proposed health care plan, the Affordable Care Act. At the extremes, some Tea Partiers also took issue with Obama himself, the nation's first black president. Tea Partiers dressed in 18th century costumes asked James Beck's favorite question: what would the founders do? Met in constitutional reading groups, and unfurled and signed gigantic copies of the Constitution in rallies all over the country. A growing right-wing populist movement adopted originalism as a theory of revolution. If the movement was scattered and drew together Americans with many different kinds of political discontent, at a time when economic growth was leaving millions of Americans behind, it also offered new opportunities for gun rights advocates to form coalitions with economic and social conservatives, all under the banner of originalism as popular constitutionalism. After the Tea Party movement wound down, its leaders began to reconstitute themselves in the 2010s under the banner of yet another call for a constitutional convention, this time with the larger and supposedly novel aim of dismantling the administrative state. In reality, this plan was the revival of the nearly century-old campaign to repeal the Progressive-era amendments and the New Deal. Originalists were not enthusiastic about this idea. They were doing very well changing the Constitution on the court. In 2014, asked if he could pass one amendment to the Constitution, what it would be, Scalia said he'd make the Constitution easier to amend, but added, "I certainly would not want a constitutional convention. I mean, whoa, who knows what would come out of that?" Originalism as a serious and considered theory of constitutional interpretation parted company with an increasingly extreme right-wing political movement long before the emergence of the Make America Great Again, or MAGA-ism, of Donald Trump. A so-called Convention of States movement held a simulated convention in 2016, featuring, among others, John Eastman, a lawyer who would later be disbarred for his role in the Trump campaign's attempt to overturn the results of the 2020 election. A group called Citizens for Self-Governance, based in Austin, Texas, and passionately endorsed by Governor Greg Abbott, called for a convention too. "We need to channel the energy to restore and reclaim this country's traditional values and founding principles of limited government closest to the people and individual freedom and responsibility," the failed Republican presidential candidate Rick Santorum said in Pennsylvania in 2022. In the decades between Roosevelt and Reagan, Americans' views about the amendability of the Constitution had remained relatively stable. In 1937, the year FDR tried to pack the court, the Gallup poll asked, should the Constitution be made easier to amend? 28% of Americans said yes, and 60% said no. Asked in another survey in 1987, the year of the Constitution's fraught bicentennial, do you think it is too easy or too hard to amend the Constitution, or is the process about right? The spread was roughly identical. 20% of respondents said amending was too hard, and 60% said it was about right. But by the 2020s, that decades-long consensus had changed. Progressives had been particularly alarmed by the court's 2010 decision in Citizens United v. Federal Election Commission granting free speech rights to corporations. In a survey conducted in 2022, before the Supreme Court handed down its decisions in Dobbs and Bruen, 41% of Americans agreed with the statement that the Constitution is basically fine as it is, while 48% agreed that either the Constitution should be more frequently amended or that it should be entirely rewritten and replaced. Americans seemed to be getting unhappier with the Constitution. Exactly how, though, was strikingly polarized. 80% of conservatives agreed that the Constitution was basically fine as is, while 85% of people who were very liberal agreed that the Constitution should be reviewed and amended more frequently, or else entirely rewritten. And the results were also generational. Older Americans, including 62% of the silent generation, born between 1928 and 1945, believed the Constitution to be fine as is, while 66% of Gen Zers, born between 1997 and 2013, wanted to change it. Also divided by generation were responses to a question about the meaningfulness of the Constitution. 90% of the silent generation said the Constitution is very meaningful, a proportion that fell with each generation, down to 35% of Gen Zers. As ever, the more conservative the court became, the more likely were their political opponents to call for constitutional amendment. Many of the federal constitutional amendments that the left had once fought for, they began fighting for again, with renewed efforts to ratify both the Child Labor Amendment and the Equal Rights Amendment, and to get Congress to pass an amendment to eliminate the Electoral College and replace it with direct popular election. None of these measures had even a remote chance of success. In a 2018 essay in the New York Times, Duke Law School's Jedediah Purdy called on progressives to reclaim the Constitution. But Harvard and Yale Law School professors Ryan D. Dorfler and Samuel Moyn argued that since liberals have been attempting to reclaim the Constitution for 50 years with agonizingly little to show for it, the better plan would be to reclaim America from constitutionalism. Purdy, in an article in The Atlantic called "The Constitutional Flaw That's Killing American Democracy," urged Americans to revise Article 5 to make amending the Constitution easier. This would be a way of empowering ourselves to become founders over and over, and not just inheritors, Purdy wrote. In the aftermath of the Dobbs and Bruen rulings, Purdy, echoing progressives of a century before, argued that amending the amendment provision was the only means to end judicial oligarchy. Like Jefferson, Purdy recommended holding a constitutional convention once every generation. In American constitutional law, silence, the fact that we have not amended the Constitution, counts as consent, he wrote. But because amending the Constitution is nearly impossible, our silence is compelled, then laundered into consent. And even Dorfler and Moyne agreed with that, conceding that any effort at altering our fundamental law would probably begin by making the Constitution more amendable than it is now. By the 2020s, some progressives were becoming interested in holding a convention to pursue a progressive agenda, or else in planning for defending progressive positions against a conservative-led convention, even as some alleged that the chief financiers of the convention movement were advocates of fossil fuel extraction, and that its likeliest consequences, as one scholar warned, would be amendments that would devastate environmental protection and hobble effective responses to climate change. Nevertheless, most progressives continued to fear a convention. This could gut our Constitution, Wisconsin Senator Russ Feingold warned in the New York Times in 2022, promoting a new book, The Constitution in Jeopardy. There are smart people and a few on the progressive side who are willing to roll the dice, Feingold admitted, but not him. For me, it is crazy to take the chance. Yet Feingold, too, was determined that the Constitution had to be made easier to amend. And even the conservatives asked by the National Constitution Center to draft a new constitution decided to make amendment easier, but not too much easier. When the journal Democracy assembled a group of liberal scholars and charged them with the same task, the single most important provision of their democracy constitution was a new amendment process, under which Congress could pass an amendment by a simple majority in consecutive sessions to be ratified by a national referendum. It was even possible to guess what the outcome of such a referendum might be. A survey conducted in 2022, shortly before the court issued its opinions in Dobbs and Bruin, found that in a hypothetical national referendum, a constitutional amendment passed by Congress abolishing the Electoral College would be ratified, 47-35, as would one guaranteeing same-sex marriage, 62-38, and one guaranteeing a right to abortion, 57-43, but paradoxically, so would an amendment restricting abortion, 51-49, while an amendment ending birthright citizenship would be only very narrowly defeated, 49-51, and no proposal to clarify or revise the Second Amendment would win ratification. Still, none of these findings much mattered, since there was no chance of any of them being passed by Congress, let alone being submitted to voters in a ratification process never before tried or even honestly considered. Reading law. Antonin Scalia hoped to replace the philosophy of amendment with the philosophy of originalism. He considered Heller to be originalism's triumph and his most important legacy. But he also wanted to leave behind a textbook, a version of Joseph Story's Commentaries on the Constitution, or Francis Lieber's Legal and Political Hermeneutics. Scalia's opus appeared in 2012, jointly authored with the legal scholar and lexicographer Brian Garner. Like Robert Bork's Tempting of America, the book was also meant as a vindication, an answer to all his critics. In Reading Law, Scalia and Gardner discussed Heller in a chapter called 13 Falsities Exposed, under the heading, The False Notion that Lawyers and Judges, not being historians, are unqualified to do the historical research that originalism requires. Historical research is not a difficult endeavor, they alleged, nor are historical sources difficult to discover or to read, nor is such a reading likely to be inconclusive. The historical record is instead legible, unitary, and dispositive. Learning how to read law required 3 years of law school and the study of many books, like the more than 500-page textbook Reading Law, but reading history was easy and straightforward. Those who said otherwise exaggerate the task. This, unsurprisingly, did not quiet Scalia's adversaries. Heller is the most criticized of all of Scalia's opinions, claimed Seventh Circuit Judge and Reagan nominee Richard Posner in a review of the book. Reading Law is Scalia's response to the criticism, Posner wrote. It is unconvincing. Scalia and Garner had suggested that one tool that made reading history so simple was the availability of so many amicus briefs written by actual historians. But as Posner observed, the book's defense of Heller's decision fails to mention that most professional historians reject the historical analysis in Scalia's opinion. Scalia must have known that the historical record is scarcely ever unambiguous. In Heller, Justice Stevens had stacked his historical evidence up against Scalia's. What made Scalia's history into law was that he got 5 votes, and Stevens got only 4. That didn't make Scalia's history right. Ironically, Scalia may have wielded his greatest influence not on the court, but outside it. At a certain point, he seems to have become more interested in having his say, speaking to his admirers off the court, than in winning votes on it. He had an insatiable appetite for intellectual battle, but as political rhetoric heated up after the election of Barack Obama in 2008, Scalia found himself the subject of ceaseless personal attack. Understandably, he grew weary and isolated. Like so many Americans, he found the polarization of the press unbearable. The crazier the far-right press of Fox News got, the crazier became MSNBC, CNN, and even the nation's newspapers of record. At the beginning of Obama's second term, Scalia told a reporter that he didn't read the New York Times and had given up reading the Washington Post. It just went too far for me. I couldn't handle it anymore. He was by then, he said, getting most of his news from talk radio. Heller, he began to fear, had been originalism's high point. But after Heller, originalism soared, both as the popular constitutionalism of the Make America Great Again movement and on the Supreme Court, as Trump added 3 originalist justices to the bench. Progressives, expecting originalism to prevail on the Supreme Court for years and even decades to come, attempted to devise something called progressive originalism, endorsed by the Biden-appointed Justice Ketanji Brown Jackson. If conservative judges are making selective use of history to make originalist arguments for conservative results, then the only way to show this is to make better originalist arguments to the contrary, wrote one law professor in 2022. Would judging law be reduced to the act of choosing between competing accounts of the past written by different groups of historians based on some as yet undefined method of determining which account is the correct one? It didn't work out that way. In a series of crucial cases, the Trump-era court cited history if it supported a preferred outcome, and if history did not support that outcome, the court simply ignored the past. After Donald Trump incited an invasion of the U.S. Capitol during a certification of the Electoral College results in 2021, historians offered an originalist interpretation of the disqualification clause of the 14th Amendment, arguing that Trump, like Jefferson Davis, could not run for president. The court set that history aside. When the U.S. Justice Department pursued criminal charges against Trump associated with the insurrection, Trump, in the case Trump v. United States, insisted that presidents are immune from criminal conviction. Historians submitted an originalist interpretation of constitutional immunity demonstrating that there existed no historical evidence whatsoever for Trump's claim. The court set that history aside. The lead author of the historian's brief assessed the majority opinion in Trump v. United States. The Supreme Court has effectively ruled that 250 years of U.S. history under a republic is enough. A leading conservative commentator concluded that in the disqualification and immunity decisions, the court's originalist majority neglected its originalism. Or, as the liberal Justice Sonia Sotomayor observed ruefully in a scorching dissent in Trump v. United States, it seems history matters to this court only when it is convenient. The Constitution is dead, Scalia liked to say. To many Americans in the Trump and Biden years, it had begun to seem that way, although half the country blamed Republicans and the other half blamed Democrats. By 2021, 1 in 3 Americans said they'd favor either abolishing the Supreme Court or limiting its power. Elizabeth Warren, a Massachusetts senator and former Harvard law professor, introduced a new Judiciary Act to restructure the court. Harkening back to the objections of progressives to a conservative court of men like George Sutherland a century earlier, Warren charged the conservative 6-justice supermajority with pursuing a deeply unpopular and partisan agenda at odds with the Constitution and the settled rights of our citizens. The next year, Trump, citing massive fraud in the 2020 election and seeking re-election, called for the termination of all rules, regulations, and articles, even those found in the Constitution. Democrats called for 2 justices, Thomas and Alito, to recuse themselves in cases relating to the January 6th insurrection. when they refused, at least one Democrat in Congress called for their impeachment. After Dobbs and Bruen, public estimation of the legitimacy of the court fell to record lows, though it divided along strictly partisan lines. In 2024, 2 climate change activists poured red powder on the glass case enclosing the Constitution in its shrine in the rotunda of the National Archives, where it had been carried 72 years before, under armed guard. This was the first attack on the Constitution since the bicentennial in 1986. "We are determined to foment a rebellion," one of the protesters said. "We will not be held accountable to laws in which we have no voice and representation. We all deserve clean air, water, food, and a livable climate." Antonin Scalia did not live to witness this crisis in constitutionalism. "For all I know, 50 years from now, I may be the Justice Sutherland of the late 20th and early 21st century," he said in an exceptionally candid interview near the end of his life. "And I don't care." Long before playing Macbeth on stage, he'd uttered some of Shakespeare's most aching lines. "Life's but a walking shadow, a poor player that struts and frets his hour upon the stage, and then is heard no more." Did he ever wonder if that might be true of the Constitution? If he had been wrong, and if it were all along a living thing, grown stunted, thwarted, ailing? In 2016, after a day hunting quail in Texas, he died in his sleep, age 79. Epilogue: The Future of Constitutionalism. As an AI language model, I do not have personal beliefs or opinions. However, based on current public opinion, here are 3 possible amendments to the U.S. Constitution. ChatGPT post on Reddit, 2023. The Constitution of the United States rests on 3 18th-century beliefs: that a constitution is a machine, that the human mind is driven by reason, and that history moves in the direction of progress. No one more clearly stated these views than Thomas Jefferson. Laws and institutions must go hand in hand with the progress of the human mind, he wrote in 1816 on the 40th anniversary of the Declaration of Independence, musing that constitutions that could be readily amended might last forever, if anything human can so long endure. An inveterate tinkerer, Jefferson knew about machines. At Monticello on Mulberry Row, he oversaw a manufactory where, as he reported, a few women and children and invalids who could do little in the farm, humans too little or sick or old to do more strenuous work, produced 2,000 yards of cloth a year, double what Monticello had been able to manufacture before Jefferson imported the latest carding, spinning, and weaving machines. And when those machines broke down, as all machines do, they could be mended and even improved. One new kind of machine would have fascinated Jefferson. In 1801, a weaver in France designed a machine that used punched cards to program a loom to weave cloth in any pattern. The punch card loom inspired the first computers, tabulators and calculators that could count and sort information. Machines whose descendants can not only produce patterns, but also detect them, faster and more accurately than any human mind. The human mind may or may not be driven by reason, but the computing mind is driven by calculation. Since the 1950s and the rise of the general-purpose computer, but especially since the 1990s and the opening of the Internet, the architecture of human communication has been ceaselessly updated, from minor patches to major version changes, a collaborative process of ongoing revision and overwriting that lies far distant from the slow and painstaking practice of amending written constitutions through democratic deliberation. In the 21st century, a world in which ideas circulate not by way of goose quills and sheepskin parchment and lead type, but by way of crystalline silicon, iron ore, and integrated circuits, an artificially intelligent machine can read all the constitutions in the world and draft a new one or interfere in the operation of an old one. In the 2020s, the White House issued a proposal for an AI Bill of Rights, which didn't grant rights to machines but instead promised to protect humans against the use of technology, data, and automated systems in ways that threatened the rights of the American public. Legal theorists began discussing constitutional artificial intelligence, hoping to coax artificially intelligent machines to align their output with constitutional principles like the rule of law and human rights. One think tank produced the Digitalist Papers, an Age of AI analog to the Federalist Papers. The algorithmic architecture of 21st century communications threatens to end the liberal nation-state and replace it with what I've called the artificial state. It could even augur the end of constitutionalism itself. Machines progress. Does history? In the first decades of the 21st century, faith in progress proved elusive in American constitutional culture. During the age of Trump, a philosophy of doom replaced the philosophy of amendment. Conservatives told a tale of constitutional catastrophe involving the expansion of the power of the federal government through the judiciary's creation of new rights, and sought to terrify Americans into defending a sacralized constitution against alteration as if to stop the passage of time itself. Progressives warned of a different dystopia, the retraction of constitutional rights, and lavishly lamented the plot of a constitutional story substantially of their own devising. Everyone, it seemed, agreed to abandon the philosophy of amendment. A philosophy of doom is an undemanding doctrine, and doomsday books are easy to write. Aside from the U.S. Constitution, nearly every constitution mentioned in this book is defunct, and nearly all the people in this book are dead, too. Mary Wollstonecraft died at 38 in 1797 due to complications from childbirth. Anne Willing Bingham died at 36 in 1801, not long after the birth of her third child. Thomas Jefferson and John Adams died on the same day, July 4th, 1826, the 50th anniversary of the Declaration of Independence. Joseph Pope died that same summer after having moved from Boston to Hallowell, Maine, to live with his son, where he invented a threshing machine, a machine to separate grain from stalks and husks. It was said that this new machine, unlike Pope's orrery, would not break down, since it depended neither on metal springs which may break, nor on complicated movements which may be disordered, nor on a multitude of parts which may create confusion or call for frequent repairs. Jefferson seems to have kept the promise he made to Sally Hemings in Paris in 1789 that he would free her children when they came of age. He did not free Hemings, who died in Charlottesville in 1835 at 62. Mary Jane Richardson and John Jones are buried side by side in a cemetery in Chicago. Charles Beard had the great misfortune of living just long enough to be disgraced. In 1948, while he was dying of anemia in a hospital in New Haven, The Atlantic published a venomous review of his last book. If he was lucky, no one showed it to him. Mary Church Terrell lived to be 90, meeting her end in Maryland, 2 months after Brown v. Board of Education. David J. Mays died in 1971, having arranged that upon his death, his diaries would be given to the Virginia Historical Society. Ethel Payne died of a heart attack at home in 1991. Patsy Takamoto Mink succumbed to pneumonia at 74 in 2002 after winning a primary from her hospital bed in Honolulu. Vine Deloria died of a complication from an aneurysm in Colorado in 2005. He was 72, remembered at his memorial as Whip Smart and Coyote Clever. In 2008, William F. Buckley, 82, collapsed in his study. After his death, his son published a political satire called Supreme Courtship, in which a Senate Judiciary Committee chairman conspires to defeat 2 nominees to the court, after which the president next names a reality TV judge, leading Congress to pass a constitutional amendment limiting the presidency to 1 term, whereupon the president seeks re-election in a race against the former Senate Judiciary Committee chairman, now playing the president on TV, and wins, but only after the states have ratified the 1-term amendment, so the election is thrown to the Supreme Court, where the justice casting the tie-breaking vote is sleeping with the Chief Justice, but refuses to recuse herself, leading to calls for her impeachment. A few years later, this plot didn't seem so funny anymore. I like to think as a country, as we grow older, we learn. 90-year-old Birch Bayh, white-haired and stooped, told a reporter in the last interview he gave before his death in 2019. It just makes good sense. Whether or not that is true of people, it does not appear to be true of constitutions. Constitutions submit to general rules. One of those rules is that outdated constitutions undermine democratic governance. The influence of the U.S. Constitution is on the decline, but it remains the most influential constitution in the world. Over all 7 continents, many of the world's constitutions are indebted to it, were inspired by it, and borrow language from it. 96% of the world's written constitutions include an amendment provision. Yet around the world, written constitutions lie in various states of stagnation, decay, misuse, and non-use. Legislators abuse them. Autocrats ignore them. As constitutions age, they become more difficult to amend because people tend to venerate old constitutions, that veneration which time bestows on everything, as Madison put it. And also because as populations grow and become more diverse and more polarized, the political obstacles to amendment increase in both number and power. How long can or should a constitution last? Is there a point beyond which a constitution cannot be stretched like a uterus swollen with life, and instead breaks like a fractured bone? Jefferson believed that with regular amendment, a constitution might last until the end of time, if anything human can so long endure. But the world contains more than things human. The 2.5 centuries since the American Revolution are remarkable for the extension of the franchise, in the assertion of human rights, for technological progress, for ever-widening and even profound knowledge of the natural world, for increases in life expectancy and the standard of living, and for economic prosperity and astounding population growth. And yet they are also remarkable for the scale of human violence, the poisoning of the earth, the development and deployment of weapons of mass destruction, the mass extinction of wildlife, catastrophic climate change, and the invention of artificial persons. If, for a large portion of humankind, these 2.5 centuries represented progress, freedom from want, and freedom from fear, every other living thing on the planet saw only decline. The human population of the planet was about 800 million when the U.S. Constitution was written. By the 2020s, it had reached nearly 8 billion. In the last 10,000 years, the Earth has lost about a third of its forest. Almost all that loss has happened over the last 300 years. Since 1880, the seas have risen 9 inches, nearly 4 inches just since 1993, and another 6 to 8 inches between 1993 and 2022. Wildlife habit is disappearing at a rate of thousands of acres a day. Between 1970 and 2020 alone, wildlife populations fell by 2/3. Birds have disappeared, fish are dying, seas are warming, storms are worsening. The very dirt is exhausted and barren, desperately in need of amendment. We, the people. America's 18th century Constitution is an artifact of a chain of being understanding of humans and the natural world. We, the people, rule over all creatures, great and small. No fundamental law restrains what humans can do to the natural world. The loam, the sheep, the geese, the wasps, the oaks. The constitution of parchment and ink is made of them. It presumed their world, but made no allowance for it or for them, set no force in motion to restrain the tyranny of humans over all other creatures, the birds of the sky, the fish of the sea, nor has any amendment provided for them. And yet a world without them is a blank page, a void, darkness upon the face of the deep. What in such a world does amendment any longer mean? Most federal measures currently in place to protect the natural world, clean water, clean air, date to the early 1970s, when Wisconsin Senator Gaylord Nelson proposed a constitutional amendment to read, "Every person has the inalienable right to a decent environment." But by then, when a majority of the world's nations were adding environmental provisions to their constitutions, Article 5 was already breaking down. Out of 196 constitutions in the world, 148 address environmental protection, or environmental rights. Most are mere gestures, they haven't stopped the earth from burning. But without these and stricter, more enforceable constitutional provisions, the prospects for halting or reversing climate change are dim. In the absence of any language in the U.S. Constitution regarding the natural world, laws are repealed, orders unenforced, lower court decisions reversed. Native nations and municipal, state, and even national governments around the world have tried granting rights to rivers and streams, to mountains and valleys, to plants and animals. And while it is not clear that granting rights to nature is feasible or justiciable, it is clear that no change to fundamental law about the relationship between humans and the natural world can happen without a restoration of the philosophy of amendment. Article 5 is a sleeping giant. It sleeps until it wakes, and then it roars. On June 23, 1970, on what must have been the last, or very nearly the last day of school, on one of the very last days that Americans had reason to believe they could still amend their Constitution, 429 students from a high school in Fargo, North Dakota, signed their names to a petition handwritten on notebook paper in blue ink. "We, the undersigned, are suffering," the kids from Fargo wrote, calling on Congress to pass Nelson's Environmental Rights Amendment. "Our environment is degraded, our society endangered, our culture in danger of wilting with last week's news." They place their faith in constitutional amendment, in the hope that the world will choose not to condemn itself to desolation, disease, and death. They had not consented to a constitution that was written in 1787 and that had nothing to say about the natural world. And they wanted to mend it. "We are young, but we ask and we demand the right to an environment in which we can grow old." They signed their names with the dreamy, loopy handwriting they used to sign their high school yearbooks. Stacy and Bruce, Kathy and Jerry, Darlene and Kevin, and Jeff and Ruth. And then they sent copies of that petition to Birch Bayh at the Senate Judiciary Committee's Subcommittee on Constitutional Amendments, and to senators from Minnesota, North Dakota, and Illinois, and to President Richard Nixon. Bayh's staff wrote back to anyone who inquired about the environmental amendment that he was looking into possible hearings on this subject. He never held those hearings. No one ever held them. No constitution can be kept forever, like a butterfly under glass, tacked down with pins, in danger of wilting. To constitute is to become or establish. To amend is to mend, correct, repair, and improve. Americans might learn again to amend, or else they could invent a new instrument to guarantee liberty, promote equality, nurture families, knit communities, thwart tyranny, and avert the destruction of a habitable earth. Constitutions began with stones and seashells, with old books and oak trees, with sheepskin and goose feathers. From the burning, scorched earth, new ideas might arise once more. Seedlings sprouting, tendrils wending to the sun.
The end.